and exhibits E, 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 E.
Okay. All right, go ahead, Mr. Jackson.
Thank you, Your Honor. We are asking the court to reconsider the court's ruling yesterday concerning Dr. La Posada and her ability to opine on the issue of dog bites, dog bite and claw mark wounds and pattern recognition. We had some concerns yesterday and previous to yesterday about an issue that has been ongoing with the Commonwealth, and we've brought this to the court's attention. The Commonwealth has been using a tactic to shift the burden to the defense with cross-examination that's laced with indications or implications about witnesses that may or may not be called by the defense. That is a problem. I brought it to the court's attention at sidebar. The court will probably remember that colloquy. It was not an open court, but I expressed grave concerns, to use that phrase, that there was a burden-shifting system that was going on when Mr. Brennan is asking our witnesses about, or his witnesses, about other witnesses that may be on the defense witness list and may be called. Obviously, as the court knows, foundationally, we don't have to call anybody. We don't intend to call anybody. We don't have to call anybody, but we can call whoever we feel like. But we shouldn't be put in a position where our hand is forced to call witnesses because of questioning by the Commonwealth, which is improper. After I brought it to the court's attention, Mr. Brennan has continued along that same line. The Commonwealth has continued along that same line, and I want to bring something to the court's attention specifically. Last night, we pulled the tape. Dr. Russell was cross-examined by Mr. Brennan on the issue, specifically, of Dr. La Posada and her opinions regarding dog bites. He asked questions over and over and over again. The colloquy probably lasted more than 5, 6, 7 minutes with Dr. Russell, specifically on the issue of whether or not she had seen Dr. La Posada's reports, whether she was aware of Dr. La Posada's opinions, implying that Dr. La Posada had opinions about the dog bites. She was asked if she was familiar with Dr. La Posada's credentials. Dr. Russell said, yes, she was familiar with Dr. La Posada by name, that she thought she had impeccable credentials, and she very much wished she could have seen her reports as it relates to dog bites. It was an intellectual curiosity by Dr. Russell that was evoked and elicited by Mr. Brennan on cross-examination of Dr. Russell. She was then asked the seminal question: did the defense, Dr. Russell, give you any reports by Dr. La Posada related to dog bites?
What page is that on here?
On the transcript?
Yes.
Oh, my motion's back at the desk.
Oh, I see it.
Does the court have it?
Yes.
Okay. I'll just read it. Question by Mr. Brennan to Dr. Russell. And so you think of all those forensic pathologists, medical examiners, you think that qualification and experience itself is not enough to qualify someone to give an opinion on a photograph about the genesis of a wound related to dog bites? Answer: well, if a forensic pathologist autopsied 1 or 2 cases of dog bite wounds versus my experience with over 500 to 1,000 cases of dog bite wounds, I'm not sure that person would be a very good expert in that kind of case. Question by Mr. Brennan: have you ever heard of a doctor named La Posada?
So are you going to read all 3 pages?
No.
So I've read it, Mr. Jackson.
I'd like to read it into the record, Your Honor.
It's in the record. I will put this transcript into the record. I'm not going to let you read 3 pages here.
It's not 3 pages, Your Honor. It's about another 5 lines.
The
It just
part
goes to
that
the
you
top of the
brought
next
to
page.
my attention is on page 15, not where you're reading.
The colloquy between between Dr. Russell and Mr. Brennan was specific to dog bite wounds. It was specific to Dr. Russell's understanding of whether or not Dr. La Posada had been retained by the defense, whether she was a defense expert, whether she had written a report, and whether she opined about dog bites and dog bite wounds. And after she was asked if she had been provided any reports by the defense attorneys specifically, from Dr. LaPosada related to dog bite wounds, Dr. Russell said, no, I haven't been. And to summarize her statements, which the court has in front of it, Dr. Russell went on and said, I really wanted to see what Dr. LaPosada had to say about these dog bite wounds. I really wanted to read her report, but no, I was never provided her report or reports by the defense. And of course, Your Honor, as the court knows, that is standard operating procedure. I don't trade reports between and among experts because obviously I want independent analysis. I don't want to cross-contaminate any opinions, et cetera, and be accused of doing so. So of course we didn't provide a report from Dr. LaPosada to Dr. Russell. But Dr. Russell's intellectual curiosity was then extracted from the witness stand, and the jurors heard all of that. So then days later, not weeks, not months, 3 days later, after eliciting testimony from Dr. Russell about Dr. LaPosada having a report, being hired by the defense on the issue of dog bites and not providing that report to Dr. Russell, the Commonwealth then moves to exclude the very testimony that he was eliciting from Dr. Russell, leaving the jurors with a very, very deep and irremediable misimpression. They used it tactically as a sword and a shield, and that's burden shifting. That leaves the jury with the impression that Dr. LaPosada was consulted by the defense, number one, that she wrote a report, number two, that the report was about dog bites, number three, that she didn't provide that report to other experts, number four, and the reason she didn't, obviously, is because her opinion, Dr. LaPosada's opinion, would be harmful to the defense. That's the only reasonable interpretation of those facts. And the Commonwealth has taken advantage of that. The Commonwealth's questioning of Dr. Russell about Dr. LaPosada and her report and her opinions about dog bite wounds specifically was deliberate, and it left the jury with an open question. We know they consulted her. We know it was about dog bites. This is how the jurors are thinking about it now. We know they consulted her. We know it was about dog bites. They hid the report from Dr. Russell because they didn't want her to know about it. Ergo, must be harmful to the defense. Now we've got Dr. LaPosada on the stand. Her credentials are peerless, absolutely peerless. They've got possibly the most qualified medical examiner in the country, certainly on the Eastern Seaboard, right in front of them, about 6 feet away, and the defense is not going to ask a single question about her opinions concerning dog bites when she reviewed the entire autopsy. How is the jury going to conceive that? How is that going to land with them? The answer is they're going to think, they have no choice but to think, the only reasonable explanation is, if Dr. LaPosada's opinion helped the defense, they would ask her. If they don't ask her, it's because whatever Dr. LaPosada says about that right arm and those wounds, it's got to be harmful to the defense. They would absolutely ask the question. So the Commonwealth got to have it both ways. They got to ask Dr. Russell about Dr. LaPosada and imply that Dr. LaPosada had opinions about dog bite wounds. And then they have it the other way, which is, let's ask the court if she will exclude Dr. LaPosada from testifying about the very issue that they brought up in front of Dr. Russell. That cannot stand. That ensures, it reasonably ensures that the jury will misrepresent or misunderstand the import of why we're not asking Dr. LaPosada about her expert opinion, especially as it specifically pertains to dog bite wounds. I want to talk for just a second, and that has, by the way, that has constitutional implications. Ms. Reed is entitled to a fair trial, not a fair trial that the Commonwealth designs, not a fair trial that the Commonwealth curates, but a fair trial. Regarding Dr. LaPosada's credentials, we went back through, specific to the court's questions yesterday, her resume. There are no fewer than 13 classes, 13, that she has taught, specific to wound pattern recognition that have included dog bite recognition. On page 7, she was the course director for medical legal death investigation. That was in 2013. She taught about dog bite recognition in that case, or in that course. She was a thesis advisor for Master of Science Graduate Medical School, Boston University School of Medicine, taught about dog bites. Staying with page 7, forensic pathology course director in pathology, course 205, taught about dog bites. Member of Quality Assurance Committee, Training Division of Trauma and Surgical Critical Care, teaching on the issue of wound recognition, animal bites, and specific to dog bites. Pediatric Forensic Pathology, Texas Homicide Symposium. She was a presenter in 1989. She taught about the issue of dog bites as it relates to pediatrics, children, dog bites in children. Forensic aspects of physical child abuse as related to being left with dogs that can injure a child. Dog bites, dog bite recognition.
Oh my
These
God.
are all classes taught by Dr. LaPosada on the issue of dog bites to other medical professionals. The one that stands out, however, and I'm not going to go through the other 9 or 10 or 11, the one that stands out is 2015 and 2016, 2 courses. The name of the course, Emergency Room Forensics, Evidence and Patterned Injuries, New England chapter of the International Association of Forensic Nurses, taught in Norwood, Massachusetts, both times, specific to dog bites and the issue of dog bites as seen by emergency room physicians, how they should handle them, what they should do with them, how they should view them, what to look for in terms of pattern recognition. She's eminently qualified. I will leave the court with one thought. The court indicated when qualifying Dr. Russell, one of the preeminent things that the court mentioned in qualifying Dr. Russell is that Dr. Russell utilized a methodology that the court sanctioned and quoted and said the methodology that she used of wound pattern recognition, dealing with differential diagnosis, utilizing and interpreting dog bites by the method of exactly what Dr. Russell did. Differential diagnosis is something that the court said was exactly why the court sanctioned Dr. Russell and blessed Dr. Russell as a qualified expert, and that's exactly what Dr. LaPosada testified yesterday she utilized and utilizes in coming to her opinions and conclusions. Going back to the open door issue, obviously she's eminently qualified, but Your Honor, this cannot stand. The Commonwealth cannot have it both ways. They cannot walk up and say, and leave the impression with the jurors that Dr. LaPosada opined about the dog wounds, but we're not able to hear it. We, the jurors, are not able to hear it because obviously that is something that is her opinion, whatever it might be, is harmful to the defense. When in truth and in fact, it's exactly the opposite. Dr. LaPosada's opinion has never wavered. Those injuries on John O'Keefe's arm are from a dog, period, full stop. Anything less than presenting that to the jury at this point would be to perpetrate an intentional fraud on this jury. Ms. Reed is entitled to more. She's entitled to better. She's entitled to the evidence.
All right, thank you. Mr. Brennan?
The pattern of conduct that stands out is persistent, repetitive, contrary to court rulings and court orders, and deliberate. And that is, the defense uses their witnesses to vouch for their own credibility. They use their witnesses to introduce information they know is not admissible, and they use their witnesses to introduce otherwise inadmissible hearsay. Dr. Russell took the stand, and she was led into answers where she was vouching for her own credibility. Dr. Russell promoted herself not only as an expert, but through the defense's questions as virtually the only expert in America who has the expertise to give this type of opinion. It is the defendant's tactics that open these doors that they then want closed. The defense had Dr. Russell all but assure the jury that she uniquely was in the position to give any type of opinion regarding dog bites. Inevitably, when I asked Dr. Russell, and I began asking her about her credentials, whether she thought that she was exclusive, and I mentioned Dr. La Posada, she denied ever reading anything about Dr. La Posada. I did not specify whether she read an opinion about a dog bite. I asked if she had heard about Dr. La Posada. She denied it, and then she told us that she knew about Dr. Sheridan. Unsolicited, then added that Dr. Sheridan, involved in a previous proceeding, believed that the bites were consistent with dog bites. I don't know how she became aware of Dr. Sheridan's testimony, and since the defense doesn't speak to her about these things, she must have watched it on her own. But inevitably, she introduced inadmissible hearsay and inadmissible opinions. And so the sum zero here is that Dr. Russell has denied that she saw anything relative to Dr. La Posada, ensured that she was exclusively qualified, and introduced an improper opinion of Dr. Sheridan. Dr. La Posada was voir dired briefly. She did not provide qualifications that she has a history of education or training on pattern wound recognition analysis as it pertains to dog bites. We asked her questions about her specific experience. She did not provide a basis, and so her opinions regarding dog bites should not be permitted in this trial.
Just to clear up the record, two things stand out about that speech. Mr. Brennan literally just said, I didn't elicit any information about dog bites. I just asked about her experience. Question by Mr. Brennan.
That's not what I said. That is not
Excuse
what I-
me.
that- No, I'm not going to.
So
That's not what I said.
I heard what Mr. Brennan said. You don't need to tell me what Mr. Brennan said, but go ahead to
How
your
about if I quote
argument.
his words? How about that? Question. And so you think of all those forensic pathologists, medical examiners, and you think qualification and experience itself is not enough to qualify somebody to give an opinion on a photograph about the genesis of a wound related to dog bites. The question was specific to dog bites. That's how he introduced the subject matter to Dr. Russell. Then his next question was, have you ever heard of a doctor named Dr. La Posada? Those were his words. Then he goes on, I think he also just said that he did not elicit information about other individuals, including Dr. Sheridan or anybody else. Question by Mr. Brennan. Were you ever told what other people's opinions might be regarding those photographs? That's the question that she was answering when she said, quote, I'm aware that there was a Dr. Sheridan involved in a previous proceeding, and he believed that those were consistent with dog bites. That was in relation or in response to Mr. Brennan's specific question. She didn't just elicit that. She didn't volunteer it. She said it because he asked her. And that was all by design. The entire thing has been by design. He elicited the information suggesting that Dr. La Posada was being hidden from Dr. Russell because her opinion would harm the defense. He left that with her on purpose, then turned around and 3 days later said, and by the way, the defense should be disallowed from using Dr. La Posada to talk about the very dog bite wounds that I asked Dr. Russell about. That cannot stand as a scorecard.
Go ahead.
It's helpful if you read the entire thing in context, which I won't do. We always have a right to object to an inadmissible opinion. So the suggestion that somehow an ambush here is not only misplaced, it's strategic by the defense to try to create an narrative. It's improper.
All right. I'll be out in 10 minutes on this, and we'll get started right away with Dr. La Posada.
All right, the court, please.
I just want to say super quick. The problem with experts in this case is that there really probably is no other case where any medical expert or expert has had to identify shallow abrasions on a corpse. Normally, if you're looking at wounds on a corpse and you're trying to determine if it was from, you're not trying to determine if it was from a dog, it's because that person died from a dog attack. So Hank is right that there really are no experts here. And what he's saying is these people have anointed themselves as experts. So I just wanted to say that. So Kate, if you want to jump in on more, add to
No,
that.
I agree, and I think that that's what the whole quandary with this stupid dog bite thing is that it's. And I'm not trying to disrespect anyone, but it's kind of pseudoscience, right? You know, and they're determining this like pattern recognition does not apply with something like dog bites, simply because if you look at a wound, it can look like, oh, I have fallen and scraped my arm and it's looked like that before. It doesn't. You need more information, and the more information here is that there's no dog DNA. So that really, and the more information here is that he didn't move from the spot where he was found, which is admittedly, out of her own mouth, the last place that Karen Reed left him. There's a lot more information here that just does not support dog bites, and it's silly. You don't ever have to guess if someone was mauled by a dog or not, because they tell you, or somebody who witnessed it tells you, or the dogs are still there. It's just silly.
Right.
So.
Oh, just one more thing to add that too. So what Alan Jackson is saying here is the judge has already approved the methodology of Dr. Russell. But if you go back, and somebody had just sent me this last week and I read it out on the air, the decision, so there was a voir dire for this second trial on Dr. Russell, that there was a 2-part voir dire. It took place in December and the second part was in January. And then the judge ruled on it because the state was trying to get her testimony thrown out. And she ruled to accept it, but with the greatest reluctance. She made clear in her ruling that there was a lot of problems with Dr. Russell's methodology and her conclusions, but that she was going to rule on the side of caution to let a murder defendant have this option, and that the defense was going to be welcome to go. They were better off challenging this during the trial on cross-examination. So this idea that the judge approved Dr. Russell, it was only in the thinnest of margins that and the greatest of benefit of doubt for the defendant that she allowed that to go on. And I also want to just welcome Boomer and Matt from Boundless Millennial. Boundless, I don't know if you're here actually listening to us, but if the reports are true that I got yesterday, my deepest condolences to you. I hope those reports aren't true, but if they are, all of our condolences to you. I don't know if you're here, Matt. He might be just connecting us to his channel. He might not actually be here. Anyways, welcome Boomer.
Hello, Kevin.
And what's the name of your new channel again, Boomer, so we can send people over to hit the subscriber, even though you have nothing on it yet?
I got a little trailer thing up there, but
good.
It's Boomer Live. I think if you use the @ symbol, it's @Boomer Live with the number 7 on the end of it.
Okay, throw it in the private chat again, and we'll link to it a couple times on the screen. But by popular demand, Boomer has been getting a lot of requests to start his own channel, which he is now in the process of doing. So we've got a couple of thousand people at least here watching on the various channels. And so do him a favor if you appreciate the work he's done. And based on the comments I'm getting from people, there's an enormous appreciation of his work on during this trial. Head over and just click subscribe. Just do him a solid. Get him going. Get him off to a good start.
Yeah. It takes 10 seconds.
Margaret, do you have any comments on what just went on in court?
Yeah, Jackson is clearly setting it up for an appeal on constitutional grounds, and that would be the Sixth Amendment, the right for criminal defendants to present witnesses in their defense.
Right.
So that's what it's all about. And you know what? Listening to him, he did make some points in that argument. So I think Judge Cannoni is going to be thinking about this possibility of the appeal, and they don't like to be overturned. So that's why she's taking 10 minutes to really consider it. Maybe she may change her mind. I don't know. But I completely do agree with you that this whole dog bite analysis is something where there's really not a methodology established. But that Sixth Amendment is looming large in this case.
I think that so it comes down to her qualifications, right? They voir dire. She can't come up with any specific dog bite qualifications, making the argument that she taught a class on child abuse. Come on.
So I'm not going to allow Dr. Laposada to testify regarding dog bites. Your rights are saved. I'm going to give an instruction regarding burden shifting. So
he was definitely setting it up for appeal.
I
Yes.
don't think that a pure instruction can do anything except bring the point home again.
Okay.
But if the court is not willing to allow her to testify to her full opinion to a reasonable degree of scientific certainty, can she at least testify that she reviewed the arm, looked at the arm, and it's consistent with an animal? And we at least split the baby.
I will do that. I'll allow that.
Ooh.
Yes.
Wow.
Over the Commonwealth's objection.
And I look to have the allow consistent opinion with a dog.
No, Mr. Jackson said animal.
I'll leave it at animal if that's what I can get. I'll take what I can get.
In her experience, Mr. Jackson, you have to lay a foundation. In her experience, seeing animal bites, this is consistent with what she has seen in an animal bite.
And that will include, I'll come to sidebar before I display anything, that will include a representation of what an animal jaw looks like.
No. No, it will not.
Why is that?
That's my ruling, Mr. Jackson.
So no visuals.
No visuals, just that one sentence that's consistent with what she has seen is an animal bite. A brief foundation, because I'm letting that statement in as long as she has said, as long as she testifies that she has seen animal bites over the years. That's it, Mr. Brennan. That's what I'm doing. So you don't want an instruction, Mr. Jackson? Okay. All right. So there are two other quick matters, but the jury's been here, and I don't think we'll get past the break without this anyway. I may have left it in I left it in my office anyway. So let's just bring the jurors in and move forward with this.
So this has been a problem that I've identified since the last trial with this judge. She's like a parent. She is always going to give a split decision, always. And that's something the defense has done a good job taking advantage of. She's never going to rule 100% on one side. Her inclination is to always somehow, if you're giving your kids a snack, you divide it up. She's always going to divide it up. That's just her nature. That's her instincts.
Well, she's protecting the rights of the defendant, though. And she's got to be very careful of that.
Yeah.
So I understand what you're saying, but from a legal perspective, I think if I were a judge, I'd probably do the same thing.
I mean, this applied even to when it came to Turtle Boy in court. She's always going to split this. She's always going to have a split decision.
Like there's some things I completely disagree with, especially Turtle Boy in court. That decision did not make sense to me.
Right.
But this one, at least she gave Jackson this little tidbit. And again, It protects her on appeal. It protects the judge in a way. And it gives if it goes up to the appeals court, the SJC, it's like, well, the judge did allow this. So, we'll let it go. We'll let it slide.
This is a pretty big win, though, for the defense.
Yeah.
They now get to say this, and so now a jury's going to hear.
I think the animal thing takes the sting out of it. You know what I mean?
Yeah.
Because, maybe he got gnawed by something while he was laying there for 6 hours. The thing is, they can't play. They want dog. They want dog because they want to tie it to Chloe to put him in the house. That's literally the only purpose of the dog bites, much like the climbing stairs, which was obliterated. It's just an attempt to place him in the house.
Mm-hmm.
Right.
They can't.
Well, now this Lapasoda is going to get what she deserves. Hank is going to have to be harsher on the cross now because we don't know why she's come forward, but it's suspicious. And just like Dr. Russell was suspicious. And it may be a hard thing for a jury to see somebody like that who's in her 70s and who's struggling to breathe, obviously has some health conditions up there. But now the cross-examination really has to go after her motive. And as far as I don't know, do you agree with that, Margaret?
What's the question again, Kevin?
So I think now that this puts more pressure on Hank to go after her motive for coming forward. Did she come forward on her own in this trial? Did she reach out to Alan Jackson, or did Alan Jackson reach out to her and say, we want an independent analysis of this? I think really, he's got to kind of do more of that now.
He will. Yes, he will have to do a bit more. And Hank, he will. Yeah. Yeah.
Which is tougher. Puts him in a tough spot to go after someone who's frail. She's obviously frail. Has some.
Oh my God.
conditions.
Yeah. There's something wrong with her. Yeah. Yeah. So again, he has to be careful.
Yeah.
With that, but I think it's okay. I think I think that no dog DNA is big. So
right.
I've said that all along. But if John O'Keefe was gnawed by an animal like a raccoon, then there would be raccoon DNA.
Right. Good point. Boomer's busy making us all breakfast, so we're all
I'm hungry.
We're all in some little yellow cottage out in the woods somewhere, and Boomer's cooking us breakfast. You can almost smell.
I can smell the Canadian bacon.
That's just ham, and you all know it.
The Canadian bacon, exactly. It's just ham.
Yeah, it's just ham. Secrets out.
Oh, I love Canadian bacon though, whatever the hell it
Oh.
is in a eggs Benedict.
Right.
Oh, that's my favorite.
Yeah. So, very interesting. Any other thoughts out there on all of this?
Yeah, I mean, I do think it is helpful that Alan Jackson managed to get that win there. Like for all the reasons you and Kate just said, I'm not saying it's a decisive win, but it is something that does help them because now instead of Dr.
You are
Russell being an
unmuted.
isolated expert, there's two that'll say something similar. But-
Yeah.
Yeah.
All right, let's get out of the way.
Prize for the jury. Hey. All persons have any business before the Honorable Beverly Kennedy, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Good morning, jurors. Thank you for your patience this morning. I know we brought you in late. Maybe should have brought you in a little bit later, but we've been working in an effort to sort of streamline things for you. So I do have those questions I have to ask you. Was everyone able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or should be. All right, can we have Dr. Laposada back, please?
Yeah.
Doctor, I'll remind you, you're still under oath. Thank you.
Thank you. I will.
Good morning, Dr.
Morning, Your Honor.
All right, Mr. Jackson, go right ahead.
Thank you, Your Honor. Good morning, Dr. Laposada. Nice to see you again.
Good morning. Glad to be here.
Yesterday, when we last left off, we were talking about a small injury to the upper eyelid of Mr. O'Keefe. Do you recall that?
I do.
Could we have Exhibit 165 with the court's permission, please?
Okay.
I'd like you to take a look at a specific area. If I could. There we go. Right here on this exhibit. You see that area?
Yes, I do.
Tell us what that is.
And that is a horizontal splitting of the skin, which was caused by application of force that overcame the tissue's resistance, so the tissue split. And behind that, we see the raccoon-eyed discoloration of the eyelid from the basilar skull fractures.
Could we have Exhibit 13, please? I want to draw your attention to this area of the vehicle. First of all, do you recognize this photograph?
Yes, I do.
How do you recognize that photograph?
I recognize it from looking at it in my materials reviewed, that it's the rear of Miss Reed's SUV.
Taking a look at the area that I'm highlighting, right about there.
Yes.
Could we zoom in on that area? Do you see that overhang over the window?
Yes, I do.
If I use the word spoiler, would you understand what I'm talking about? If we call that a
Yes,
spoiler?
yes, I do.
Okay. Is the laceration to Mr. O'Keefe's upper eyelid that we just looked at, is that consistent in your opinion with a strike from that area of the vehicle if that vehicle were traveling in reverse at, say, 20 plus miles per hour?
No, that rounded, thick area would not cause that skin defect in his upper eyelid.
If, in fact, a person were hit at, say, 20 plus miles an hour in the face with that rounded edge, what kind of what kind of injury would you expect to see on that person's face?
I would expect to see a ribbon of bruise that would correspond to the height of that spoiler, and then it would go across the eyeball, it would hit the nose. So I would expect to see some horizontal ribbon of bruise.
Did you see anything consistent with that, with Mr. O'Keefe's injuries?
No, nothing.
Thank you. We can take that down. We talked yesterday about this phenomenon known as coup contra coup injury to the brain, correct?
Yes.
What happens to the brain after a coup contra coup, a significant coup contra coup injury?
Yes, this was quite a severe brain injury. Was injured on the back of the brain and also the front of the brain. The falling back and impacting the back of the head made the skull fracture radiate along the base of the brain on the right and left sides. It also radiated around on the side of the skull, and that indicates a tremendous transfer of force and energy to the skull and then to the brain, and the brain is rattled around, therefore, within the cerebral spinal fluid in the skull. So what that does is that it breaks the connections between the neurons in the brain and causes small little hemorrhages, and it causes the brain to swell. So when you get an injury, like if you get an injury on your arm, it starts to swell. The same thing happens when that injury energy is applied to the brain. The brain starts to swell. And unfortunately, the brain, when it swells, it doesn't have anywhere to go because it's encased in the skull. So what happens is that the brain stem under the brain starts to go down the opening in the base of the skull where your spinal cord goes. And that is a harbinger of death, because that means that the brain stem is getting pushed down in this hole in the skull and compressing the areas in the brain stem which control the heartbeat and breathing. And that's called brainstem herniation, and that you just die after that. So that's what happened to Mr. O'Keefe's brain.
I have a document that I'd like to approach with.
Okay.
Yes.
Doctor, can you take a look at that document that I've just handed you and tell me if you recognize it?
Yes, I recognize this.
How do you recognize that document?
From looking at the autopsy photos of Mr. O'Keefe's brain.
And what portion of the brain are you looking at?
This shows a photograph looking up under the brain, and it shows a cross section of the brainstem that went down in the hole in the base of the skull, and we see there's hemorrhage in it, and those have a special name. They're called Doherty hemorrhages.
How do you spell that?
D-U-R-E-T with there's a little accent somewhere there.
Caret over the E?
Yes.
Okay.
And this shows that the brainstem is going down into the hole where the spinal cord goes. It's stretching the blood vessels and causes little hemorrhage and compresses the neurons in the brainstem, which control your heart rate and your respiration. It's called brainstem herniation, and that's a harbinger of immediate death.
Your Honor, with that, I would ask for the admission of the next, that document is next in order, subject to the appropriate redactions.
Okay, so we'll take that into evidence. Yes.
Your Honor, with the court's permission, with the redaction, may I present the...
Not yet. 1 minute. Jurors, I told you before that there were photographs that have been introduced into evidence that aren't pleasant. And you may find that these photographs are graphic. And I'm instructing you again that your verdict must not in any way be influenced by the fact that these photographs, you'll see some more today, I believe, that have already been introduced into evidence. So you're not to, your verdict must not in any way be influenced by the fact that these photographs may be unpleasant or graphic. The defendant's entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the deceased, which might be occasioned by the photographs. Importantly, consider the photographs only as they may draw your attention to a clinical medical status or to the nature of Mr. O'Keefe's injuries themselves. So again, these will be presented to you in the deliberation room in an envelope. But today you'll see some on the screen, and I just wanted you to know that before you see it. So now you can display it.
Your Honor, may I approach very briefly?
Yes.
If you wouldn't mind taking a look at that document.
Oh,
Is that
yes.
a redacted version or a close-up version of just the brainstem?
Yes, this photograph shows the cross-section going this way of the brainstem with the hemorrhages caused by the brainstem going down into the foramen magnum.
With that, Your Honor, actually, I think with the court's permission, I would trade that as the next in order rather than the unredacted version.
All right, is there any objection to the switching the exhibits like that?
No.
Okay.
Thank you.
Oh, and the arrows point to that on there.
So this is going to be the next exhibit?
That'll be it.
Exhibit 225, Mark.
Thank you.
This is for ID.
The other one will be for identification, the first one.
Thank you, Your Honor.
And that'll be FFF for ID. Number F.
Okay, you can display it now.
Thank you, Your Honor. Mr. Walt? Do you see what's displayed on the screen above your head?
Yes.
What is that?
Excuse me, that's a cross-section across the brainstem of Mr. O'Keefe, and it shows where the blue arrows I've put in there show the red areas, which are areas of bleeding, which is the sign of brainstem herniation. All the background is white material, and that's part of the appearance of neurons in the brain. So that shows that the brainstem, because of the brain swelling, pushed it down into the hole in the base of the skull where the spinal cord goes, and it pulls on the blood vessels, causing the blood vessels to break and the blood vessels to bleed, and that shows you that the brainstem has been compressed and damaged, causing death.
May I approach?
Yes.
I'm holding a green laser pointer.
Oh, thank
You
you.
can use the display to your right so the viewers can better see it, could you point to the areas with that laser pointer of the bleeding that you indicated causes the swelling?
Okay, so, okay. Is that going on the?
It is. It's
Okay,
probably
thank
hard
you.
for you to see.
Oh, that's okay. So this sort of roundish thing is the brain stem, and the arrows are pointing to the red areas. So there's a blood vessel that's broken there because it's been torn and pulled, with surrounding blood going into the neuronal tissue here and over here and over here. And also some of this is also bleeding, with the blood looking brown because the brain was placed in formaldehyde. So all this brown area, the red area, should not be there.
Is this type of herniation life-threatening?
It causes death. Yes, it is life-threatening.
How quickly, we can take that down. How quickly, doctor, would you expect that this could cause, let's first talk about incapacitation.
Yes.
How quickly would someone be incapacitated after they suffer a coup contra coup injury of this magnitude with the concomitant injuries that you see in the brainstem?
Well, there would be two parts to what that injury would cause the body to do. First, there would be immediate unconsciousness because of the transfer of all the energy to the brain and the massive skull fractures. So that, excuse me, so that would disrupt the normal function of the brain and produce immediate unconsciousness. Then the brain would start to swell, and within 15, 20 minutes or so, then that brainstem starts to go down the opening in the bottom of the skull, and then the blood vessels are broken, the brainstem gets compressed, and the centers in that brainstem which control the heart and the respiration then stop. So you go unconscious, brain swells, then you die.
Turning to the actual, your review of the actual brain, in this instance, Mr. O'Keefe's injuries specifically, did you reach any conclusion or opinion to a reasonable degree of medical certainty about his incapacitation, the length of time it would take for him to become first incapacitated and ultimately to be rendered dead?
He would be immediately incapacitated with a decreased level of consciousness. Once he received that impact on the back of the head, he would not be able to make any purposeful movements. There might be some arm jerking or some seizure activity, but he would not be able to carry. He wouldn't be able to get up. He wouldn't be able to walk. He wouldn't be able to do any purposeful activity. He would be severely concussed, unconscious, not able to walk, not able to carry out purposeful activity. And then as the brain continues swelling and that brain stem gets compressed, then the heartbeat is disrupted, the breathing is disrupted, and then those heart and breathing stop. And within 15 or 20 minutes, then he could be dead.
Is that opinion to a reasonable degree of medical certainty?
Yes, it is.
You testified concerning wound pattern recognition pretty extensively during the course of your giving your qualifications. What is a patterned injury?
A patterned injury is very basic to the training in forensic pathology and medicine because it helps us understand some change on the body, some pattern injury that corresponds to the object that made it. So we can look at an injury and say, we can figure out what made that. Sometimes you can, sometimes you can't. But a pattern injury is very important for a forensic pathologist to recognize because it's going to really help the police investigation. Because I can say, oh, this looks like it's a wound from scissors. This looks like it's a wound from a screwdriver stab. So by identifying the pattern that object makes on the body, I can help the death investigation by helping the police say, look for some screwdriver, look for some hammer. So looking at that, identifying a pattern injury is really important to it's basic to the forensic pathologist's knowledge base, and then also very important to the investigation of the crime or incident.
I'd like you to look at another photograph, an exhibit that's already been put into evidence. 160, please, with the court's permission.
Yes, jurors, this may be one of the photographs as well. Right. Or there'll be a series.
Dr. LaPosada, I want to draw your attention to the center of this photograph.
Yes.
First of all, do you recognize what's depicted here?
Yes, I do.
How do you recognize?
I recognize it from reviewing the autopsy photographs of Mr. O'Keefe.
You reviewed it, informing your opinions and conclusions?
Yes.
Can you describe what's depicted in this photograph? What are we looking at?
Yes. So we're looking at the back of Mr. O'Keefe's head and an injury caused by the angular acceleration going down and hitting his head in the back. And then this is also a patterned injury. So what we see is the horizontal tear of the scalp, and we can see it's undermined a little bit. So that means the direction is going from bottom to top. Also, we see these sort of vertical lines in here and down below. So what that tells me is that the back of his head hit something that had a fine granular pattern to it to cause those individual little marks, and then also something that had a linear or ridged pattern that he went back on that broke the scalp there. So we have two parts really to this pattern injury. We have the horizontal tear of the scalp made by impact with some sort of ridged surface. And then we have these vertical scraping of the skin above and also below. They're obscured a little bit by the ruler there, which says that whatever he hit had some little like granularity to it, with each little sort of granule making those vertical marks, and then the ridged pattern having the major point of impact.
What is the significance of the pattern when you say ridged pattern? And there's two things we're looking at: the laceration or the abrasion versus the defect above and below that laceration.
Yeah. So what this injury tells me, and what I would tell the investigators, is that Mr. O'Keefe went back onto some object that had some sort of ridge to it to make that horizontal tear in the skin, but that ridge also it wasn't smooth. It had some little grainy grainy things sticking up on it that would make each of then these little things. And then it's the job of the police then to go back to the scene and look around for something which might fit that pattern.
We can take that down. Did you, in furtherance of your investigation, coming to your opinions and conclusions, look at the area of 34 Fairview?
The outside, yes.
Meaning photographs?
Yes.
Did you also see photographs of any significance to you related to the garage, the interior of the garage?
Sustained. Jurors, disregard that comment, that question.
What part of the area did you see? What part of the location did you see?
Excuse me. I saw all the scene photographs taken by the police, which showed the front yard in the area where Mr. O'Keefe was found. I also saw some photographs of the inside of the house and the inside of...
So I'm going to stop you there, Dr. LaPosada. Jurors, I'm striking anything afterward. The pictures from outside, Mr. Jackson. Move on.
Let's stay with the outside of the home. Did
Yes.
you see the front lawn area?
Yes, I did.
How did you, what did you note about the front lawn area?
Well, I was looking at the area where Mr. O'Keefe's body was found, because we know once he came back and slammed his head, he's not going to get up and move around.
So, yes, I'm going to strike the second part of that. Just answer the question specifically.
Okay, I'll try, Your Honor. Thank you.
Why were you interested in the outside area where his body was found?
Because then I could identify an object possibly there that would have caused the injury on the back of his head.
Did you see any such object in any of the photos that you reviewed?
No, there was nothing there. It was a flat grass surface.
Would the flat grass, let's assume that the grass was very cold and very hard, the dirt was very cold and very hard. Would falling backward onto that dirt, hard or not, would that cause the patterned injury that you see, that we just saw in Exhibit 160?
No,
Why do you say that?
because if you fall back on a flat surface, you get many times the tear you get in the scalp can be more like a star because you've just hit one part and then the tears go in kind of a star pattern. And also because you would not have those discrete vertical scraping of the skin. You would tend to, if you fell back on grass, you would tend to see, you might see grass in the wound, or you would tend to see an irregular kind of crisscross pattern of the flattened grass. And that's not what we have here on Mr. O'Keefe.
Do you have any training or experience in diagnosing hypothermia in individuals?
Oh, yes.
Have you conducted autopsies of individuals who've suffered from or died from hypothermia?
Yes, many.
How many?
100 or more, and then I've supervised my assistants who've also diagnosed the same death from decrease in body temperature.
Have you ever engaged in any death investigation, aside from the actual autopsies, death investigations in which the cause of death was deemed to be hypothermia?
Yes,
How many times would you say you've undertaken that type of investigation?
at least 100.
Have you ever reviewed any peer-reviewed medical literature associated with or discussing hypothermia and something known as Wisniewski spots?
Yes, that's in the medical literature and also in our forensic textbooks.
Did you review the medical examiner's file, Dr. Scortibello's file, as it related to, in connection with this case, you reviewed the entire file, correct?
I did.
Did you conduct a differential diagnosis as it relates to the potential for hypothermia?
Yes, I did.
Describe, before we get into your findings or your conclusions and opinions, what is inferential thinking?
Inferential thinking is another name for making a differential diagnosis. In other words, seeing a finding and then saying, how many ways can I get that finding? And then go and investigate each one of those ways and either rule them in or rule them out as being responsible to causing that finding.
Did you note whether or not the medical examiner, Dr. Scortibello, mentioned hypothermia as a potential cause of death in this case?
She did put that on the death certificate,
Along with something else?
along with the blunt force head injury.
Do you agree with or concur with the blunt force head injury
Yes,
as a cause
Miss-
of death?
Yes, Mr. O'Keefe died from the blunt force head injury.
Do you concur with the diagnosis of hypothermia?
No, the body did not have any hypothermia.
What led you to that conclusion?
Well, when you have we know that normal body temperature is around 98, and we know that then at the hospital that Mr. O'Keefe's rectal temperature was around 80. So we know that his temperature went down. So there are two ways the body temperature can get down. It can get down while you're alive, or a dead body also cools when it's in a cold environment. So those are the two things you have to look at.
I'd like you to take a look. I'm
Show
sorry,
Mr.
Mayor
Millington.
Coach.
Yep, show Mr. Millington.
Thank you, I apologize.
Yes.
Do you recognize what's depicted in that photograph?
Yes, I do.
What is that?
This is a photograph I took from our forensic medical literature, and it shows the lining of the stomach. So the stomach is opened up, and we look at the lining of the stomach, and it shows a characteristic pattern of small ulcerations throughout the stomach which are called medically Wisniewski's ulcers. And that allows a forensic pathologist to diagnose death from being exposed to a cold environment or death due to hypothermia. And they're caused by, as the body gets colder and colder when it's alive, the small blood vessels in the lining of the stomach, they start to break, and then they're in the acidic environment of the stomach, and you get tiny little ulcers, which then look like small dots. And that is how at postmortem examination or autopsy, it's one of the findings I look for to see if a person died from hypothermia.
Doctor, what is gastric mucosa as it relates to the stomach lining?
The gastric mucosa, when you open up the stomach and you look at the inside, the first cells lining that inside is called the mucosa.
Is that what we're looking at in this photograph or no?
Yes, we're looking at the mucosa with ulcerations, which are little craters that form in it due to hypothermia.
Is that exemplar of what Wisniewski spots looks like as it relates to hypothermia from a book that is, or literature that is peer reviewed?
Oh, yes.
Is it widely accepted in the medical field?
Yes, it is.
And is it referenced by forensic pathologists and used in teaching?
Yes.
Your Honor, I would move for the admission of that photograph.
Okay. So 226.
Permission to display, Your Honor?
Yes.
Is this a fair representation of what you were just looking at?
Yes.
Describe what we're looking at.
Okay, so this, I took this photograph from our forensic medical literature, and this was from a person who died due to exposure to a cold environment. And this is the stomach has been opened, and we're looking at the inside of the stomach. And the normal appearance is kind of pinky white. That's how it should look like. And what's abnormal here is all these black dots, which are the Wisniewski's ulcers, which are diagnostic of death due to exposure to the cold. So these areas are little tiny craters, and they fill up with blood. And we see that in over 90% of the cases of people who die from exposure to the cold.
Doctor, did you also look at Mr. O'Keefe's stomach lining?
Yes, I did.
If we could have, with the court's permission, Exhibit 164 put up as well.
Okay.
Do you see the photograph on the right?
Yes.
What is that of?
This is the Mr. O'Keefe's stomach, which has been opened up, and we're looking at the inside. We see that the mucosa is a little bit red, and there's a little bit of increased blood flow here. And this is the normal pattern of the inside of the stomach. It's kind of ridged. That's called rugae. That's the normal folds inside the stomach. But there's no ulcerations here. So the diagnosis of death due to hypothermia is not appropriate in his case.
Did you see, or do you see, any classic Wisniewski spots in Mr. O'Keefe's stomach lining or gastric mucosa?
No, no.
Do you observe any ulcers specific to Mr. O'Keefe's stomach lining?
No, there are no ulcers. It's a normal appearance of what we would call a gross specimen. When you open the stomach at autopsy, you can see some redness of the normal lining of the stomach.
Did you, let me ask this first. Do you have an opinion as to a reasonable degree of scientific certainty based on the totality of your review and examination of the autopsy and its associated file, an opinion as to whether or not Mr. O'Keefe died of hypothermia or complications related to hypothermia?
I do have an opinion.
And what is that opinion?
He did not die of hypothermia.
And is that opinion to a reasonable degree of medical certainty?
Yes.
taking a look at the darker red areas in the stomach lining of Mr. O'Keefe on the photograph to the right.
Yes.
That's Exhibit 164. Can you describe what those are? What are those darker areas?
Well, here we see a little bit of bleeding. The darker areas are the areas of the lining that are at the bottom of the normal rugae, because the inside surface of the stomach sort of looks like it's covered with little mountains. And so we can get the redness in between what the rugae in the stomach, and there's a little bit of increased redness here, but no ulceration.
Do you have an opinion, or were you able to form an opinion as to what the increased redness might be or is associated with?
Yes.
Cystine.
Did you note anything of significance in the rest of your examination of the file, the autopsy file, the medical examiner's file, that was related to what you see in the photograph 164?
Yes.
All right, I'm going to see its sidebar for just a minute here.
We can take that down.
We can see from the image, this is going to be a very quick sidebar. So if somebody wants to jump in and say something here, get a few seconds.
Well, clearly, I can't wait for the cross-examination here.
Yeah.
About why he didn't die from hypothermia.
I mean, it seems to me the doctor is saying that John would have been dead within 20 minutes. So how does this fit into the theory that the defense is trying to send out to the public over the last couple of years? It doesn't match it.
No.
So, because it doesn't match, the
doesn't.
guests left the house, I think around between 1:30 and 2. So John would have been dead by 1 o'clock.
Right.
If this doctor's correct.
You're right, Kevin.
May I continue?
Yes.
Thank you. With regard to the, it's my word, not yours, doctor, so forgive me, the defects, the redder marks that you're mentioning on the rugae or in and around the rugae on the gastric mucosa, did you note that there was a machine that was used for life-saving measures as it related to Mr. O'Keefe?
Oh, yes, it caused some damage to the body.
Okay, let's talk about that for just a quick second. What is that machine called?
It's a mechanical device to administer chest compressions, and the company that makes it is called Lucas, or one of the companies, so it's called a Lucas machine, and it can be attached to the body. Your arms go up over a ridge, and there's a plunger, and it goes around your back, and so it just plunges, and it does mechanical resuscitation and chest compression, compressing the chest right over the lower sternum, about 2 inches or so, and it's very helpful in a situation where the manual compressions, where the attendants and the ERT people, they get tired continually compressing for a long period of time. So the mechanical device was invented to prevent the EMT fatigue when administering chest compressions.
When you mention the sternum area of the body, are there, you go without saying, are there organs beneath the area that's being compressed by the mechanical Lucas machine?
Oh, absolutely.
What do those organs include?
Well, ideally they include the heart, because that's what's supposed to be pumping the blood out, but it's also in a circular area that's right below the sternum, which includes the heart. But what is also under there is the esophagus and the interior of the stomach. So this area is right under where the machine is compressing as well, as long as, in addition to part of the head of the pancreas, which is also right there under the lower sternum. And what can happen with the Lucas machine pushing in for 100 times a minute for a depth of about 2 or 2.5 inches, that these organs right underneath of it get compressed between the Lucas pump and the bony vertebral bodies that's along your back. So you have the Lucas machine compressing these organs, and they're compressing them against the vertebral bodies of your bony vertebral column in the back. So you can get other injuries, organ injuries, that is a complication of the automated mechanical resuscitation. You can get cardiac ruptures, you can get ruptures of the liver, because all those organs are clustered right there, and that machine is pushing those organs in between the pump and the back of the bony spinal column.
Doctor, in your review of the medical records, was there any indication that an automated chest compression machine, a Lucas machine, was used on Mr. O'Keefe?
Yes.
May we can take this down?
Yes.
There's two documents that I'd like to show you. First,
Yes.
that document, and then after you're finished, familiarize yourself. First one and the second one.
Yes.
Taking the first document that addresses the Lucas machine,
Yes.
how do you recognize that photo or those series of photos and graphs?
These are illustrations I put in my report, and one shows a generic patient with the Lucas machine in place around him to do the chest compressions. Then I have a photograph of the actual apparatus of the Lucas machine itself. Then I show what's recognized as medical complications and injury from that machine. It shows, I have an example of a CAT scan of a section through the body horizontally, right where the plunger goes into the chest. And it shows in another patient hemorrhage around the pancreas and around the top of the stomach. Then I have a diagram also taken from our medical literature that shows the direction of force that compresses those organs between the resuscitation paddle and the vertebral body and the backbone.
Doctor, are those photographs and graphs taken from peer-reviewed literature in the medical field that's normally relied on by other medical professionals?
Yes.
Your Honor, I'd move for the admission of that first document.
Right, subject to redaction?
I don't think so. I think that that one is not objected to.
Okay. All right, so would you hand that to?
Sure, thank you.
Exhibit 227.
Permission to display, Your Honor?
Yes.
Doctor, I know that's a little bit small and far away. We'll enlarge it as you need.
Okay.
It's not an eye test. Can you tell me what we're looking at? Yeah, let's take the top half of the document. What is that to the left, and then what's the machine in the
Okay,
middle?
so what you see on the left is a anonymous patient showing how the Lucas machine is placed onto the patient, where the arms are pulled up and clasped against these rigid mechanical bridges. And then here is the engine which puts the pump, and that's the pump which just goes up and down to do the chest compressions. And so that's how it's affixed to a patient.
To be clear, Doctor, that is not Mr. O'Keefe. That is
No, this is
could be a model.
an unknown
Okay.
person.
Okay. And then what are we looking at in terms of the actual machine to the
Yeah,
right?
this shows the actual machine before it's put on a patient. You can see how it encircles the patient, and then there is this circular pump, which is the compressor pump.
If we can look at what is that a picture of, the highlighted portion?
That's the circular part that actually is projected down onto the body
That makes contact with the chest?
Correct, and it has a spring in there that the engine above it gives a certain number of compressions per minute.
And you said on average the compressions per minute would be about what?
They should be around 100.
Okay. If we could go to the bottom half of the page of the graphics on the bottom. What are we looking at in this photograph?
Okay, we're looking at, on the left side, we're looking at a CAT scan, which scans a person who's had some injury from the Lucas compression machine, and it's a cross section. So the arrow here is pointing to the head of the pancreas and the area of the esophagus, and then the machine would compress down onto that. And the important part is that I don't know if that's working on there. The little thing that looks like at the very bottom, that's circular and then has a little, looks like a little steer head, that's the vertebral column, and that's bone. And so the pump is pushing in that area where the arrow is pushing those organs against the bony vertebral column. Excuse me. And that's on an actual patient that had that. Then on the right, it shows the schematic of the blue arrows indicating the force coming down. Then we see the organs, and the red arrows show how the pancreas can get hemorrhage, and also some of the esophagus that goes into the top part of the stomach. And we see that's, I can't really see where that, I think it stopped.
Oh. May I approach you?
Yes.
Oh, no, you've got it. Okay.
Maybe a battery issue.
Okay. And then we see at the bottom with those three little things projecting from it, that is the vertebral body, which is made up of bone. So you can see how the chest compressions, not only hoping to save the life by keeping the heart blood functioning, can also cause some injuries and damage, not life-threatening usually, to the other organs there.
We can take that down. Doctor, taking a look at the second document that's in front of you, do you recognize what's depicted in that document?
Yes.
What is that?
This is a picture of Mr. O'Keefe, his chest, while he's at the hospital, which shows a lot of the resuscitation equipment.
Is that a true and accurate depiction of of Mr. O'Keefe at the hospital based on your review of the medical file?
Yes.
I'll move for the admission of that.
Okay.
Oh.
Exhibit 228. Done.
Permission to display briefly.
Okay.
Taking a look at the photographs to the left and to the right, do you see any indication on Mr. O'Keefe's body that is suggestive that where the Lucas machine was situated?
Yes, as I pointed out here with the blue arrows, that big circular mark there is the mark on the skin where the compression pump compressed the chest of Mr. O'Keefe, and it caused some rib fractures, and it also caused those reddening of the stomach and some hemorrhage in the pancreas.
We can take that down. Doctor, based on your review of the medical records, did you calculate the approximate number of compressions that Mr. O'Keefe would have been subject to based on that Lucas machine?
Yes.
What is that calculation?
His body was found around 6 a.m, and he got to the hospital around 6:37, I think. So if they put the Lucas machine on him when they got him into the ambulance, and it's compressing at 100 times a minute, and that is from the time of the body being discovered to the time at the hospital, that's around 37 minutes. So if you multiply 37 minutes times 100 compressions a minute, that's around, over 30,000 compressions that would have been done to Mr. O'Keefe's body in the course of his resuscitation efforts.
Doctor, do you have an opinion as to what caused the hemorrhaging that we saw on Mr. O'Keefe's stomach lining?
Yes.
What is that opinion?
It was from the blunt compression of the Lucas machine.
Is that opinion to a reasonable degree of scientific certainty?
Yes.
You indicated earlier that there is a difference between someone dying of hypothermia, or complications associated with hypothermia, and a body that's already passed away just cooling, correct?
Correct.
Do you have an opinion as to a reasonable degree of medical certainty as to whether Mr. O'Keefe suffered from hypothermia?
I do have an opinion.
What is that opinion?
He did not experience hypothermia.
Did you observe any signs of frostbite?
No.
Did that have any weight concerning your opinion, overall opinion, as to whether or not Mr. O'Keefe died with complications associated with hypothermia?
Well, if someone dies due to exposure to low temperatures, you expect to see not only the Wisniewski's ulcers, but you expect to see some frostbite changes in the extremities.
Based on your overall review of the medical records associated with Mr. O'Keefe, were you able to reach an opinion and conclusion as to the cause of death of Mr. O'Keefe?
Yes.
What is that opinion?
He died of brain injuries and skull fractures due to blunt force trauma of the head.
Do you hold that opinion for Mr. O'Keefe's cause of death to a reasonable degree of medical certainty?
Yes.
I want to shift gears for a minute, Dr. LaPosada, and talk about patterned injuries elsewhere on Mr. O'Keefe's body. You've obviously talked about your training and experience as it relates to recognition of patterned wounds, correct?
Correct.
That's something that you were trained in when you were training, correct?
Yes, it's very basic to the discipline of forensic pathology.
And have you also trained others during the course of your 40-year career on the issue of wound pattern recognition?
Yes.
You've taught courses and given lectures, is that right?
Yes, I have.
I'd like to show you Exhibit 167 with the court's permission.
Okay.
Do you recognize what's depicted in this photograph?
Yes.
How do you recognize it?
Is a photograph of the right arm of Mr. O'Keefe.
Did you review and consider this photograph and others in coming or forming your opinions, coming to your conclusions and opinions in this case?
Yes.
In order to come to your ultimate opinion and conclusion, or opinions and conclusions in this case, is it important to take all of the injuries that a decedent may have suffered into account rather than one or two piecemeal?
Now you have to look at the whole picture to understand what happened to the body.
Why is that? What's the importance of that? It may be obvious, but explain that for the jurors, please.
Well, when you're looking at changes and injuries to the body and trying to understand what happened to the body, there are different patterns of injuries on different parts of the body. And by trying to separate those and understand what patterns were caused by certain things, then you're able to put together a sequence of events that happened to the body prior to death.
What role do photographs play in a forensic medical examiner reviewing the medical evidence and coming to opinions and conclusions? How important are photographs?
Oh, those are huge. It's standard practice to always document at the postmortem examination important findings with photography.
Were the photos in Mr. O'Keefe's case useful in coming to opinions and conclusions concerning his injuries altogether?
Yes.
What about the injuries to his right arm?
Yes, those photographs are very important to understand those injuries.
Do you believe that there is a patterned injury on Mr. O'Keefe's right arm.
Yes, there is a pattern injury there.
Have you ever seen, in your experience, either being taught or teaching, patterned injuries as they relate to animal wounds, generally?
Oh, absolutely. Very common.
Do animal wounds include both claws and teeth, dentin?
Yes.
So bite marks and claw marks might be two different types of patterned wounds that you may see in your evaluation, just
Correct.
in general?
Correct, because when an animal approaches the body, there may be damage from the claws and also from the mouth.
Do you expect to see punctate wounds as well as linear abrasions?
Yes.
Do you expect to see certain bite patterns as well?
Yes.
What types of injuries, let's talk about animals in general, what types of injuries do animals produce on the skin of human beings?
Well, animals can produce, if you're talking about, mammals, can produce injuries from their claws, where you get parallel scrapes of the skin from the claws applied to the skin, or you can see a pattern from the jaw configuration of the animal. And most animals that attack or get in contact with the body have canines. So there's two canines on either side that make paired marks, and that would be called a pattern injury. So it makes parallel sort of gouges, and as the canines move in a horizontal pattern or a vertical pattern, the space between them can change. The other thing you see in a animal bite is you see not only the canines that come out, but depending on how the jaw is applied to the body, you can have little dot-like imprints in sort of a U-shaped pattern, which are from the incisors, the little incisors of the animal. So you look for punctures, you look for paired gouges, which would be the canines, and then you look for arced patterns of little dots, which can be the application of the incisors of an animal bite.
What is an incised wound?
An incised wound is a wound due to cutting from a sharp object.
Would you expect to see incised wounds from an animal bite or claw marks?
No, they don't cause, they're not like knife wounds. They cause more of a scraping injury.
Do you see the injuries that you're looking at in Exhibit 167, are these more consistent with incised wounds or the scraping abrasions that you just talked about?
Sustained.
Were you able to determine from your review of the medical records whether the injuries that you see on Mr. O'Keefe's right arm were pre-mortem or post-mortem?
They were, oh yes, I can determine that. They were inflicted prior to death.
Do you have an opinion as to whether or not the wounds that you see, the patterned injury that you see on Mr. O'Keefe's right arm is consistent with an animal bite or claw marks?
Yes, it is, very much.
Thank you. We can take that down. May I have just a moment, Your Honor? Actually, Your Honor, may we approach very briefly?
Okay.
So we're supposed to believe that John was dead for 5 or 6 hours on the lawn and the paramedics wouldn't notice that? That seems kind of absurd.
I agree.
Do you guys?
It's all absurd. Yeah. None of that makes any sense.
Yeah, that's crazy.
Oh, I'm surprised she got that much in
Yeah.
on animal bites. I thought it was going to be a lot shorter.
And what does this mean about Karen's statement about pulling John out and the nose started bleeding and a live person?
Mhm.
You know,
Well,
I
she
mean, I
said
suppose that could be
gushed,
dismissed. Right.
right?
And I suppose that could be dismissed as just a bad memory or a false memory, but
Sure.
interesting.
Still strange to say, right?
Yeah.
And tagging it with gushed. That's bizarre.
I know.
That is very, very bizarre.
I think the main point, though, is it's going to be hard for jurors to believe that paramedics would arrive there and someone's been dead for 5 or 6 hours and they wouldn't know the difference. What happens to a body that's been lying in the yard dead or lying anywhere, even if
Well,
it's
I
in the
mean,
garage
that's
or
the
wherever?
thing is like, the lividity didn't really set in until later on, right?
Right.
Mhm.
Right.
Mm-hmm.
So how is Hank going to address this in rebuttal? Is he going to bring in Dr. Wolf, the neurologist? Is he going to bring in back Dr. Scorty Bella? I hope they got somebody better than that, but
Yeah.
Probably doubtful.
Yeah, I doubt it.
oh, John was here too. Sorry, John, I didn't see you. It was on the bottom of the screen here. We'll bring you in next time. There should be a break coming up soon too, so we'll be able to get you in on that, John.
May I inquire?
Yes.
You indicated that, in your opinion, the wounds to Mr. O'Keefe's arms were pre-mortem, not post-mortem, correct? His right arm, I should say, were pre-mortem, not post-mortem, correct?
Correct.
What's the basis for that opinion?
Well, a forensic pathologist has to be able to differentiate changes that happen to the body while the person is alive versus things that happen after the person is dead. For instance, there is something called post-mortem predation, where if the body is out in the woods and dead, then wolves and such can come and make, quote, injuries to the body. But we're able to tell from our training and experience that those were made after death. The usual way we tell is that when it's made during life, the blood vessels that are damaged, the heart's pumping blood through, so you can see a reddish color and maybe some blood around it. Whereas if the body is damaged after death, the changes to that body and those, quote, injuries look more yellowish and kind of brown because the blood is not flowing. So that's how you can tell if something done to the body is while the body was alive or whether it was done after death.
Do you have an opinion to a reasonable degree of medical certainty that the wounds on Mr. O'Keefe's right arm were pre-mortem?
Yes, they were done while he was alive and bleeding.
You talked about death investigations. As a matter of fact, you mentioned something about what a forensic pathologist's role is in a death investigation to potentially send investigators back out to answer certain questions, correct?
Yes.
Did you see any evidence in the medical records or the medical examiner's complete records that any effort was made to send investigators to the location to see if there were any animals at the location at or around the time of John O'Keefe's death?
Sustained.
Do you believe it's important? Well, let me ask it a different way. Would following up with investigators be an important part of any forensic pathology investigation?
No, absolutely. You're working as a team to figure out what happened to the body.
Thank you. We talked about the theme and theory of differential diagnosis, correct?
Yes.
How does engaging in the process of differential diagnoses avoid bias in an investigation?
By after you have your findings and you sit back and think, well, how many ways could I get this finding? And so bias sometimes means, oh, I think it's this, and then you just stop. So that's a sort of a bias where you make a decision too quickly and you don't then stop to consider what other things could cause this same finding. So you have to consider not only what immediately comes to mind, but then you think, how else could we get this pattern of injuries?
Did you engage in a differential diagnosis as it relates to this case?
Yes.
Did you consider whether the injuries could have been caused by a motor vehicle accident?
I did consider that.
Did you consider whether Mr. O'Keefe's right arm injuries specifically could have been caused by being hit by a motor vehicle.
Yes, I did think about that.
Were you able to rule that out?
Absolutely, not,
So the objection sustained, jurors strike that answer.
Tell me about, well, let me ask it this way. Did you come to an opinion or conclusion as to whether or not Mr. O'Keefe's injuries as a whole were produced by a motor vehicle pedestrian incident?
Sustained.
You indicated that you've done thousands of autopsies yourself, correct?
yes,
You've supervised many times more that.
correct.
How many of those autopsies that you've performed or supervised have involved motor vehicle incidents?
You know, hundreds.
How many of those hundreds have involved motor vehicle pedestrian incidents?
Almost as many.
Have you performed autopsies specifically on individuals known to be hit by vehicles?
Yes,
Have you performed autopsies on individuals believed to be hit by vehicles?
yes,
Have you engaged in differential diagnosis and inferential thinking in terms of developing an opinion or conclusion to a medical certainty about whether or not the injuries that you see on a decedent are consistent or inconsistent with a motor vehicle pedestrian incident?
yes, that's part of what we figure out as a forensic pathologist.
Did you do that in this case?
Yes, I,
Sustained.
What are some of the injuries that you would expect generally to exist if a pedestrian is hit by a motor vehicle at speed? Not 1-2 miles an hour, let's say 20 plus miles an hour.
yes, one of the things you see is a pedestrian is, standing upright and is impacted by this blunt object of a automobile or a van or a SUV. And what you see first most is the tissue is crushed where the projections of the vehicle impact the tissue. And when you crush the tissue, that gives you a bruise. So that's the first part of the pattern of impact. It crushes the tissue, it gives you a bruise because it breaks the blood vessels underneath the skin. And then depending on how much more force is applied, the skin can break.
So I'm going to strike that. Next question, Mr. Jackson.
In addition to bruising, what else might you expect to find in an individual who has been struck by a vehicle at speed?
So let's come over to Simon.
As I bring people in, what did the judge really expect? It's not just Jackson. Any defense attorney would have done this. And this is the problem with always doing these split decisions. There's other ways to introduce this stuff. It's not even really shady on Jackson's part. In this case, he's just doing his job as a defense attorney. I'm sure Margaret would do the same thing and anybody else would. Why did the judge not foresee this? I just think she's lost control of this trial. This is the problem with always trying to split decisions. And I'm going to bring in John DePetro. And for all the people here watching, if you haven't already, please, if you go to YouTube and look for the John DePetro Show, he's got a lot of subscribers and you'll really enjoy his work. So let me just bring him in. Welcome, John.
Good morning, Kevin.
Hi, John.
Hello,
Hey,
John.
everyone. Kevin, I agree with you. This morning, I view this, for those that watch sports, when you see when in a game, if the refs feel they blew it, they do a makeup call. And right now, my biggest fear is not Hank Brennan's ability to cross-examine this witness, who is, if you pay her a certain amount of money, I mean, she's got a rate card. She'll come in and testify whatever you want. She won't push back, right? Marie Wilson, Russell didn't push back that those weren't punctures, but the judge, because the Commonwealth made a mistake, I'm more fearful that the defense is going to try to capitalize on this, and they just want to run this trial off the rails. They know it's not going well, and now I agree with you. I don't like the split decisions. I think the next 48 hours are really crucial because they're just going to TLSC up with motions. They want to bore this jury. The jury, their patience is really hanging in the balance. And Canoni's got to reel this thing in. But right now, I agree with you. It's starting to spiral out of control with the defense.
Margaret, talk about this strategy of obviously you get the witness to say something and the judge can say strike that, but it's already in the juror's mind. So this is something I'm sure Hank will try to take advantage of this too, but this is something you guys must do all the time, right, Margaret?
Yeah, yeah. I mean, questions are not supposed to be considered, but of course the jury's going to listen to the questions, especially if from attorneys, especially if the trial has gone on this long. Absolutely. You can't, both sides have done that though.
Yeah, right. Both sides have done it, but the
It's like
judge
the
really,
lawyers are testifying.
Right. I mean, the judge had to, how could the judge not foresee this? That when she allowed that split decision this morning, that Jackson was going to do that. And then she gets to, and this expert is clearly trying to do everything she can for whatever reason. We don't know what her motive is, but to help the defendant here. And she knows it. So she's going to quickly try to get her answer in too. And
Absolutely.
I don't know how the judge couldn't anticipate this. It bothers me.
Oh, she anticipated it. I mean, of course she did. But
Kevin, you know what?
Again, it's an appellate issue. She's preserving this for the appeal.
Right.
Kevin, you know what's interesting is I don't think maybe we don't pay attention to a lot, but like Marie Russell, notice after she testified, she then has a website and she's promoting herself. And there's this subculture out there. And let me tell you, Marie, there's a lot of money to be made. And this trial, you get an endorsement from Alan Jackson. And, would she drive up for, less than an hour from Rhode Island? She's testifying. She's not going to go to the mat against Brennan. She'll have delivered as far as what AJ wants. But there's a lot of money to be made. And she just sees dollar signs ahead that she's this premier, witness. So
you're right.
Yes.
And there's also the attention. If you've been retired for a long time.
Right where I left off, so I'm just going to pick up.
Okay.
As best my memory can serve me. It has been suggested that Mr. O'Keefe's right arm, Doctor, was injured by contact with the right rear taillight of Miss Reed's 2021 Lexus LX 570.
No, I'm allowing that in.
Thank you. As Mr. O'Keefe, it was struck as Mr. O'Keefe was standing and the Lexus backed into him. That was a postulate put forward. I want to find out from you, do you agree with that?
Well, that's something to think about.
So,
Oh, I'm sorry.
yes, I'm going to strike that question and answer.
Let me ask it a different way. Let me ask it a different question. Do Mr. O'Keefe's pattern injuries on his right arm, do they correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm?
No, not at all.
Why do you say that?
First of all, those injuries are patterned injuries from an animal bite. We have the canines, we have the incisors.
All right, so I'm going to strike that, and let's see you at sidebar.
As we said, she's going to strike it, but the damage is already done. This is a sham at this point. This is absolutely a sham. Let me bring in people again.
This is a mess, hey?
But he'll just keep doing this.
Yeah,
like
I know.
this is the strategy, right? And Kevin, as we're standing back, that now they have him in the garage, and the cult doesn't go anywhere. There's still people out there saying that 227 happened, but here's the deal with Marie, because she's widely used, and a lot of Massachusetts lawyers use her. This is someone, she's not looking to make a name for herself, but she's just looking to increase her visibility. Hey, look at Marie Russell. They fly you cross country. They put you up. You get to ride in the limo with a lessee. It's not no heavy lifting, no holidays, no weekends. These trials don't. It's not like it's. Go ahead.
I don't mean to interject. You keep saying Marie. You mean Elizabeth, right?
No, when I'm referring to Marie Russell. Marie Russell.
Okay, all right. I'm sorry. Okay,
is someone who Marie Russell wants to be Elizabeth. That's what I'm trying to say.
Okay,
Marie Russell was flown cross country, put up, traveling. Elizabeth, she has business. She makes a good living doing this. Plus, she's at Brown, so that gives her more credibility. So, but this just raises her profile even more. And she is, what you're seeing on the stand right now, she's a real pro. She knows the drill. She knows, when Jackson, the whole trick here is to just try to answer as quickly as possible because she knows the judge is going to come in and that Hank is going to object. But
Right.
this doesn't distract Alan Jackson from his strategy, which is you don't then say, okay, I'm going to back off. You just keep coming at it in different ways. You wait
Right.
for Hank to even have his guard down or the judge to have her guard down.
Right.
And you're dealing with a real pro that knows, they're dancing. She knows
Right.
exactly where he's going. And I, by the way, there are people like this out there. She just happens to be the one on the stand.
Right.
People need to caution. I am well aware of this woman.
I was
Wait till
gonna say,
Hank.
with being
Act,
being Rhode Island,
yeah.
I'm sure
Oh
you
yeah.
know all about her
Wait till
credibility.
they
Yeah.
talk about Station nightclub fire. Wait till they talk about the condition of the morgue. But right now, the Karen Reed people are jumping for joy, and Alan Jackson is just throwing raw meat out to the crowd.
And now Hank is going to have to use all of she has a long history that can be used to destroy her credibility. And Hank has no choice but to use it now. But how's it going to make him look with this, in front of a jury, ripping apart this witness who really seems to be frail and has a lot of health issues? As did Dr. Sheridan last year.
Yeah. He's got no choice, though, because
he has no choice.
Right now, I think she's the most effective witness they've had. She's not a snake like Dr. Wolf. She seems to just be this knowledgeable older woman. We don't know how much she's being paid, but this is something that if you're on the jury, there seem to be two different doctors that are saying two different things. So
it's interesting how, John, did you notice? I'm sorry to interrupt because we're about to go back.
Oh, go ahead.
How the defense pointed to that scuff mark along the side spoiler. How does that?
Yes.
How did Karen back it into John's Traverse cause that?
Yeah.
How was that caused? What is the defense? What is Free Karen Reed world? How do they think that's that long? It's in some ways you could easily, and I think Hank's going to do this, use what she just said to describe. So it also, she described the ridges that caused the head wound. And I think she only looked at Microscott's recreation that shows a flat lawn. But anybody that looks at that actual lawn, and then he's going to ask that, did you look at the lawn? It's not smooth or flat at all.
Good point. Oh, here they come.
May I, Your Honor?
Yes.
In your report, Doctor, you indicated that Mr. O'Keefe's patterned injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm. Do you recall putting that in your report?
Yes, I wrote that.
Do you stand by that?
Yes, that's my conclusion.
And you also wrote his arm had no tissue bruising from impact injury. Do you remember writing that?
Yes,
Do you stand by that?
I do.
You also wrote, neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes at various angles and depths. Do you remember writing that?
I did.
And do you stand by that?
I do.
You also wrote that you noted Mr. O'Keefe had no bruising on his arms or torso. Is that right?
Correct.
And you also wrote, in particular, Mr. O'Keefe did not have bruises on his legs, correct?
Yes, correct.
And you indicated that that was shown by dissection of the leg tissue and muscle at autopsy. Is that right?
Yes, there was a special leg dissection done to look for bumper impacts.
You reviewed the entirety of the medical records associated with the autopsy,
Yes,
including photographs,
taken to the hospital, yes.
okay, and autopsy photographs,
Yes,
and other data and documentation, correct?
yes.
Are x-rays an important part of an autopsy generally?
Oh, yes, usually there are x-rays taken of the body prior to the examination.
What do x-rays show? Why are those important?
They're important because they show foreign material in the body, like a bullet. They also image the skeleton, so we can look for fractures of the bones.
may have just a moment, Your Honor.
Okay.
May I approach?
Okay. Yes.
Is it a possibility to call in Crosby now? I don't know. I'm wondering. I know Hank said he wasn't going to call him,
Right.
but after what she's been rambling on about,
Margaret, I was thinking the same question. So the option is still open to Hank to do that, right? Or tell us what you think.
I think she just stepped away right now.
Oh, okay. I'm sorry, Margaret. I didn't. We all got caught by that a little by surprise. I was getting text from someone. I looked up and it was Fan. I was like, oh, oops, sorry, guys.
oh, you're
Anybody have?
muted.
Margaret's back. Margaret, do you? So Boomer's question was a good one, and I was thinking this too. So even though Hank informed the court yesterday that he was not going to call Dr. Crosby, does he still have that option?
Please rise for the jury.
So we're going to get about a 15-minute break here, I assume. So, Margaret, does he still have that option to call in Dr. Crosby to rebuttal? Dr. Crosby was the dog bite expert the state had on their own rebuttal list. Does he get to call on a medical examiner now? Or do they get to call Dr. Wolf, the neurologist, back? We can't hear you, Margaret. I don't think your mic is on. I see
Yeah,
you
I think you're
talking.
muted.
Hey, Kevin, can I just,
Yeah, go ahead, John.
oh, you know,
Dr. Laposada, you can step out, okay?
hold on.
All right,
Are they-
I did receive another motion this morning for a curative instruction. I'm not going to even consider this today. We can consider this at the charge conference. So that's where we're at with that. All right, work it out. If you can't work it out, let me know. I'll come out before the jury.
All rise for the court,
Can you hear
please.
me now?
Yes, we hear you now. Yeah,
Yeah.
good.
I don't know why it switched over to my AirPods.
Yeah. So if you have a reply to that question about what are his options into calling up rebuttal witnesses? Can he still call Dr. Crosby? Can he? I don't know if or Mr. Crosby. I'm not sure if it's a doctor. Can he still call medical examiner or Dr. Wolf, the neurologist? What are the options here?
Yeah, I mean, he does have an option. He can request, he'd tell the judge that he has they're still on his list, that now things have changed and he would like to call Dr. Crosby but it's a strategy decision for Hank.
Right.
I mean, he may decide to address it in closing arguments, and let's wait and see what his cross-examination looks like.
Right. John, what were you going to say?
I was going to say that, let's go down that road. We all know they're not dog bites. Marie Russell even testified that there was no puncture, but let's go down to that road. Okay, they're dog bite. What dog? A neighbor's dog? A stray dog? Right now, in that courtroom, Hank Brennan has set up the narrative. It happened by the flagpole. He's on the ground outside. So where are they going with this? Was it a neighbor's dog? Was it someone just a loose dog that night? So the dog's attacking him on the ground. There's no remote implication or evidence that places him inside the house. And let's just say he was in the garage and the dog attacked him. How does he end up on the lawn? I think Hank just stays on the path he's on. I admit, he's going to need a aggressive cross with this individual that's on the stand, La Posada, which I think, again, I don't think she's going to do a lot of pushback. I think much like Marie Russell, who, when he got her to say, yeah, they're dog abrasions, there's no bites there, even though everyone's calling them dog bites. They're not, to me, they're not fully ready to go to the mat. I mean, we saw Dr. Wolf. There is someone working with the defense as an advocate who is, oh, I don't remember. You got to ask my partner. Could you repeat the question? He doesn't answer. I loved how Hank would say, oh, you don't like that question because he doesn't answer it. But this, I think he will successfully be able to pull out exactly the testimony he has. And I just don't, this woman is, I don't think, is going to go to the mat. She is.
And she was only allowed to say animal. She wasn't allowed to say dog. And so if the jury is entertaining the idea that it was some wild animal out there, unless it's like a chupacabra, it's going to be something that also would have left DNA. So if it was like a raccoon or a coyote or something like that, there would be DNA for that too. I guess maybe a wild pig.
A wild pig.
I
was just going to say that.
What are they going to charge the homeowner? Because as John was out there after she hit him laying there, that the homeowner didn't stop, that a stray dog started attacking him? Like, where are they going with this? What Judge Cannoni said yesterday about, she can sense the jury. You guys, that's really accurate because, okay, so today I'm not but I when you spend as amount of time as I did in the courtroom, you start talking to a lot of different people on both sides, by the way. The jury is checked out. The jury was promised 6 to 8 weeks. We're at that mark. They're like, what is this? How much longer do we have to go through this? They haven't lost anybody yet, but the jury, ignore these people that are saying the jurors are writing everything down and the jury, like it's all bullshit. I did a TV segment last night and someone's like, the woman said, oh, and my sources tell me the jury's paying attention and they've dismissed Brennan. That is patently false. It's put out as propaganda to try to influence people. There's always a couple of jurors that I have down in my notes. They're like scribes. They write everything. I can't even imagine. Like maybe they just do it out of nervousness, or they think they're supposed to.
Or it's a way to stay awake.
Yeah, way to stay awake. If you want to, if you focus on, there's a couple of jurors, you could just keep saying they're writing everything down. Yeah, but I go with the majority. There's 18 people. What is the impact on the majority? And right now, I think she's got to rein this thing in, the judge. Or if this starts to go out of control and it starts to go 9 to 10 weeks, then Hank could have some problems because then.
John, I have a question for you, John.
Go ahead.
But also, Margaret, if you could be considering Lisa's question that's on.
Yes,
the screen
I'm actually typing in the comments right now, but I can talk about it.
I want to let you speak to that, but I have a question for John first because I think people want to. So people that haven't been in the courtroom, and so we hear that the deliberation room must be downstairs. So just to explain to them from what you're seeing there, this process of, do they get called up and then they're waiting out in line in the hallway outside, and then while discussions are going on, seems to be part of the frustration and the fed up, as the judge said there. But explain the process of the setup there, and then we'll go to Margaret to answer that question on the charge.
Okay, where they are. So when you enter, I go through security, and you take a right to go up to, it's the courtrooms on the second floor, and then it's the one over in the corner, and it's next to, where the Sacco Vanzetti courtroom is, the big grand one that's right there. But where the jury is, now, when I come in and I go through security and I go right up the stairs, if I go straight, if I go down that hallway, to the right is Morrissey's office. To the left is the office where the O'Keefes go during lunchtime and the breaks. If I keep going down that hallway, there are There's, a Coke machine, and there's candy and those types of things. To the left, you could go up these stairs, and that's where the tech people are, or they call it the overflow room, where the media can go. However, to the right up the stairs, that's where the jury comes in and out of. So when
Okay.
they're bringing the jury in, they bring them down those stairs, because I've been, there's benches there, and you're kind of away from the fray, and that's where I would eat during this type of break. And
Mhm.
they bring them up those stairs, so they're in the far right corner of the building, but they're actually on the second floor. So
Mhm.
if you were in the big Sacco Vanzetti grand courtroom, which is next to where the trial is, I would think you might have access through there, because then when they bring them in, they bring them in through that courtroom, the Sacco Vanzetti larger courtroom,
Mhm.
and then they bring them into the courtroom that way. They don't have them cut through, if in fact, because a lot of times there's another trial going on and they're using that. So it's not like a huge delay, but what people need to understand are these are people 18, and they don't know each other. They didn't know each other. They spend a lot of time together. They're spending more time with these people than their family. This is, it's just
I'm
kind of draining on. So I
Mhm.
think they're right at the edge. She's got to
Mhm.
find
I'm
a way to
gonna
wrap this trial up.
I'm gonna say this about the medical examiner to so I think that it's the dog bite thing is unfortunate they keep sneaking that in. However, I think it will stick with the jury that she's not allowed to be asked or answer these questions, and Dr. Marie Russell was. They're not idiots. Number two, I think that yet again, I would anticipate that Hank is probably much brighter than I am, so he'll probably address this in cross. I know I would. She kind of strengthened the Commonwealth's case with her testimony, and in a very meaningful way. She dug into this whole sorry, shh, the head injury would kill him or incapacitate him immediately. Leave
Oh,
him alone.
good audio clip. I like that.
That's a Lessie boomer.
Yeah,
Kate has a
that's
Lessie there.
right.
Sorry. Oh, the little fur menace. She's just a pest. Is she making fun of your hands? So she's testifying that head injury would have incapacitated him immediately. So what's a good judge of when he was incapacitated? Well, there's digital footprints as to when he stopped moving, and that data is uncontested by the
Right.
defense.
And not only that, I thought it was effective that she mentioned, and this actually is what Dr. Wolf said, is you don't go completely, it's like in a movie where someone just stops moving. The body is, the body, the arms and the legs are moving. And therefore, to me, that's why when Karen said he didn't look mortally wounded, I believe her that when she drove past John lying there, she saw some movement with the arms and legs. But what Marie Lapazada did was once again back up what Dr. Wolf said is, when someone's having a seizure, it's not like they're not moving. So he was unconscious, but he did have some body movement.
Margaret, did you get an answer to that question we had about the
Oh,
charging?
yes. I'm sorry. Yeah, absolutely. So at the end after closing arguments, the judge will instruct the jury on the law. Okay. So the defense attorney and the prosecution and the judge will have a meeting at some point to discuss what the judge will be instructing the jury on. And, they'll go through the typical judge's instructions, on second degree murder, what is manslaughter, what is leaving the scene, and what is reasonable doubt. And it's a long instruction. It's important that they'll talk about it. They'll say, well, we'd like you to instruct a little bit this way, add this instruction to, beyond a reasonable doubt part, right? So, and it's important because lawyers in their closing arguments will like to mirror the judge's instructions to some extent. For example, Hank Brennan may say, well, you will hear, your honor will explain such and such in the judge's instructions. And, so sometimes that's what they do. They tailor their closing arguments to what they anticipate the judge will say on a particular point. So that's what the conference is all about as we're getting near to the end of the trial.
Thank you for that. That helps a lot. That really does.
Hopefully.
Thank you, Margaret. It's good to have you
You're
here.
welcome. Well, I love being here. It's a great panel discussion. And I am streaming this to my audience.
Oh, wow. Excellent.
Nice.
Yeah, I figured out how to do it.
Oh, good. Good for you. Excellent.
Hey, Margaret, I also just want to mention, and by the way, I'm glad that I don't know if you were on last night, but they've recognized talent and brought you on to Canton Confidential.
Yeah, thank you. I'm on tonight. So I'll be on at 7, Canton Confidential.
And again, I'm not
Court
trying to
TV.
make you uncomfortable. This is just my opinion, and I want to do it professionally, diplomatically. But what a problem I have with the NBC Boston is, you appear on Court TV, Kevin appears on Court TV, I do. Vinnie Politan will say, and Karen Reed supporter Nick Rocco and Kevin Lenihan. So they establish, this person's going to almost defend the Commonwealth. This person's going to defend. The problem I have with that program is they position Sue O'Connell as, I'm just this middle of the road person. I don't have a side. And again, I'm not trying to, be a barking dog or a broken record, but it's so clear to anyone that pays attention that NBC Boston should be saying, and joining us is Karen Reed, supporter. Courtrooms inside it. That's what it is. As much as people may, not Court TV, Kevin, as we've talked about, at least they're upfront about it. That's the problem.
Right.
It's not even a Sue problem. To me, this is more of an NBC Boston problem, because for anyone that wants to pay attention, it's very clear where her allegiance is, how she tailors it. I just think that's the Boston media has really dropped the ball. If this were, and I don't want to get involved politics, but if this were somehow a political discussion, and let's just say she was pro-MAGA, oh my God, the Boston Globe would have an expose on it, and how does this go on, and blah, blah, blah. But for some reason in this trial, it's allowed.
And I remember Canton Confidential covering this early on, like say a couple of years ago, when the case first got in the public mind through Turtle Boy and through Karen's defense team putting it out there. And I don't think at that time that NECN was yet part of NBC. I think that acquisition came later. But Canton Confidential was extremely pro-conspiracy. That's all that 100% of the time. So since then, NBC, the local NBC they were a hotbed for conspiracy theory. Since then, they've acquired NECN, the New England News Network, or whatever that stood for. And so they've tried to add a little bit of balance, but it's still the holdover. That Canton Confidential group, which was really starring Sue O'Connell, is to some degree a source of disinformation. Like in the documentary, when Sue said that there was a small window to plant evidence, there was not. She should not have said that. That shouldn't have made that. That shouldn't have got through the editing process.
Yeah.
So.
Yeah, it's all live.
Yeah.
So I'm trying to provide a legal balance. That's what I'm trying to do on the show. And they'll ask me a question, and I try to be as neutral as possible and think about, what is the legal, answer to this. And a lot of times it's very quick too, because their lead legal analyst goes on, and then they'll ask me a follow-up question or something like that. And sometimes it's already said, so I have to come up with something else. But I try to be as balanced as possible on these shows. I'll be on at 8:00 tonight for Court TV. Are you guys going to be on as well?
I'll be on at 8:00 too, so I'll be with you.
Oh, good.
There you go.
Nice.
Who else? What about you, John? Are you on?
I haven't checked my email. They usually notify me day of, but it could be, or I could be back in the 9:00, which is fine.
So this must mean that Joe is not on tonight, because usually they have a pretty consistent panel. They try to keep me, Nick, and Joe together, and then there's like a fourth.
He was on in the 9 last night. They had Joe on against this. I don't want to say against, but just on with in the segment.
Right.
But I think it's listen, the fact that the headline of local media was that Hank Brennan, this whole narrative that he misled the jury. That's, that is something that her supporters, the defense, the conspiracy crowd, they were looking for that. And it's not going to last, but it definitely gives them a spark. It definitely feeds the narrative that the fix is in, it's rigged, blah, blah, blah. I just hope the judge can reel this thing back in.
Right. I always wish I could get Kate on Vinny's show, but Kate really won't ever do it because she really
good,
I know,
good luck
Kate would
with
be
that.
not much
great.
use.
You know what else I
doubt.
want to mention is, as much as everyone's saying Hank, we also have to remember, I mean, you do have two other people sitting there. You know, the guy's been working
Yeah.
nonstop. That if Adam Lally was ever going to step up and be useful, that could have been a moment. Hank is obviously
Oh,
the face of
right.
that, you know. So I think you know, I think that was tough and unfortunate. But as I was telling someone, listen, there's going to be mistakes. You know, you're watching again. I'll go to a football analogy, but there's going to be missed snaps. There's going to be interceptions. There's going to be fumbles. It's all part of it. And the defense, to me, have made a lot more mistakes. But Kevin, I think the narrative that Hank Brennan has established for those that want to pay attention, and with this jury in this courtroom, is it still comes back to what happened outside the house by the flagpole. It's the taillight. Even Randy rescue Randy of him, the
Yeah.
mannequin, breaking the glass. I think the jury is seeing that video in their sleep, and I still believe that was a mistake that they've just reiterated, because you could see in real time and in this demonstration of what happened with John O'Keefe.
Absolutely. Test example E. That did them in.
Yes.
That was the
Boomer,
one
you know
right
what
there.
else is? Kevin, when they showed, now I know that, you know, and Hank Brennan went after him for, they had the mannequin rescue Randy behind the SUV. And then they did it, you know, Karen was saying, well, let's see it in 24 miles an hour. Let's see what that looks like. I don't know about you guys, but like it was so violent when they showed that. And I was horrified by that. And when you look at it twice, I know that it's a mannequin but it could have been a person. And to me, I think it's tough to separate. I think, you know, where Hank could really bring this home, and people need to understand this. And I run into it every day of people that say, you know, I think she did it, but I think it was an accident. Where I think Hank is really going to drill down is she intentionally went forward, and then she intentionally put it in reverse, and then even, you know, the tires spinning in neutral. But that was so violent. And when you see the mannequin slide across the ground, to me, the jury is like, wow, that's how we got the grass stains. And that's only 24 miles an hour that they were doing that at. I am really, I still can't believe they showed that, because, you know, they're trying to argue over, like Nick Rocco. Well, the holes in the sweatshirt, you know, if someone robs a bank, you don't have to prove what they had for breakfast that morning. I talked to a criminal defense attorney from the outside that was watching this. Like, what are they arguing about? You know, what was the speed of the person that robbed the bank? Like, you don't have to prove. These people
It was kind
have
of
a
it was
they
kind
have
of
a
funny, John. I
misguided
think
notion of, like, Karen is acting, and her supporters, like, you have to do an exact replica of what she did, or therefore you have to vote. That's reasonable doubt and not guilty.
I think you watched the segment
never
that I was on
happens.
Friday, John, and it was kind of funny. So when they went to Nick first, and then when they came to me, I said that
Yes.
kind of similar to what you're saying now, that this was actually powerful for the prosecution, because now
Yes.
through this video, they could visualize things like how that taillight cracked and stuff like that. And Vinny and the other lawyers looked at me like I had six heads. But then after the commercial break, when they decided to show the clip of that, Vinny had a different reaction. He was kind of like, wow, I can really see how this could have happened now. I don't even think he realized that that's exactly what I was just saying 5 minutes before.
Yes. Yeah.
But, you know, a picture's worth 1,000 words, and a video's worth a lot more than that. And so now the jury, after 7 weeks of trial, the images from that video that ARCA created, that's what's going to linger in their minds. And it matches up to the state's theory of the case. And same somewhat here with this Dr. Lapa Soto, whatever her name is.
Yeah.
She didn't go to the crime scene. And so she has an image in her head that lawn is flat and smooth, which she probably got from looking at microdots recreation that for some reason was allowed
Right.
to be used in the first trial, but is not allowed to be used here. But if you go out and look at your own lawn, it doesn't look like that. It's especially if it's frozen, but you're going to see it's not smooth. You're going to see those ridges out there and little divots and holes if you look closely at it. And that lawn in particular on 34 Fairview was not in very good shape. Brian was not a guy that wanted to spend a lot of time taking care of his lawn, and his own family has said that. But if the doctor had went there and get out of her car and looked at that lawn, she would see that it has exactly what she described. It would have been necessary to create those wounds.
Yes.
And I think that, again, Arca's videos have kind of undercut some of her testimony as well. She went through the whole, I would have expected to see leg breaks and trauma to the legs, the lower body. And now the jury knows that that doesn't always happen because they saw it for themselves.
Test example E is so brutal for the defense. It did so much damage.
I thought so. And Kevin, that was an excellent point. I did catch that. Look how far, and I mean, Boomer and Kate and you guys know, I mean, they've gone from Carl and Albert, slugging John when he walked in the house to knock him to the basement, to now Nick Rocco's arguing the holes in the sweatshirt don't match. I mean, talk about a retreat. I think, I'm not sure who said it, but it is interesting how, and again, I get that it's not in the courtroom, but how quickly the mob just pivots to, okay,
I know.
then they brought him in the garage. Then, I mean, it's defense du jour. Like, whatever you say, we're going to come up with a way around it.
I mean, this doctor just said he was dead within 20 minutes of that wound.
Yes. Yeah.
How does that fit any of the theories that they've been pushing on us for a couple of years? And they don't even ask those questions. Like, so the guests at the house party would have still been inside the house partying.
Yes.
When John was dead, if this doctor was correct in her testimony.
And they would have had to drag him right outside somehow.
Right.
So
why is Jen
saw
McCabe
that.
going in search for how long to die at 2:30 when John was already dead, according to
That's an excellent point, Kevin.
Yeah.
Oh, wow. I like that.
And it takes time, it takes time to drag a body outside. So somebody would have seen that.
Yeah.
Based on
There's no
this
movement.
analysis.
That's the thing. What really screws her in here, the one thing they don't have an answer for the data. They don't have an answer for the data.
Oh, yeah, absolutely not. It's bulletproof.
So,
Data's bulletproof.
Right. And they're not even, they're not trying because they can't. Okay. That's what's happening there. So everything that they have their testimony tailored to try to create some, doubt there is really contingent on being able to, dispute the data, which they can't and they won't. So, I mean, it's kind of like, again, the only peril this trial's had from the beginning is whether or not the jury's been infected. A reasonable jury, what does it matter if they're dog bites or not? You can't put them in the house. The dog bites were merely a creation to try to put him in that house and get him away from the flagpole, because that was the last place that she left him. I mean, and so they tried the stairs, they tried the dog bite, and they can't get past the data. So now they're trying to argue, injury inconsistencies when one of their own experts already said, yes, if you drive a car into a group of people, the same car, right, in this group of people, everyone's going to have different injuries, right? And I'm sure he's going to be able to do the same with this one. But I think what really, really screws them is that she locks in that timeline even more to that trigger event, because she's saying once he gets that head injury, he is not getting back up. And so, okay, great. You used all the evidence to come to your conclusion. Did you use the data? Because here's when he stopped moving, right?
Mm-hmm. Right.
And here's where she backed up her car.
And also, one of the comments, I think Jeff said that in the phone, how could he go inside the house for 20 minutes when the phone remains underneath his body the entire time on the lawn? Mm-hmm. So that data just doesn't go with what they're saying. Defense is saying. Thanks, Jeff.
No, I think people on either side get all worked up. Like you've got two sides of an argument here. Nobody's going to be bringing in, well, except for Karen this trial, apparently. But under normal circumstances, nobody brings in information that's damaging to their argument. So it's to be expected. Yeah, they're going to present a witness that says that he got bit by a dog and not hit by a car. That's their theory. Fine. The Commonwealth has one that says the opposite. But, it's the rest of the evidence that comes together that makes this case. And even still, you're not doing well if even if you have an advocate like this expert up on the stand, if they're saying things that hurts your case and helps the Commonwealth, bad position to be in. I haven't seen one witness that they've called that hasn't ended up in that position, because the truth is the truth.
Here's a question that you guys can take on. So I've been reading a lot of anonymous mass lawyers, brilliant articles on Substack. But one area that we disagree, and maybe I disagree with a lot of lawyers on this, is he takes the view that the defense needs to have a pretty detailed and specific alternate theory of what happened here. Now, the way I imagine this jury working, and I think this defense is pursuing this strategy, is what they want is the jury just confused in that deliberation room and arguing a bunch of whole different stuff, trying to connect these various dots here. The more confused the jury is, and the more they can't settle certain questions, the more that plays for the defense. So is that part of their strategy here? Is that they just want the jury confused about to some degree about what the state is saying that has happened and how to make it all add up together? Is that part of the strategy here? Do you guys think?
So
Go ahead.
Go ahead. Are you answering the question, Margaret, is the defense trying to make the jury mad with the delay? Is that the question you're on now?
No. I'm sorry. That was that was just a separate thing.
Okay, I'll answer the next question.
Is there a strategy just to have the jury confused? And I don't know. Let's see if I can't quite get this.
No, I understand what you're saying, but
for
I
the
don't.
Defense.
Yeah. Oh, sorry.
Yeah. The defense strategy is just to have the jury.
Yeah. So the defense is trying to raise reasonable doubt. Yeah, absolutely. I'm sorry. It's hard to look at the comments
I accidentally
and then
clicked
listen
on that. Sorry.
at the same time. I'm not.
I had you confused,
yet.
not just the jury.
No,
Yeah, me too.
I'm trying to read and listen.
But
here's
I was
the thing.
spinning plates too.
I've talked to a lot of lawyers about this case. All the time we're talking behind the scenes, and defense attorneys will say, from the get-go, Jackson should have argued reasonable doubt as opposed to creating this conspiracy theory. So he, hammer away on reasonable doubt. So I'm sure for trial number 2, that's going to be what he'll be doing. That's why, going back to the other question, when they're conferencing today about what the judge will instruct, that's going to be a big thing, the whole reasonable doubt instruction as to what she's going to use, because the trial isn't going very well for the defense, they're going to have to hammer away on reasonable doubt. And that you will hear that peppered more than you heard that in the last trial. I guarantee it, because that's what lawyers love to argue. And of course, that's smart, for the defense to do that. And what was the other question? The other question, I believe, was directed at me. And is the defense trying to delay the trial? I don't think so. You are unmuted.
Well, maybe the longer it is, the more confusion it makes, and the more frustrated or fed up the jury is.
Yeah, and again, they're trying to create a cloud of reasonable doubt.
Right.
That's what they're doing.
So it sounds like they're bringing in the jury now. Yeah.
Okay.
And hopefully Jackson is almost done.
Oh God, please.
I think what the attorneys that are criticizing it, though, Kevin, are saying is that they're creating the potential for a certain burden shift, right? When you create an alternate narrative, it needs to make sense. And I think that the defense's strategy, the more that I think about it between the two trials, was a lot of baiting. They were baiting the Commonwealth into putting on this case for them. And I think they were taken aback a bit when they didn't, because Lally did, right?
Right.
Mm-hmm. Big difference between trial 1 and trial 2 as far as the prosecutor goes.
Right. And we have to separate the attempt to pollute the jury pool by spreading this conspiracy from the trial strategy, which can be very different.
Mm-hmm. Yes. That was done pre-trial.
Yeah, but I think it was intertwined in a way. I really do, because I think that the social media strategy gave some legitimacy to what they were crafting as this alternate narrative, and it forced, at least Adam Lally felt that it forced his hand to essentially put on the defense case for them. And I think that's, and you really see it shine through, I think, in this trial, because they set the trap and Brennan didn't walk into it. And I don't think Lally would have a second time either. So I want to credit him with that. Brennan is absolutely benefiting from learning from the first
Oh yeah,
trial.
absolutely.
Yeah.
Absolutely.
Mm-hmm.
Yeah.
Right.
Both of them, both sides.
But they never wanted any of these people on direct. They always wanted them on cross, and they always anticipated them on cross. That was their entire plan, was to be able to lead them into this flimsy narrative. And now that they can't, you see what they're left with. And so I do agree that it's probably to create some, confusion. They're trying their best at reasonable doubt, but I think that their strategy was quite contingent on the prosecutor's cooperation. You know what I'm saying?
I think
and I think so. Both. Go ahead, Boomer. Go ahead, Mike.
I was just going to say, I think the defense may have blurred the lines too much between a trial by jury and a trial by public opinion. I think they've been trying to make their case to the, the Free Karen Reid crowd, and I think that's hurting them in the courtroom. I think that's where I think you might be right. Yeah.
I think too, like we were just both talking about how both sides are going to benefit from or improve and based on this, what they learned from the first trial. And I think it's in different ways though. Look, we all know, I don't think it's not being unobjective for me to say that Karen's did this. The evidence is just too insurmountable at this point. So from that starting point of knowing that Karen is guilty, it's a slightly different strategy. So I think where the prosecution is obviously benefited is they get to not only learn from mistakes they made in the first trial, but they've got new evidence on this and new experts and stuff like that. Mm-hmm. Where the defense is benefited is some of those experts that are willing to help them, including, or not just experts or witnesses like Officer Barrows. They get to improve their testimony over trial, what they're going to say and stuff like that. Mm-hmm. So Dr. Marie Russell got to improve quite a bit from what she did in the first trial.
On the court's bench, there's an item I'd like to treat back.
Miss, we need that marked for identification.
I need all three of them marked for identification.
Okay, and we'll do that afterwards. Just please go ahead.
Do you see any x-rays?
I did.
What were the x-rays of?
The x-rays were taken of Mr. O'Keefe at the medical examiner's office, and they were x-rays of his chest, his arms, and his legs.
Did you specifically review x-rays of his right appendage? Hand, forearm, arm?
Yes, they were included in the x-rays.
Have you seen x-rays before?
Oh, many times.
How many times?
Thousands, probably.
Is part of your job to review x-rays? To make a determination of whether or not they indicate broken bones, fractures, hairline fractures, things of that nature?
Yes, it's part of the medical legal autopsy to study the x-rays of the deceased.
That's done in the ordinary course of being a forensic pathologist, is that right?
Yes.
Are you trained on how to read x-rays?
Yes.
You have to be a radiologist to read an x-ray as a medical doctor?
No.
Medical doctors do that all the time, correct?
Yes, it's part of general medical training.
And is it also part of specialized training for forensic pathologists?
It falls under the rubric of general radiology that a doctor knows. There are some specialized areas in forensic where you have to understand like decompositional changes that you can see on an x-ray that aren't something that you would see in a clinical setting.
Taking the appendage one item at a time, did you look at Mr. O'Keefe's x-rays of Mr. O'Keefe's right hand?
Yes.
Did you see any defect in the bones of the right hand?
No bony defects, and the tissue was normal.
Did you take a look at the x-ray of Mr. O'Keefe's right arm?
Yes.
Did you notice any defects at all in the bones in the right arm?
No, the bones in the right arm were intact.
No breaks?
Correct, no breaks.
Fractures, hairline fractures?
No.
Did you look at the upper arm x-ray of Mr. O'Keefe?
Yes.
Did you note any defects in the bony structure of Mr. O'Keefe's upper arm?
No, the bones were 100% intact.
No breaks, fractures, hairline fractures?
Correct, none of those.
Was there any indication in your mind, based on your review of those 3 x-rays, the hand, forearm, the arm, that that arm had suffered any kind of bone trauma at all?
Sustained.
Was there any indication, based on your review and your expert opinion, that his arm had been broken, fractured?
No, the bones were intact. No breakage, no fractures.
Thank you.
Okay, thank you. Examination.
Good afternoon, Dr. LaPosada.
6 minutes till the afternoon. Okay, good afternoon.
That's okay. You wrote a report in this case, doctor?
Yes, I did.
Do you think that based on your analysis, was Mr. O'Keefe thrust backwards? Is that what you determined looking at his head injury?
That he was, I didn't understand, you had your hand in front of your
Sure,
mouth.
I'm sorry.
Yeah.
You talked about a head injury that Mr. O'Keefe had, that
Yes.
he suffered from,
Yes,
that caused his death.
yes.
Was that caused by being thrust backwards?
Yeah, the motion was upwards, down.
Okay. And the way you just showed it could be a fall.
Correct.
Did you have an opinion looking at his wound that he was thrust backwards?
What do you mean thrust?
Well-
His body went backwards. There may have been some applied force to it.
I don't know about thrust. I'm asking if you have an opinion. Your words. Do you have an opinion about thrust?
What do you mean thrust?
Did the forensic pathology diagnosis mean Mr. O'Keefe's body was thrust backward?
If you want to say thrust as indicating movement, that it went backwards, then you could say it was thrust.
Okay, may I approach?
Yes.
I'm showing you page 2 of your report, Dr. LaPosada.
Yes.
I'm just going to ask you to read it, not out loud, and then I can ask you the question after we take it, but I want to
Yes.
take a look.
Yes.
Are you familiar with that?
No, absolutely.
So, Dr. LaPosada, what did you mean when you described that Mr. O'Keefe's body was thrust backward from a standing position?
I mean that he was standing upright and his body had momentum and went down and hit at the back of his head. So it was thrust backwards.
You cannot tell forensically how much momentum he had, can you?
No, we don't do those analysis.
And you can't tell if anything caused that momentum based on the head injury, can you?
What do you mean causative? It was caused by his body went backwards.
Yes. And so the amount of force causing him to go backwards, that's not something you can determine from the head wound, is it?
No, I can't tell you the amount of force. It was significant because he had the massive skull fractures.
Did you say it would be significant?
Yes, significant force.
In modern medicine, there are a number of different machines that can help us see the brain, like a CAT scan, perhaps,
Sure.
MRIs.
Yes.
Would you agree with modern medicine that the use of MRIs and CAT scans and other tools give a clinician equal, if not better, opportunity to examine the brain as actually cutting it and holding it in your hand?
No, the actual gold standard is the pathology, to be able to have the brain in your hand, look at it with your naked eye. And we have conferences in the hospital where we meet with radiologists and say what we find at autopsy and see if their radiology was correct.
Can CAT scans and MRIs show contusions on the brain?
Well, they might.
Subdermal hemorrhages?
Subdural hemorrhages. Yes, they can.
Herniations?
They can.
Do you have any doubt about the modern medicine and the use of MRIs and CAT scans? Do you think they're inadequate in any way?
Well, I'm not a clinician, so I don't use those to diagnose diseases in living patients.
Dr. LaPosada, have you ever had any experience studying the brain in real time, clinically, going and opening somebody's skull and treating the injury before the person dies?
No, I'm not a neurosurgeon.
You don't have any neurological expertise, do you?
I'm not a neurologist. I'm not a neurosurgeon. I'm a forensic pathologist.
Do you have any clinical experience at all where there's an acute head injury and you're making an effort to observe it and analyze the injury as it progresses in an attempt to save the person's life?
I don't treat or diagnose living patients.
I understand, but as far as your background, have you ever had any experience, clinical experience, showing the progress of an actual brain injury and trying to treat it?
I understand the physiology of what happens to the brain when it is impacted by something, whether it be a bullet, a boulder, a fall. So I know what happens to the body to cause the changes from that trauma. I don't treat people for those injuries.
In observing a brain that's in trauma and making determinations of how long it's viable or whether the person will expire, do you know the process that a neurosurgeon would go through in order to fight to preserve the person or save the person? Do you know the step-by-step process that they would undertake?
To do what?
To try to operate or save somebody from a head injury, from a brain injury.
I'm going to allow it because of prior testimony.
Well, it depends on what the brain injury is. If you have head injury and you have bleeding on the brain that's pushing the brain one way or the other, it would be a subdural. Then a neurosurgeon would come in and try to take that blood away so it doesn't compress the brain. So that's something that neurosurgeons do to treat head trauma. They can also put in drains into the ventricle of the brain, and that can relieve pressure in the brain because that brain swelling is a bad thing. So those are some of the things neurosurgeons do to treat brain injuries.
And can they remove part of the skull to relieve pressure?
Oh, yes, they can do that. It's called a craniotomy. They can take out part of the skull if they need to.
So there are a number of different steps that a neurosurgeon can take when someone suffers acute brain trauma to try to save the person, isn't there?
Well, the job of any doctor is to try to save a human life if you treat living patients. So certainly a neurosurgeon would evaluate the patient and decide if there's any treatment needed that could improve the patient.
When you've had cases in the past as a medical examiner where there have been issues regarding brain injury, wouldn't you agree that you have sought outside consultation with people who have a higher degree of specialty in brain injury than you?
Sometimes what we do is when we're examining the brain, we can call in for a conference and have a neuropathologist come in and review the brain with us.
And back when you were a medical examiner, you did that on a number of occasions, didn't you?
Yes, that's routine.
The reason why is because there are different specialties in medicine, and some are different and separate than your specialty, correct?
Of course.
And a neurosurgeon or a brain surgeon, it would be a different specialty than yours.
Yes.
And they're focused on the brain, yes?
A neurosurgeon does brain surgery.
And so, how many times in your career do you think that you've assisted the help of neurosurgeons to take a look at brain study to help you?
I've never needed to speak with a neurosurgeon to look at a brain. Sometimes we call in neuropathologists, and we have a forensic neuropathology conference where we look at brains with the interns and residents.
How often would you call a neuropathologist?
Maybe once a month we would have a routine conference.
And again, the neuropathologist that's dealing with a person's brain after they're already died.
Correct.
So it's not a clinical setting or a clinical experience of actually watching the brain at work and seeing the injury as it progresses.
We don't do neuropathology like that on living people. The person is deceased.
You had an opinion to the jury today, and you said that you believe that Mr. O'Keefe died within 15 minutes?
Yes, I think that process would start within 15 or 20 minutes.
Is that to a reasonable degree of medical certainty, that opinion?
Yes, based on the severity of the injury and the brain swelling.
You're aware that there are numerous level 1 trauma centers around the country that deal with brain injury, right?
Sure.
And the idea is that people suffer all types of brain injury, and if they are given medical attention in a reasonable amount of time, there's a chance they can be saved, yes?
Well, it's possible, but many are so severe that they cause death no matter how fast they can get medical attention.
In fact, every day when people get the right attention or proper attention, they're brought to level 1 trauma centers around this country to try to help them or save them. Isn't that fair to say?
I would hope so.
Do you think?
Sure.
When you looked at Mr. O'Keefe's brain, obviously it's after he already expired, correct?
Obviously, yes.
And so you didn't have any clinical observation of the progress of his injury that night, did you?
I was not observing him. I did not observe how he got his injury.
When you gave an estimate or you give an opinion about how long he was alive for, are you aware that there's certain tests that are done by neurosurgeons when people are suffering brain injuries but there's an attempt to save them?
Sure.
Have you ever heard of a Guzman coma score?
Glasgow, you mean?
You know, with his Glasgow, but you've heard of Guzman?
It's called Glasgow coma score.
Have you ever seen the assessment that a level 1 trauma center goes through when they're trying to save somebody with a brain injury?
I'm generally familiar with the emergency procedures to save somebody's life.
Have you ever read any statistical studies attempting to correlate the brain injury with the time somebody would live for?
I am aware of that, and I see that in my practice of people who have survived brain injuries and die of something else. Then I can look at the brain and understand how the brain can heal or react to injuries.
And many people who suffer coup contre coup will go into a brain surgeon center, and many of them pass after time, don't they?
Now, every case is different.
Right. Some might live for an hour, hours, weeks, months, or survive the injury. Isn't that fair to say?
It depends on the case.
In this case, you don't have any objective criteria to identify the amount of time Mr. O'Keefe would have lived if he had the appropriate help. Isn't that fair to say?
I don't think it would have been effective because there were massive skull fractures to the base of the skull, and there are cases where the amount of force and energy applied to the head, causing skull fractures, breaking the neurons, causing the brain swelling, despite rapid medical treatment, those people cannot be saved. They can't effectively stop the brain swelling.
Many people can't be saved. Did you know that about 1/3 of them do get saved?
I don't know what you're talking about. 1/3 of everybody has different sorts of injuries. 1/3 of what?
With a clivus fracture, coup contre coup. Are you aware that 1/3 of those patients survive if they get the proper treatment?
It depends on the amount of force.
Okay. Are you aware that a study would show. Have you ever read a study by Isaac Wolf on Clivus fractures?
No.
Have you read any studies on Clivus fractures?
Clivus fractures? Yes, I understand what Clivus fractures are. It's a part of the base of the skull.
Okay.
And
And
it
have
depe-
you,
Oops. Okay, go ahead.
please, did you want to say?
No, you go ahead.
Oh, I'm sorry. Have you read any studies that tell you with the proper treatment, despite these potentially catastrophic injuries, that 1/3 of patients can survive?
No, but that's not the case we have here.
And so in this case, I asked if you had any objective criteria. You don't have any objective criteria about the progress of Mr. O'Keefe's wound that can be a basis for you to conclude that he would have died in 15 minutes. Isn't that fair to say?
No, I understand what happens to the brain when it gets that sort of injury. I understand the time course and the physiology. I've seen hundreds of individuals who've had brain injuries. Some survive for a longer period, some die earlier, and it depends on the amount of force and the amount of brain swelling. And in Mr. O'Keefe's case, we had the massive skull fractures of the base of the brain and immediate swelling and subarachnoid and subdural. So he had a large force applied to his head, which caused the brain swelling and the and the progression of the brain stem down through the foramen magnum that stopped the brain. It was a very forceful impact.
You examined his brain after you looked at photographs. You can't tell us objectively when his brain swell started.
It started immediately after impact.
And you can tell us what the progress of that brain swell was by looking at his post-mortem photos.
By looking at the postmortem photos and the postmortem examination, I can tell the degree of force from the extensive skull fractures that were present.
What was the degree of force?
It was medium to large.
Well, that's a wide range. What do you mean? Quantify medium
So I'll
to
strike
large,
the comment,
please.
ask the question, Mr. Brown.
What does medium to large mean?
Enough to cause a lot of fractures to the skull. He didn't just like sit down and lie down.
If he sat down and lied down, he probably wouldn't have fractured his skull, correct?
That's obvious, yes.
Right. And so when you're telling us you can identify that he immediately died or died within 15 minutes, I'm asking you for objective criteria. For you to give that opinion, I'm asking you what objective information you have. And so you said that there was a large amount of force, correct?
Sure, but because there were massive skull fractures and there's a lot of energy transmitted to the brain, starts swelling immediately
How do you know this wasn't medium force and not large force?
because of the extensive number of skull fractures.
So are you saying it was medium or large force?
Medium to large.
Okay. How much force is that? Can you quantify it?
No.
What other objective criteria do you have to support your opinion that Mr. O'Keefe died within 15 minutes?
My training and experience of seeing thousands of deceased people from head injuries and knowing some of their clinical course when they get immediate medical treatment, they don't survive.
But you would agree many do.
Depends on the case.
Right. And in this case, you didn't have any opportunity to observe the progress of Mr. O'Keefe's injury that night, correct?
I'm going to allow that.
I wasn't there. The body told me what happened to it.
You have no assessment of the development of his brain injury and how much time it took that night, do you?
I do, from understanding the significant skull fractures and the swelling of the brain and the compression of the brainstem that all happened very rapidly because of the amount of force that caused all those skull fractures on the base of the skull that actually then hemorrhaged into his upper eyelids. That's a large amount of force.
Was gross edema found on his brain?
I think it was swollen, yes.
But was that a finding?
Yes.
Where did you see that finding?
Well, in order to have the herniation of the brainstem, the brain swells.
Where did you see that finding?
I can't answer that. I just know it from understanding, looking at the pathology.
So at the end result, at some point, Mr. O'Keefe had gross edema.
In order to get the brain stem hemorrhages, the only way you get that is because the brain has swelled, and there's no, after injury, tissue swells, and there's no place for the brain to go when it swells, except down into the natural hole in the bottom of the skull where the spinal cord goes down. So that's where the pressure goes. So that seeing the brainstem herniation tells you that the brain has swollen a lot.
Undoubtedly, but it doesn't tell you when it began to swell or the progress of that swell, does it?
I don't know what you mean.
You see inevitably because of the swelling, there's the suffocation, but when you see that, you don't know when the swelling began or how quickly it progressed. You can't tell that from an autopsy.
Yes, you can, because of the severity of the skull fractures. I know there was a lot of force, and that force applied causes you to go unconscious, then your brain swells. If there was just like one skull fracture, then that's a little bit different. But this was massive skull fractures on the base of the skull. So there's a lot of force applied. So I know because there's a lot of force applied to cause the skull fractures, that the brain would swell rapidly.
You would be unable to identify the rapidity of the swelling if you don't know the amount of force. Isn't that fair to say?
Well, I do know the amount of force because of the amount of skull fractures.
In what you know is, in your words, medium to large force.
Yes.
You've heard of periorbital ecchymosis?
Yes.
And that's sometimes called raccoon eyes?
Well, periorbital ecchymosis just means bleeding and bruising around the eyes.
And you saw the bruising around Mr. O'Keefe's eyes, didn't you, in the photographs?
Well, it wasn't bruising caused by blunt force trauma to the eye. It was bleeding in the upper eyelid because the plates above the eye and the base of the skull were fractured by the brain hitting it. So, and that's a result of basilar skull fractures and not the application of force directly to the eye.
Would you agree it takes a few hours for the bleeding to accumulate in the person's eyes?
No, as soon as you break the skull bones and the heart's pumping, the blood comes out of those injuries.
So
it starts to accumulate right away. It starts within minutes, you can see it.
So you would disagree with the suggestion that it takes at least 1 to 2 hours for that bleeding to occur in the eyes. You disagree with that?
I do disagree with that. It starts immediately.
Do you have any studies that you've relied on or literature or support for that?
I understand the physiology of what happens when you get those skull fractures and the density of the blood vessels. And if your heart is pumping, you pump the blood out those broken blood vessels into this small area above the eye. And it can happen within minutes.
Do you have any studies or literature to support that?
It's my training experience. I can't cite you a particular article at this time. I could certainly go look it up and bring it to you.
Okay. Let me ask you questions about the wounds to the back of Mr. O'Keefe's head.
Yes.
You see a linear abrasion?
Yes, the vertical lines, yes.
Now, would you characterize this as a classic wound caused by falling backwards and landing on your head?
What do you mean every wound is different?
Every wound is different?
Sure, every person's different, every way you get injured is different.
And so if somebody falls backward on their head and suffers the basal fracture, the wound from your perspective can look different.
It depends on the impacting surface.
Wounds on the same surface, say 2 people fell on the same surface, could they have different wounds on the back of the head if they suffered the same injury?
In theory, if they rotated their body, if you could reproduce something exactly, then you would see the same wound patterns.
this wound pattern is typical of falling backwards on a hard surface, isn't it?
We know it's from falling backwards and striking something hard.
Can the frozen ground be hard?
A frozen ground can be hard, but it doesn't fit the pattern in this injury.
We'll get to that, but is it
Oh, okay.
hard enough to cause a basal fracture?
It can cause a skull fracture.
The frozen ground is different than a sheet of ice, right? It's not smooth and flat like a sheet of ice, is it?
It could be, I guess.
Okay. You mentioned there's some granular patterns in this wound.
Yes.
didn't you?
Yes.
The area in front of 34 Fairview, the frozen ground, do you know if there was any impediments in the lawn that was frozen?
In the what? Oh, the lawn?
Yeah, yeah, sorry.
Yes, I saw the scene photographs of when the snow was removed, and it was like winter lawn grass. So it was some green, some brown that was pushed down, and like straw that was going different directions, which wouldn't give you that pattern.
Did you see the exact area where Mr. O'Keefe last moved?
I saw that general area, and there were a lot of photographs,
Well,
yes.
You say general area. Can you tell us that you saw photographs of the spot where Mr. O'Keefe was lying when he was found?
Yes, that general area.
Could you see the ground where his head was? Can you identify that?
Yes, with the scene investigation, they shoveled the snow off of that area.
And you had never had a chance to go out to that scene yourself, did you?
No, I just looked at all the photographs.
You cannot see what's under the grass and the dirt, can you?
Well, dirt's under the grass.
Well, do you know if there's any rocks or impediments or bumps?
It was a smooth surface covered with grass.
It was a smooth the front lawn was a
It
smooth
was
surface?
a flat surface
Flat.
covered with grass.
Okay, and do you know what was under the grass, whether there was any pebbles, rocks, debris
I didn't see any.
from the photo?
Correct.
But you don't have any firsthand knowledge that exact area where he ended, what the turf was like, do you?
I saw photographs of that lawn where they removed his body from.
So you're relying solely on the photographs, is that fair to say?
Correct.
Do you know if Mr. O'Keefe was wearing anything that could cause abrasions when he landed to cause that scraping pattern in addition to the linear abrasion?
He did have a baseball hat on, but that would not cause that pattern.
The area of the abrasions, is that in the area of the level of where a baseball hat would be on the back of somebody's head?
It could be.
Could be. If somebody hits the ground and falls backwards, can they slide?
If they're on an incline,
What if they're thrust?
well, if you fall backwards and you fall backwards on an incline, your body might move.
Well, what if you fall backwards on flat ground? Does the body, can it move after it falls?
Not really, maybe a little. If from the momentum of the impact, it might move slightly, but not really.
So when a person falls backwards and lands, you don't think their head has any room for movement?
Not significant.
Well, not significantly, maybe just a quarter inch, half inch.
No, it's possible.
Okay. And did you see the scrapes around the wound of Mr. O'Keefe's head?
Of course I saw them, yes.
Okay. And they're all within, what, about an inch?
What are you describing? What part? Are you describing the tearing, the laceration of the scalp, or the vertical abrasions?
The vertical abrasions.
There were maybe an inch and a half.
Inch and a half? Do you think that if someone fell backwards and landed on their head, they could move an inch and a half?
Well, he landed on something that had a ridge on it to cause the laceration in the scalp. And then with a little bit of movement, those vertical scratches were caused by some kind of like pebbly-like surface.
You mentioned that the orbital bones were broken and you had opined that it was caused by the brain. Do you agree that a brain is very soft, consistent with, for example, tofu?
Oh, gross. What do you mean? It is soft.
Is it that soft? Is that the texture of
Well,
it?
it depends on what kind of tofu you have.
Okay. Do you think that the orbital could have broken when the break on the back of the head split the skull and then would cause the orbital break instead of the brain?
The orbital plate fractures, if you look at the base of the skull after you take the brain out, you can see the fractures go up from the back to the front into the orbital plate. Sometimes when you fall backwards, the brain can also slap those orbital plates and cause some damage, but I could trace the fractures from the point of impact along the base of the skull to the part of the skull over the eyes.
Do you think the base of the skull break, when it separates, could have caused those orbital fractures?
I don't understand your question.
Okay. When Mr. O'Keefe incurred that head injury,
Yes.
the basal fracture, do you think that the pressure, the damage from that basal fracture, the separation, could have caused the orbital breaks in his eyes?
Well, the fracture of the plates above the eye, when the blood is still pumping, there's a space there where the blood can come down into the upper eyelid.
So you described the brain as causing that break. I'm asking you, could it have been from the basal fracture, from the skull fracture?
Yes, the fracture that was caused by the impact to the back of the head, radiating to the front of the base of the skull.
So when you told us on direct it was from the brain that caused those fractures, was that just a summary, or is that to a reasonable degree of medical certainty?
Well, sometimes the brain can also, in a fall, flap and hit those, but in this case, I could also see that the skull fracture started at the back and came to the front, but it could also be contributed to by the brain hitting those delicate bones.
I guess my question is, when you've provided the opinions generally of what you believe and what you've seen, are these general opinions, or are they actually specific opinions based on the facts of this case?
They are opinions based on my examination of this case, but all that's based on my 40 years of training and experience.
Well, when you told us about the brain causing those orbital fractures, you would agree with me, at least now anyways, that it very likely could have been the basal fracture that caused those breaks.
They're both.
It could have been both?
Sure,
Okay, could it have been just the basal fracture?
that's possible.
When you offered the opinion to a reasonable degree of medical certainty, had you considered the basal fracture as the source of those breaks?
Of course.
Is there a reason you didn't share that with us and you just said it was the brain?
I had no reason not to share it.
Okay. Was there any depressed fracture to Mr. O'Keefe's skull?
No.
Can you tell us a little bit about a depressed fracture? Depressed fracture is different than what we saw with Mr. O'Keefe, isn't it?
A depressed fracture is when something fractures the skull and then pushes the skull and moves the skull inward. This just had a fracture, but it didn't move the skull inward.
And you've seen depressed fractures in your practice over 40 years, did you say?
Of course.
In those 40 years, depressed fractures can happen from sharp objects,
Sure.
pointed objects.
Sure.
If someone hit a person in the back of the head with enough force, with like a hammer, for example, that could leave a depressed skull fracture, couldn't it?
Certainly. You can hit somebody on the head with a hammer and cause the fracture, and then the continued force will move that fracture into the brain.
There was no depressed skull fracture in this case, was there?
Correct.
You gave some opinions today about you gave some opinions about wounds on Mr. O'Keefe's arm. I'd like to talk to you a little bit about that.
Sure.
Could we have that photo brought up, please? Do you see all of those superficial abrasions?
Yes, I see patterned injuries.
Right. Would you agree that they're superficial abrasions?
Yes, they go along the skin surface.
How many punctures would you identify in that photograph?
Let's see, there may be some punctures like around the elbow, consistent with the teeth puncturing. Most of them are the teeth scraping along the skin.
I'm not going to ask you what you believe the cause was. I'm going to ask you just about the wound. How many punctures do you see?
Well, this doesn't show, there are other photographs which show more of them, but there's the little dot-like areas, you could call an area of skin puncture.
Can you tell us from this photograph how many punctures you would say are in that photo?
I didn't count them.
Well, did you suggest that there was more than one puncture on that wound?
I think I see more than one, yes.
Pardon me?
I see more than one on there.
Okay, could you give us a count of how many punctures you see?
Well, without looking at all the photos, I couldn't give you a correct number.
Okay. You've written a report, haven't you?
I what?
You wrote a report?
I did.
And in your report, you describe many of those abrasions as punctures, don't you?
Yes.
And a puncture isn't just a scratch. A puncture is a penetration of the skin, isn't it?
Yeah, a point-like penetration.
A puncture has a very specific medical meaning, doesn't it?
Yes, it's a point-like penetration of the skin.
And according to you, there are many punctures in that wound.
Yes, I can see 1, 2, 3, 4, 6 or 7.
Can medical professionals disagree on opinions about wounds and causes?
I suppose they can.
You also gave some opinions that you did not believe that Mr. O'Keefe's scratches were caused by having some impact with broken pieces of plastic or glass, correct?
Correct. They weren't caused by that.
Broken plastic or glass can cause a number of different angled wounds, can it?
It causes an array of irregular, random injuries.
It can have infinite different patterns, couldn't it?
Could.
There's nothing to hold a wound from a broken shard to be north or south or east and west. It all depends on how the force is impacted on the body, true?
I'm not quite clear on your
Okay,
question.
I'll try to do better. When you're talking about shards of broken glass or broken plastic, there is no set direction that they may cut somebody, is there?
Well, it would depend on the case and how those occurred.
They can happen in many different forms as far as depth, yes?
Well, anything's possible.
How about length?
What about length?
Wouldn't that change? Couldn't that change depending on how the injury occurred, the length of the wound?
Sure.
And in this case, you talked about your opinions of injury relative to a motor vehicle, didn't you?
That was something I considered.
That's something you considered. Did you know much about the details of the motor vehicle in this case?
Yes.
Okay. When you considered your differential diagnosis, did you consider whether there was any DNA on the vehicle?
I didn't look at any of that.
I'm sorry?
I did not look at any DNA.
Did you know if there was any hair on the vehicle?
I don't know.
Did you consider the scene itself where there may have been a debris field? Did you take a look at the debris field in this case?
I know there were photographs of various pieces of plastic around the area where the body was found.
And do you remember where those pieces were found?
Somewhat, yes.
Did you have an opportunity to consider other evidence like a shoe in the area near where Mr. O'Keefe was found?
I know one shoe was on his foot at the hospital, the other was at the scene.
Do you know if his hat stayed with him after he landed on the ground?
The hat was in the area where his body was found.
Did you take a look at his pants, the back of his pants?
I looked at that, yes.
Okay, what did you see when you saw the back of his pants?
Well, because he had bled from the back of his injury and he was on a hospital gurney, some of that blood came down, so some of the blood was on the back of his pants.
Did you see anything else other than blood on the back of his pants?
I don't remember.
I'm sorry?
I don't remember if I saw anything else.
Did you look, when you were doing your differential diagnosis, did you look at any evidence other than physical evidence? Did you look at any data evidence?
I don't know what you mean, data.
Like data you would find on a cell phone?
No.
Did you look at any of the data evidence from the defendant's Lexus?
No, other than looking at the contours of the back to see if it had impacted Mr. O'Keefe.
When you were doing differential diagnosis, did you look at any information that would tell you what the speed of that impact may have been or allegedly was?
Well, it didn't hit him, so it doesn't matter.
Okay. So you didn't care to know anything about the car or the data in the car because you had already formed your opinion?
It did not hit him, so it was not relevant to my opinion.
Is that a different way?
By looking at the body, I could tell that there was no evidence of impact with a vehicle. So whether the vehicle was going slow or fast is not relevant.
And so you didn't try to get any information about the speed of the vehicle? It was totally irrelevant to you?
Correct.
And did you also disregard, well, let me ask you, do you ever look at statements?
I look at witness statements if they're available to me.
Were any of the defendants' statements made available to you?
I did hear some of them.
Did you consider the ones that you heard?
Of course.
Which ones did you hear?
I really can't answer that. I don't know what you'd have to give me an example.
You said that when Mr. O'Keefe first incurred his injury, you think that he was unconscious?
Yes, I think that the severity of the impact made him immediately unconscious.
So if hypothetically Mr. O'Keefe incurred his injury sometime around 12:32, is it your opinion that he never moved again until he was moved physically by somebody else?
Well, I don't know the exact time that he got the injury on the back of the head, but after that time, he could not carry out any purposeful activity.
May I approach sidebar, Your Honor?
Okay.
I just want to say real quick, Kevin, her attitude shift is a gift. It's an absolute gift to Hank. Like we were all surmising, how's he going to approach her? She's wheezing, the optics, she looks so frail and weak. As soon as she did that 180 and became snarky, she handed Hank an easier deal. Right?
Yeah.
And she's not as sympathetic anymore. That was great.
Yeah, she corrected him right out of the gate on it's not afternoon for 6 minutes. I'm like, wow.
Oh,
Yep.
That wasn't good. I bet the defense cringed.
If she kept up the wheezing and just appeared more frail, it would have been Hank would have gotten there, but it would have been a lot harder.
I know.
Margaret, do you think Hank has decided to there are a lot of things in this doctor's background that they could go after. There are some questionable things there. Has he decided strategically just it's best to leave that stuff alone? Or is he going to still go into it possibly?
He could possibly still go into it. We'll see how he wraps up, but he's not finished yet. I think he's made some great points on cross-examination. Like did she pay attention to witness statements? Well, she wasn't hit by a car. And it looks like she didn't. I mean, and it looks like she formed an opinion back in the very beginning when Alan Jackson hired her, right? Yeah, she has confirmation bias, and yeah, her attitude is not good. But I think he's doing a wonderful job. He seems very calm, and I think he's doing a wonderful job so far.
Will the jury remember Dr. Wolf, the neurosurgeon, since it was 6 weeks ago? Because he's obviously smart, even though she comes across as pretty competent, effective, and knowledgeable. But next
She's
to him,
not a neurosurgeon.
yeah, and Hank did a good job pointing out that she's never treated a patient. So how could she possibly know how long someone would live, with that injury? And it's very different than what Dr. Wolf had said. And he does deal with these patients and surgery on them every day and trying to keep them alive. Her testimony that was very specific that this person would die within 15 or 20 minutes, and she was very sure of that. That almost doesn't seem medical.
It's because they need that from her. He needs to be.
Kate, are they going after this? Kate, are they going after the second degree? People pointed that out in chat. Is that the purpose of this?
I think they are trying to knock that off if they can. I think they are trying to knock that off, diminish as much responsibility as they can. So, he would have died within 15 minutes. Nothing she could have done. Right. That's part of it. Part of it is they don't want him, to be able to move after he gets the injury, because they want to draw that 30-second difference between when they want to portray the impact happened and when he stopped moving, which is ludicrous.
Right.
And
I don't remember if Dr. Wolf was 6 weeks or 5 weeks ago. It just feels like a long time ago. Obviously, a lot's happened to me in that time span, but I'm sorry if I'm off by a week on this, but
so
I'm sorry.
Kyle Gibson points out medium to large force. That was a good takeaway as well. Like, how clinical is that? Well, what kind of force? Medium to large. Well, medium to large, or large-ish. Like, come on.
Can you put a number on it?
Yeah, exactly.
Can you put some type of scientific or physics number on that?
Right, but she impresses that it takes a pretty large force to create that level of injuries on the head after they've seen Rescue Randy get smoked by the SUV. So,
right.
And don't forget, in the closing arguments, Hank will bring Dr. Wolf back into it in a big way. He'll remind the jury.
It looks like they're going to go into lunch now, because this feed is a few seconds behind, and they'll go into ceiling fan, so they're going to dismiss the jury now. They may have some business to discuss here, though, in the court, because there's new motions in, and a lot of these motions have to be decided right away, right, Kate? You think?
Yeah.
I think it's kind of flabbergasting that this doctor could be so specific and say that John would have died within 15 or 20 minutes. And it's worth pointing out that Dr. Sheridan for the defense didn't say that last year. No other medical expert has said this year. Is she that uniquely qualified?
She's a mercenary. I mean,
yeah. So they are going to do some business during the lunch, at least the start of it.
So I was digging through my.
All right, so jurors, rather than keep you here while
You're right.
I'm going to excuse you for lunch. Lunch will be about 50 minutes or an hour, and when you come back, we will go straight through the afternoon. We're going to do everything we need to do now. Jurors, thank you very much.
Jurors, please follow me. Close your notebook, please.
Okay, thank you.
Judge Cannoni looks a little tired and stressed.
God.
Oh yeah, she does today. Definitely.
So I was digging through my old screen recordings there, Kevin, and maybe you'll remember this. Maybe Kate, Margaret. I don't know if you've seen this. It's quite the treasure. Back when they were saying, "Oh man, no way could a human break a taillight." I have a free Karen Reed scientist slapping meat onto a taillight housing attached to an aluminum shelving in someone's garage.
All right. So, Mr. Brennan, if you can briefly tell me what it is you want to introduce through this witness.
To remind the court, on direct examination, the defense promoted Dr. Lapasada's credentials, including specifying her successes with the station nightclub fire and her running of her office. We have an audit from 2005, State Department of Rhode Island, Department of Health. In that audit, it paints a very different picture than was presented on direct examination. In that audit, they investigated the chief medical examiner, and they compiled the history of statistics for the medical examiner, which was Dr. Lapasada. There were no reports, incomplete reports, and unsigned reports of over 1,500 individuals between June 30th, 2000 to June 30th, 2005. So in that 5-year period, there was an extraordinary number of individuals that weren't properly attended to, showing negligence, if not malfeasance. It was recommended that the standards, policies, and practices of Dr. Lapasada's office would need to change because of the extraordinary backlog of cases regarding autopsies. In addition, it was noted that the incomplete reports confirmed that there was significant concerns with the historical management practices of the medical examiner's office shortly after Dr. Lapasada resigned. In addition, it was promoted that in the station nightclub fire, Dr. Lapasada had a heroic effort, and in her testimony, she also noted that there was a failure, or implied there was a failure because the medical examiner or somebody did not go to the scene to look at the turf in front of 34 Fairview Road. She suffered the same criticism for hours and hours after the station nightclub incident. She was contacted with a request to come to the scene. She refused to come to the scene, did not appear for at least 17 hours. Directly on point to the claims that she's making against other people is the same conduct she engaged in on a more extreme scale. She testified in Commonwealth versus Tompkins. In Commonwealth versus Tompkins, she was listed and testified as an expert, attempted to testify as an accident reconstructionist, which was denied. Inevitably, the court made conclusions. Actually, in that case, her efforts to be an accident reconstructionist were denied. Then she testified in a case called Patino. And in Patino, after testifying, she received great scrutiny and criticism from the court. The court noted on page 1025 of the transcript, when Dr. Lapasada gave the testimony, she knew the boy wasn't like this because he fell off a bed. She knew the mother was lying. She read the text messages and knew the defendant had beat the boy. The only reason I conclude that she offered such testimony was to distance the defendant from causing those bruises, setting up an argument against malice, but instead destroyed her credibility. On cross-examination, she came across as a hired gun. Sometimes it's seemingly small things that impeach a witness's credibility. Inevitably, on the credibility determination by the court would agree. The jury gave greater weight to the testimony of Dr. Gilson and Snelling than they did Dr. Lapasada for the reasons I addressed previously. The jury was justified in discounting her testimony and concluding the other doctors testified apparently impartial. While she appeared as a paid advocate, at least on this occasion, without impugning the witness's integrity, because that witness is known to the court, but in this case, when she testified, she was not credible. That's a direct credibility determination by another tribunal about her testimony. So I would like to, and that's why I came sidebar rather than ambush, to give the court notice that I'd like to get into the criticisms regarding her run as medical director that led to resignment after she was audited and left 1,500 bodies unattended or incomplete. Also get into the criticism she received for her handling or lack of handling of the station nightclub fire, and finally get into the credibility, adverse credibility determination in the Patino case.
So I'm not familiar with the Patino case. So I'll need a copy of that.
Yes.
All right, Mr. Jackson, I'll hear you.
Thank you, Your Honor. First of all, Mr. Brennan said that the audit established that, as the chief medical examiner, the audit revealed that she left 1,500 bodies unattended, was his quote. Bodies unattended. That's absolutely not what happened in that situation. It was a political situation. The medical director for Rhode Island came in and took over. He began to change protocols and cut quality control. He said he did not want a second set of eyes on any of the reports, not the autopsies. There was never a suggestion, ever, that an autopsy was not performed efficiently and timely. Never. The reports that were attendant to the autopsies it was a two-tiered set of criteria that Dr. LaPosada put in place to establish quality control and quality assurance. First, the medical examiner conducts the autopsy and writes a report. Then the doctor herself, the chief medical examiner, because she is a perfectionist, determined that she was going to establish a protocol in which she would put eyes on every single report. Hundreds and hundreds of reports per year. In doing so, she had to prioritize which reports were going to take a priority, which ones were being subject to litigation, which ones were going to be subject to criminal cases, and which ones were never going to be subject to any review at all. For instance, if somebody was found, let's say somebody that was without family, etc., found and unidentified, there's no litigation attendant to that report, she would put that report aside and get to that report after she dealt with the reports that were on sort of on the front burner, if you will. After, by the way, none of the reports were ever not done. They were all completed. There were a small fraction of reports, according to the audit and according to Dr. LaPosada herself, that had to take a back seat. When the medical director came in 2005, by the way, this is 25 years ago, right? These are autopsies that were performed, and the audit was performed for autopsies and reports dealing with the year 2000. It's 2025. This is 25 years ago. When the new medical director came in for Rhode Island, he said, I don't want any review of any of the reports because it's more efficient and it's faster to get the reports out in a timely fashion. She resisted and said, I will never, ever, and she was published saying this, I will never, ever sacrifice quality for speed. I want the highest quality coming out of this office. They had a difference of opinion. She walked away because he was asking her, the new medical director was asking her to sacrifice quality of the conduct that she was undertaking as the chief medical examiner for the state of Rhode Island. So it's a very different circumstance than was just suggested. No bodies were ever left unattended, ever. Certainly did not involve the other phrase that was just used is negligence and malfeasance. It was a backlog, and they had a very public political fight over it. Number two, with regard to the Station nightclub fire, her staff was on location immediately. She, as the chief medical examiner, was there the same day. So that's of no legal moment. It's of no consequence. It certainly has nothing to do with her opinions and conclusions in this case. The Tompkins case, we've already talked about that in voir dire, Your Honor. The Tompkins case dealt with an issue dealing with accident reconstruction, which she's not undertaking. I'm not asking her, and she ain't saying.
I've excluded that part of it, based partially on the Tompkins case.
Right, and I don't know anything about the Patino case, and what I would say is, given the fact, look, we don't know what the facts of that case were. We don't know what the trial was about. We don't know what the cross-examination was about. We don't know why she was called. We don't know what she looked at. We don't know why she was looking at what she did look at. We don't know why she didn't look at things that she might not have looked at. We don't know why her opinions and conclusions were ultimately rendered. We would have to have a trial within a trial, which I would be happy to undertake if someone gives me a file. Happy to do that. But I don't think we want to do that. I don't think the court wants to do that. Also, I will say, I don't think that attacking this witness's credibility is in good faith by the Commonwealth. Mr. Brennan himself has hired Dr. LaPosada personally no fewer than 4 or 5 times. Maybe it's 3 or 4 times. He knows her qualifications. He knows the quality of her work. He's actually undertaken to consult with her as a medical examiner and a consultant. So I don't believe that these last 2 issues are in good faith. I don't believe the station fire has anything to do with anything because she was late, according to Mr. Brennan, in coming to the actual location. She was there the same day, and she had an entire staff that was there immediately. And in terms of the audit, it's a 25-year-old political fight that isn't quite what Mr. Brennan made it out to be. So I don't think any of these things are relevant for cross-examination. I'll submit.
All right.
I just want to make a note that Attorney Jackson has a way with words to just inflate or make things up. I have not hired Dr. Laposada 4 or 5 times. And so that is just a mischaracterization which he likes to do for the public. But the reality is, I've used her a few times, and the last time I used her, I'm not going to disclose why I don't use her anymore because it would be unfair without her in the room. But the suggestion that somehow I'm endorsing the qualifications of this witness, I am not. That's what I'm going to say on the record.
Okay. So the first two, the backlog issue, if we can call it that, with the ME's office, I'm going to allow the Commonwealth to get into that through questioning. Same with the station nightclub fire, based on the testimony already in evidence. Those two areas, and Mr. Jackson, without leading, you can certainly go back and rehabilitate her. But those two will come in. I'm not going to do anything with Tompkins because I used it for the basis of keeping out what appeared to me to be biomechanical engineering opinions of this witness, and she's not qualified to do that. So I have not read Patino. I will read it over the lunch break and see if we get anywhere with that. Okay, so I need a copy of that. I want you to give Mr. Jackson a copy as well. Okay? Okay, so, all right.
The only other thing, I don't know if you want to handle it now or after lunch or later, that I want to address the issue of the three.
Okay, so let's mark those now.
Sure.
Can we mark them all as one, A, B, C?
I have no preference one way or the other. It's just three. They're all.
Mr. Jackson, if you can I just read everything?
Of course.
I just want to say on a personal note that it's been great to meet all of you guys and to work with you and get to know you personally. But none of this would have happened for me were it not for the station fire in Rhode Island. I wouldn't be here. I would have never launched a YouTube channel. I would still own a bar. The only reason I'm here is because of a chain of events that was begun by the station fire, in which I forget, but over 100 people tragically died. I won't go into the story about it, but were it not for that incident, just all the strange connections in this case, I wouldn't have got to know you guys. So
Show me that one again.
That's wild.
yeah. So I do think it's fair if she was the chief medical examiner for the state and she had her staff there, that she didn't have to be there personally herself right from the first moment. I think that's fair. And so I guess now we know why Hank hasn't gone after her yet. He wanted to make sure this was approved by the court first.
Absolutely.
It also sounds like her attitude towards him may be related to more than just this case.
Yeah, good point.
Thinking that
Good
myself.
point. Yeah.
Bit of bad blood, maybe.
It sounds like he had some problem with her the last time he used her.
All right.
Yeah, she doesn't like him.
She's a hack.
Mr. Brennan, there's no objection to these coming in through another witness, so you agree that they'll be coming into evidence?
I'll stipulate
All right, and what's the objection to them coming in through Dr. Laposada?
it's not part of her report or opinion. I think she's gone beyond her report, talking about the fact that she's studied x-rays and given an opinion. I think that suffices. I think it's beyond the scope of her testimony to begin with. I'd be gracious with it. Stipulate these, I'm sure Dr. Wentz will utilize them if they're stipulated.
So you'll stipulate to them prior to Dr. Rentschler?
I will.
So you can use them with Dr. Rentschler?
I expected that I could because he certainly used them in his analysis and opinion. But I should be subject to the entry of evidence in the defense case in chief. I understand I can use them in Dr. Rentschler's testimony that I want to use in with Dr. Laposada. She's a medical doctor.
Would you-
Consider them for purposes of her opinion. I cannot understand.
So what do you want to ask her about them?
Are these the x-rays that you reviewed? Yes, that's it. That's
Okay,
it.
okay. So go ahead.
If that's all he's going to ask, I won't have a problem.
Okay, yeah, I have no problem with that in that form.
That's it. Literally, you see the x-rays that we talked about a little bit earlier? Yes. This is the right hand? Yes. That's the arm? Forearm? Yes. That's the upper arm.
All right, so they're cumulative, but if they're coming in anyway, I will let you put them in.
Thank you.
All right, so the last thing is Dr. Rentschler. I need to hear argument from both sides. I have a new PowerPoint, so I'll hear both of you. Mr. Brennan, I'll hear you on your motion.
We've received the most recent update to Dr. Rentschler's PowerPoint. There are some additions, different analysis in that PowerPoint. This is within 24 hours of him testifying. There are opinions on page 6 and 8 of his May 7, 2025 report. And there are a number of numbers that we have objections to. Dr. Rentschler just generally shouldn't be allowed to express opinions and conclusions about what he thinks about the case or about other
All right,
witnesses.
so I'm looking, I think, at the new,
Do you have a copy of the new one?
from today, page 6. So what I have are just photos with measurements, so I don't know what the testimony that corresponds with those. I've read, obviously, the report of Dr. Rentschler from May 7th. That does not seem to detail everything, and that's no criticism. I'm just saying it's a scant report, so I don't know what the opinions are regarding these.
I'm sorry. Yep.
I
Please.
didn't want to speak over Mr. Brennan, I apologize. I just wanted to let the board know we're talking about apples and apples. We went through, based on Mr. Brennan's suggestions last night, and significantly edited the entire thing. Literally every single slide that you had a problem with. There were a couple that we just literally left, but it's very, very.
I see that a lot of the hearsay's been removed.
Okay.
And I can identify this report as helpful.
Thank you.
I'm sorry?
I can identify this report as helpful, the ones that were changed.
All right. But,
It made streamlines.
so what do you both, I'm going to hear from Mr. Brennan first. What are you objecting to as the report now stands?
I have a most recent copy of the report now. So 9 through 27.
Slides 9 through 27 or pages?
Slides 9 through 27 now have Dr. Rentschler identifying and attempting to match different abrasions with different holes in Mr. O'Keefe's sweatshirt. And so basically what he is trying to do is to suggest that there are a different amount of abrasions relative to the amount of holes, or perhaps he might want to testify about that the holes in the sweatshirt were in a different place on Mr. O'Keefe's arms than the abrasions. The reason why this is concerning is because there is no background for him regarding fabrics. This is a different and new opinion that we have not prepared or obtained an expert for. We probably have very little time to get somebody to rebut this analysis regarding fabrics. I don't see anything in his CV or his history that allows him to equate the number of holes in fabric with the number of abrasions on somebody's arm. It does not consider or account that there could be multiple wounds from one hole, or there could be holes that don't create wounds. So whatever the implication is going to be by Dr. Rentschler, we're not very sure, but it obviously would require some type of expertise, which I do not think that Dr. Rentschler has a foundation for. So those are 9 through 27 generally, and then specifically, I can run through quickly the individual objections I have. Slide 6 tries to define the theory of the alleged incident. Doesn't say whose theory it is. It implies it's the government. It's an improper suggestion.
Hold on. Okay, so which one of 1, 2, and 3 on 6?
1 is objectionable. What's the core issue of the case? It's an ultimate issue for the jury. An expert reconstructionist or a biomechanical engineer shouldn't be defining the core issue of the case. And then 3, first event is alleged contact between the rear of the Lexus and Mr. O'Keefe's right arm. Again, that's offering an opinion that doesn't have facts and evidence, not in a position to draw that opinion.
And is 2 okay? Or are you moving to the whole slide?
No, on number 6, all 3 of them shouldn't be there. Asking what the core issue is in the case, Dr. Rentschler or no expert should be defining what the core issues in the case are. They should talk about their training experience, any testing, observations, evaluation, and then give their opinions, not core issue in the case.
All right.
Slide 9 outlines perhaps his process. The first step of the analysis to determine if the arm injuries are consistent with the physical evidence. Evaluate the abrasions and compare the evidence. I suppose this is what he's done. This is one of the less offensive ones, although unnecessary. It doesn't provide an opinion. I could live with that. The next one,
You could live with what?
number 9.
Okay.
Number 23. Again, this gets into that new core opinion about trying to identify or, I think, compare the abrasions to the different wounds. I think the part that's objectionable is the words measurements, question mark. I'm not sure if it's implying failure of somebody else. It seems to be an opinion, and I'm not sure of the context of it. 24. The expert is trying to define what Dr. Welcher had done. It may be that he's saying he conducted his testing based on the position of Dr. Welcher's arm. I think that would be an appropriate comment, but it's not clear what they're saying. The pain transfer test, number 2, is the only test noted with respect to the arm.
So without the text, are you objecting to this
No.
slide?
No.
Okay.
31 posits questions regarding ultimate opinions. I think it's inappropriate. And then 32, I think, is improper because it ultimately endorses or vouches for the witness's credibility. I think he certainly can give an opinion that the evidence is inconsistent with the injuries to Mr. O'Keefe's arm, but I don't think it should be on the slide bolstering his opinion. 33. Again, it's posturing the weight of the evidence. And it's resigning the government to a particular study, one study. It's really a commentary on the government's case. It goes like this. Number 1, Dr. Welcher only did A, and second part, A is insufficient. So that's really what this is saying. It's commentary, it's hearsay, it's inappropriate. 34. I think if one said that that's what he did, I, Dr. Rentschler, took a step to determine the kinematics of Mr. O'Keefe's arm during the alleged incident and asked how would this arm move, I think that would be appropriate. But he shouldn't be giving a opinion on what steps should have been taken by Dr. Welcher. Number 2 on slide 34. And number 3, I don't have a problem with. The next one is 46. Again, this is bolstering the expert's opinion by putting it in writing on a slide. I think some of these opinions are appropriate for Dr. Renshaw to share with the jury, but his final ultimate opinion shouldn't be endorsed on a slide. 47. Again, this is self-endorsement of the success of his tests and giving his opinion about his success. Number 1 and 2, I think, are inappropriate. Number 3 has really no context standing alone. And number 4, if he notes that's his next step, I wouldn't have a problem with number 4. Slide 54. Again, number 1 gets into his opinions. Number 2, he gives an opinion about a different expert, a medical opinion. And number 3, it's, again, self-endorsement on his own opinions. So all these are opinions either bolstering himself or somebody else's work. I don't think it should be in a slide. 55. I think it's accurate. I think it's proper testimony. I don't think it's proper for a slide. Same with 56. I don't know that he has the basis for number 1. Number 2, I don't have a problem with on slide 56. And number 3, again, it's bolstering his opinion. So I think 1 and 3 are improper too. Not. Slide 58. I don't know what the basis for number 1 is. I suppose we'll have to see. If these are Dr. Renshaw's views, I don't know how they're relevant to the Commonwealth's case, but certainly I think he has the experience to make these conclusions, but it shouldn't be in a PowerPoint. He shouldn't be commenting on the reports of another expert in a PowerPoint, number 3. And number 4 is ultimately an opinion that he's self-endorsing. 66. Again, it is an opinion. I don't think it's an admissible opinion, and it shouldn't be in a slide. He's trying to draw a conclusion on what the jury should conclude based on the Commonwealth's evidence. He's not in a position to do that. 67. Parts of this are objectionable. I think that he certainly could testify. He hasn't seen any simulation by Dr. Welcher, but posturing it about in a manner that suggests there should be doubt in some way is inappropriate. 68, I don't think Dr. Welcher's report was introduced. And putting in a fraction of a report, I can't appreciate the significance of it. It's hearsay. Perhaps there's a reason he'll be able to point to the report, or talk about the report, I understand that, but putting in a random page from a report as hearsay should not be admissible. I don't know if there's going to be a conversation about trying to introduce the entire report, but one page will take it out of context. 72. I think the expert has a basis for the opinion. I don't think ultimate opinion should be in PowerPoint because it's self-endorsing. 74, again, it's a conclusory opinion, it's bolstering. Some of these can be said but shouldn't be in PowerPoints. Same thing with 75 and 76. They're ultimate conclusions. And so I'm not in agreement with all of the conclusions that the expert may try to introduce, but testifying about an ultimate opinion and putting it on a board to self-endorse shouldn't be permitted. And those are my objections.
Okay. Ms. Little?
Thank you, Your Honor. First of all, there are, if I stand here only because I'd like to be able to reference the PowerPoint.
Yeah, that's fine.
Thank you, I appreciate that. First of all, there were no additions, just to be clear, to the PowerPoint. The only changes that we made were directly in response to the objections that were filed by the Commonwealth. We did delete a large section, trying to accommodate some of their concerns, as well as shorten some of the opinions. So those were the only changes. I just wanted to be clear before. There are no additional changes that have been set forth in the PowerPoint. With regards to slides 9 through 27, that was not one of the issues that was identified in the Commonwealth's motion. They objected to slide 9. There's half of those slides are not referenced.
I do agree. It's a new objection. I just don't know when there's an objection raised how a biomechanical engineer is qualified to testify to tears and clothing.
So this is a direct test. His testimony is going to be based on his knowledge of forces and forces applied to certain objects and how that results in injuries.
And I understand that, but some of the specifics that he says, I'm just saying I had a concern, so I understand it's new.
I think that we'll be able to satisfy the court's concerns by laying a proper foundation for him.
All right, so we can come back to the fabric argument or whether it's beyond his scope of expertise. But actually, Ms. Little, if I can just ask you, and I can hear you later, as I assume everybody wants lunch and we're coming back in at about 20 of, quarter of at the latest. Can you just explain to me why these slides, if Dr. Rentschler is permitted to express these opinions, why we also need them on slides? That's the problem I have.
I think that's a great question, Your Honor. And the reason we didn't do these on slides is because we objected to Dr. Wilkins coming in on his PowerPoint.
So I looked at that yesterday.
A copy of the specific opinion that was placed up on the screen with regard to his opinions and conclusions. That was done over the defense's objection.
So which one? Because I did look last night at that and did not see it.
It's slide 136, Your Honor. The totality of the evidence.
Hold on one second. Is it a conclusion page?
I don't know. I just.
Hold on.
But it's page 136. It's entitled Evidence Reflexes Ictonology. And it states the totality of the evidence is consistent with the right rear corner of the big 2021 Lexus impacting the argument. And this Doherty striking the rear posterior aspect of his head on the frozen ground.
Okay.
So if he's allowed to do that.
So that is different than what I said he could be asked on his ultimate question, right? But it still came in? Was there, I'm sorry?
Yes, that came in over the defense.
All right. Because what I did note is that I was very careful to say exactly what the ultimate question could be from Mr. Brennan. In fact, there were objections. I sustained them twice, so I wrote out exactly what could be said. And Mr. Brennan asked a variation of the first one, and there was no objection. So I didn't remember that this came in. All right, so I will take a look at that. What I would like to do in the interest of time, so maybe we can talk about that in the conclusion page, but where he outlines everything else, there's so many pages with text that I may not have a problem with testimony regarding this, but why do we need testimony and text so much here?
This is to assist the jury.
It's what?
This is to assist the jury. There is a significant amount of information that needs to be relayed.
Okay.
It's an 80-page PowerPoint.
Okay.
This is solely to make sure that this goes efficiently and effectively. I think it's helpful for these. You've narrowed down the text on the slide significantly. It's important to see those PowerPoints.
Okay.
Just to the major issues. I think we've streamlined this a lot, but I think having the PowerPoint will allow us to make this go smoothly and quickly.
All right, so I will look at these. What I'll try and do is if there are any changes in the first 15, I'll try and get those done during lunch, and then we can have this argument afterwards.
Thank you, I appreciate that.
All right. All right, we'll see everybody no later than 4:15.
That was a big info dump right there.
Yeah, it was.
Yeah. So I'm interested, Margaret, what are your opinions as far as that court case involving Dr. Lapasato? Do you think that comes in?
I doubt that will come in.
Okay.
I don't know much about that court case, so obviously Judge Cannoni is reviewing it right now, but that might just open up a big can of worms.
Right.
I think some of it should come in so that Hank is able to impeach the witness's credibility, but we'll see how much Judge Cannoni limits that.
Right.
What is your thought on that case?
I mean, I think that I can see why it would be kind of prejudicial in the sense that it was specifically a child abuse case where it sounds like she was minimizing for the perpetrator, and that can really emotionally inflame people. Yeah.
Right. Yeah, it's just she's got to limit it to some extent because the jury is getting a little bit antsy. So, but she'll review this over lunch and figure. I would imagine Hank will get to ask a few questions about that impacts this witness's credibility. What about? See, I don't know much. I'm wondering, what do you think about Jackson's response as far as the Rhode Island fire case is concerned?
That's not the way that it was portrayed in the media at all.
No.
And she resigned amidst all this. So
yeah, that fire, it impacted musicians. I mean, all the way up here in Canada. I recall when that happened. I was I didn't use pyrotechnics very often, like almost never. We had a gig that had a decent floor size, and we were going to bring in these little flame columns, right? They shot fire up about 12 feet, and it had a vaulted ceiling, so everything was good to go. And that fire happened, and the establishment was like, no. I had to bring in a ticketed pyrotechnician to sign off to do that. That was right on the heels of that fire happening within a week.
Well, as far as Lapasato's involvement, I mean, Jackson really fluffed over and misstated what happened. She didn't have, I mean, I guess staff is not a very good word. It's rather imprecise, but she sent one investigator in 17 hours, despite being made aware of the magnitude of what had just happened. One investigator. So it wasn't like she had ample staff that was down there handling it and she was just home because she was the boss and I'll come by later. That's not what happened there.
Okay.
Yeah. The backlog, it wasn't just a political disagreement. She was audited. They were found to have a tremendous backlog that she had misrepresented. So that's another issue of not only competency, but honesty, and then you hear that she's been called a hired gun in another case. Yeah, I think that's, maybe they want to limit the subject matter. Maybe they don't want to mention that it was a child abuse case just so it's not overly prejudicial. Right.
Yeah.
But she was the court found that she was incredible and a hired gun. And I think that's important for
That's important. Yeah. But I'm still not sure if Judge Cannoni will allow that.
Right.
I mean, most of these expert witnesses are hired guns,
Well, for sure.
They're all
But to
hired
varying
guns.
degrees of honesty, though, right?
Sure.
Like, I mean, there's hired for a job, you do it with ethics, and then there's straight up mercenary. You do whatever you're paid to do.
Yeah.
I think she leans
paid a lot of
towards
money.
that. Yeah, big time. Yeah. They paid a lot of other people's money.
Mm-hmm.
Yeah, I mean, I think there's an understanding that most experts are hired guns to some extent. Is it usual for the court to call that out, though?
No, you know what? Usually they don't. So I'm surprised the
Right.
judge would use that language. So that's why I'm not sure if that part will be allowed in this case. I mean,
Right.
that could have come from a judge who was overstepped by saying that. I mean, that should not have come out by a judge in front of a jury if it did. That's not right. Don't you agree?
Possibly.
And that was said in front of a jury?
I don't know that it was said in front of a jury
Okay.
as much as it
Yeah.
was a decision.
Mm-hmm.
But
That's inflammatory.
I guess I would have to know more about the circumstances surrounding that, because it is inflammatory. But is it needlessly inflammatory, or is it reflected in the findings of that particular judge? Like, what precipitated that? I just don't know.
Right.
All right. So on that note, I know I have to leave shortly because I have to take my older dog to the vet. He has developed some sort of bump on his back, and I don't know what it is. It's probably nothing, but as soon as I noticed it, I made an appointment. So I have to do that this afternoon. I know Kevin will be back.
Okay. I'll be here. I have to make a dump run. I do. I've got my, tomorrow it's closed and then the next day it's closed. So, Karen Reed, it's tough to get all these little errands in, right?
I always say that,
Big time.
A lot of people ordering takeout. The X-ray. So yeah, I do want to bring up free Karen Reed people. I got to give you that point. I was under the impression this entire time that he was never X-rayed. I believe there was even testimony that he was never X-rayed, and it turns out that he was X-rayed. So.
Okay.
Well, there you have it.
There you go. You got that
exactly.
One. Yeah. What that changes, I don't really know. I mean, I suppose if you want to get hung up on a lack of bones breaking in the arm, you can. I don't know what that really, particularly because if we go back to Dr. Marie Russell's testimony, if you drive your car into a group of people, everybody's injuries are going to be different. Some people will be, immediate fatality. Other people will walk away without a scratch. So you can't really quantify what's going to happen during a
my daughter got hit by a car in New York City, and guess what? She just walked away without a scratch. So it really varies. Really, really does. And that's where the jury will come in and bring their own experience into it. I mean, I got to believe she was lucky to be hit a certain way.
Mm-hmm.
So she didn't even go to that. She just kept walking and went to work.
Just walked it off and went to work. Didn't even take the day
and
off.
went to work.
Wow.
No, but she called and complained to me. Oh my God, Mom, you're not going to believe this. I get hit. No, she got hit. She must have gotten hit perfectly so that
The
I don't know.
strong work ethic. I mean, I think a lot of people might milk that like, hey, look, I can't
I
come into
know.
work today. I got hit by a car. I don't think any boss would really fault you.
Yeah, exactly. Well,
Strong
she
work
must
ethic
not have
for
had
sure.
any scrape. You know, obviously, she didn't have any scrapes or bruises or anything, so then they might
Right.
not believe her. But
Right.
anyway, just go. I'm, you know, but it's all different. Obviously, this SUV was traveling approximately 24 miles per hour,
Mhm.
and just by that dummy test with Randy the dummy, my God, that was very impactful for me. I'm still blown away that the defense, you know, use those videos with the crash
Same.
dummy. It just really, really helps the prosecution's case.
Yeah, it put it in visuals. It was concrete proof of everything they were saying. Free Karen Reed was screaming from the rooftops. Could not be done. Could not
Yeah.
happen. There it was.
Yeah, yes,
You know.
James, we do not understand. Perhaps we don't understand the type of X-rays. If you want to explain that,
True, James.
I
Yeah.
don't. I don't know. Yeah, I thought Squirty Bell had said that she did an X-ray as well.
Randy will convict her.
Yeah.
That's a good one.
Are we going to have another Alessi screaming mistrial with prejudice? There was X-rays. That'll be the new.
No, because they brought them in. They brought them
They
in.
like that. They want
Yeah, they
that.
brought them in. They were the ones who brought them
Yeah.
in. All right, so I'm gonna put up the banner, guys, and Kevin will probably be back. One thing I am gonna do is unmute this music. So God forbid if I'm in traffic on the way back.
Okay. Well, I'll be back after lunch, and I mean after the dump.
All right, sounds good, guys. All right.
Wish me luck.
All right.
All right. Good luck.
Yeah.
Hey guys, just to let you know, I'm back, so I'm monitoring things as soon as they come back into court. I have it on another channel too. I have it on the court TV feed, and so you won't miss anything. Kate had an appointment that she had to go to at 2, so she'll be back sometime in a little bit after that.
Graduations, parades going on this weekend. I think Friday is an okay day. I think Sunday is an okay day, but in between, it's a bookend or sandwich the weekend with another round of showers, which will likely make 14 weekends in a row that often have measurable rain or trace amounts of rain at the very least. Monday, we're right around 74 to 75, and we sustain that. They do upper 70s through next Tuesday and Wednesday. We need some of that heat, though. There's another chance of.
Okay, so we are set up and good to go. I won't have the Karen cam until Kate gets back. Kate puts up the Karen cam. So just getting a little ahead of that now. I know when we don't have that up, people will be asking, where's the Karen cam? But as soon as Kate gets back, and she indicated she wasn't going to get back too long after 2 o'clock, so maybe 2:30 or something like that, she will put the Karen cam up. But we will not miss anything about what's going on in court. Background noise. Oh, I have the TV on. Sorry about that. I will turn. I had on NBC, NECN. I had the trial on that channel too, but now I've muted. Thank you for helping me with that. I'll put the fan on too in case that was making noise. Thank you, Angel. I seem to be slowly recovering, but there is now, unfortunately, a cold sweeping through this house. So I expect that sometime between today and tomorrow, I will come down with a cold, which is the last thing that I need. But, oh, well, it is what it is. We'll survive it. I'm not sure what the noise was that people were talking about.
You are unmuted.
Okay, we're getting life back on court.
Back in session, you may be seated.
All right, the jury is coming over. I just wanted to tell you what I was able to do during the lunch break. So, Mr. Brennan, you argued for 4 points of admission regarding this witness. I'll allow in 1 and 2. I've had a chance to look at 4. I think I already told you I would not allow in 3 because I've already considered it. I've now looked at the 4th one, the case. I'm not going to let you get into that during cross-examination. If the door is open and you think you can get into it after redirect, please come to sidebar.
Thank you.
All right, and also I had a chance to look at the actual exhibit regarding what came into evidence from Dr. Welcher and Ms. Little. Contrary to what you said and what Mr. Alessi was nodding to, page 136 did not come into evidence. It's a blank page. So that PowerPoint did not come in. I had a chance to look at Dr. Rentschler's PowerPoint, and at least for now, maybe you can persuade me otherwise, any text that has hearsay on it that you say will help assist the jury, what I want to say is I think we have to give the jury some credit here, okay? They have been listening to this case intently for weeks. I don't find that anything that you've recommended here comes in to assist the jury is necessary to assist the jury. So before Dr. Rentschler testifies, those slides that were objected to that have text are out.
Can I have a moment just to examine the Dr. Welcher PowerPoint?
No, not right now. You can look at it, yes. You can look at it while we're bringing the jury in.
Okay, because we have 4 copies of the PowerPoint, and I know that I'd like to be able to. 137 is the report. Yeah. So
Mr. Alessi, please. One 136, 137, and 138 are all blacked out. All right, the jurors on their way, right? Okay.
Just think about how exhausted this judge must be. So for her 15-minute lunch, she had to look over those documents and make decisions. So she doesn't really get a lunch. She's got to wolf down some food perhaps while she's working. Very, very difficult. And for WD-40, talking about the poll, does that mean something to you? Does a poll mean something to you? That poll is not based on people that have watched every day of the trial. That poll is based on the media influence. And the Karen Reed machine has been polluting the public with false information for 2 years. You have to recognize that. There's no rational reason to not recognize that anymore, because all of the stuff that the defense team has been putting out for 2 years, they're not even presenting any of that to the jury. Does that mean something to you, WD-40? Does it mean something to you that the jury is not going to learn any of the stuff that is influencing the public on this? The jury's not being presented anything on how long to die in the cold. The jury is not being presented with anything about the data of going up and down stairs. All this stuff that has influenced you and the people in the public, none of that stuff, none of it was presented to a jury. You could just ignore that? Does that mean nothing to you? So what does a poll mean to you? A poll means absolutely nothing. What matters is what the jury got to see. Now, if there's somebody within that poll, if some of those people watched all of the trial, and I doubt there are, that'd be different. Those people are just looking at what the exploitive social media and defense
Right,
team are
Mr.
feeding
Brennan,
them.
whenever, I'm
It's just
sorry.
a non-stop stream of false information for 2 years. You can't just ignore that, dude. You can't just ignore that. So I guess your goal is to just continue
Good
that
afternoon.
misinformation.
You are.
You were asked on direct examination about your qualifications. You were a medical examiner for the state of Rhode Island, is that fair to say?
Yes, I was the chief medical examiner.
For 20 years?
12 years.
I'm sorry, 12 years. When's the last time you worked as a medical examiner?
In 2005.
When's the last time that you conducted an autopsy?
I've done probably a handful of autopsies, private autopsies in my consulting practice.
Since 2005?
Correct.
When do you think the last time you did one is?
Maybe 4 years ago, 4 or 5 years ago.
4 or 5 years ago?
Yes.
Okay. Since you left the medical examiner's office, have you had any specialized training in brain injuries?
It's all part of keeping up with the medical literature and knowing the forensic pathology literature, reading medical literature. So it's a continuing endeavor to keep yourself educated with medical updates.
Since you left the medical examiner's office, have you had any specialized training in brain injuries?
I've not gone to a course on brain injuries.
Since you left the medical examiner's office, have you taught any students on brain injuries?
Yes.
Have you given any classes or seminars on brain injuries?
Yes, I have.
In coup counter coup, how many times have you experienced that as a medical examiner, that condition?
Well, I myself haven't experienced it, which was good, but in cases, hundreds of cases, it's a common injury.
You said you did differential diagnosis. That is to exhaust any potential bias you have, correct?
Well, a differential diagnosis is to think, how many ways can you get this finding? And it does help prevent bias.
Did you say on direct examination, part of the benefit of differential diagnosis is to make sure that you don't have a bias?
Yes, yes.
In order to eliminate bias, you're supposed to look at all reasonable alternatives, correct?
Yes, that's part of it, making a differential diagnosis.
So you don't just look at a person's body, come to a conclusion, and ignore other evidence. That would kind of defeat the purpose of differential diagnosis, wouldn't it?
Well, you always have to look at all the evidence.
And so if you didn't look at all the evidence and you disregarded some of the evidence because you had already made up your mind, that really wouldn't be the proper study of differential diagnosis, would it?
Right, I don't do that.
I'm sorry, ma'am.
I don't do that. I always look at all the evidence.
And would you look at all the evidence even if it was contrary to whatever opinion you want to give in court?
Well, the evidence allows me to come to an opinion. So it's not like I decide on some opinion I want to give and then look for the evidence. The evidence is going to tell me what happened to the body.
So you would never say, like, I don't need to look at that evidence. If it's presented to you, you would look at it and study it and consider it in differential diagnosis?
Sure, it may or may not apply, but I'd look at it.
Because if you did that and said, well, I don't need to look at this, and it was relevant evidence, that would defeat the whole idea of differential diagnosis, correct?
Well, you always want to look at all the evidence that's going to help you decide what happened to the body.
If you were to ignore relevant evidence because you already made your mind up, that could create some type of bias, even if you're not recognizing it, correct?
Well, I don't make my mind up. I make it up on all the evidence I have. Then if something else other evidence comes up later, I have to reevaluate everything and consider that new evidence.
When you were talking about car collisions, I don't want to belabor the point, but you didn't major in physics, did you?
In what?
You didn't major in physics, did you?
No, I took physics, but no, didn't major in it.
Okay. And the last time you took physics was probably, what, undergrad?
Correct. Thank goodness.
You have no study in biomechanical engineering?
No, I'm not a biomechanical engineer.
Understood. You never taught courses in accident reconstruction, have you?
Only in terms of looking at the injuries on the body and showing how that they could or could not have occurred from impact with a motor vehicle.
Have you taught classes in accident reconstruction?
Only as far as it would affect the findings on the body.
Do you know what I mean by when I say accident reconstruction?
Well, accident reconstruction meaning, and I'm telling you that my expertise in accident reconstruction is restricted to looking at the body and then understanding how impacts may or may not have occurred to the body. I don't take a car and look at mileage and such like that.
You don't do any studies of the actual vehicles, you're focused on the body?
I'm focused on the body, but I also look at the vehicles to look at the points of impact that might be possible.
You do not have any advanced study in biomechanics, do you?
No.
Okay. Now, you had mentioned that when you were in the medical examiner's office, you had a number of higher profile cases.
Well, every case is important because somebody's dead.
You pointed out some pretty specific ones on direct examination. Were those more important, the ones that were highlighted, or is that the same as every other case?
I don't know what you're talking about.
Well, you had mentioned the Egypt airline crash, station nightclub fire. Those were highlighted or pronounced on direct examination. Are they equally important as every other case?
Oh, absolutely. Every person is my patient.
You talked about some of your commendations. The station nightclub fire, you received quite a bit of criticism on that, didn't you?
Well, there was a flurry of negative press without any basis.
You had mentioned that a doctor, a medical examiner, should have gone out to the scene to look at the area where John O'Keefe was found to make observations. Did you suggest that in any way on direct examination?
You have to know what the scene looks like, and usually that is documented in police reports and in police photographs who document the scene.
The Station nightclub fire, that had numerous victims, didn't it?
Yes, 100.
And you received criticism because you were repeatedly requested by emergency responders and police officials to come to the scene, and you refused?
That's incorrect. First of
Okay.
all, nobody called me to come to the scene, and medical examiners are not first responders. As soon as I got a call that there was that fire in the nightclub, my investigator went right to the scene, and I was in constant communication with him throughout the early morning hours of that horrible accident. And I went into the medical examiner's office because I had to start getting ready to run our office 24 hours a day to not only take care of the poor individuals who expired in the nightclub fire, but also the regular work of the medical examiners. So there was no need for me to go to the scene because I had my investigator there, and my job would be at the office to get things all set up to handle the influx of deceased.
Did you receive criticism that over 17 hours there was an effort to have you come to the scene, but you refused?
There were, I'm going to allow it in a different form.
Yeah, that's incorrect.
Hold on, Dr.
Oh, I'm sorry.
Oh, no, I didn't mean to scare you. Just
Oh. Okay.
Hold on for a second.
Okay.
Ask him differently, Mr. Brennan, please.
Did you receive criticism that officials?
I'm going to allow it based on the ending, pursuant to the ending. Let's hear it.
Did you receive criticism that for over 17 hours officials were asking you to come to the scene and you refused?
It was untrue. It was printed in the newspaper. We looked up all the phone records and provided it to the newspapers and showed that nobody called me to go. I would have gone if I needed to. I had my investigator there. It was just bullshit. No, it was erroneous stuff.
Was there other criticisms in 2005 before you left the office?
No, there was a flurry of stuff in the papers. There were union issues, new director of health, new governor. So yeah, there was a little flurry of stuff, which was not substantive.
So you inevitably did resign in 2005.
Yes, because my budget was going to be cut, and I knew that if I had to get rid of a medical examiner, we couldn't do a good job for the state, and I'd done it. I'd been chief for 12 years. I'd been on call 24 hours a day for 12 years, which was an honor, really. But then if I couldn't do a good job, if we cut the budget, I had to get rid of a medical examiner. I couldn't serve the people of Rhode Island well, so I resigned.
Did you resign shortly after the audits and criticism?
No.
Same year?
Oh, I don't even remember.
Okay. After you resigned, you opened your own company?
Yes, I started an independent consulting practice.
How much of your business is consulting?
It's a consulting practice.
Yep. How much of your business, how much of your income is consulting?
100%. It's consulting.
Do you consult in both criminal and civil cases?
Yes, I do.
What percentage of cases are criminal cases?
It's maybe half and half.
Half criminal, half civil?
I don't keep track of it in that way, but that would be a guess.
I'm sorry, I'm sorry, I didn't hear you.
I don't keep track of numbers of civil or criminal cases that I'm consulted in. If I had to give an estimate, it would be half and half. I've worked on over 1,000 cases in my private company.
And fair to say you get compensated for your time?
Yes, I get paid for my time.
Dr. LaPosada, you had mentioned that there were some scratches that you had taken a look at on Mr. O'Keefe's body. If we could have Exhibit 165, please. Now, would it be fair to say, Dr. LaPosada, you do not know the genesis of that cut on Mr. O'Keefe's right eye?
I do not know what caused it. I can tell you what didn't cause it, but I don't know what did cause it.
You said that was from blunt force?
It's from application of blunt force to that little area that broke the skin.
When you were asked a question about whether that was consistent with a punch, you opined that it was consistent with a punch, yes?
It could be consistent with a punch.
You weren't saying it was consistent with a punch to a reasonable degree of medical certainty, were you?
That would be within my differential diagnosis.
It could be consistent with all other types of blunt impact, or many other types of blunt impact, couldn't it?
That's correct.
Ground, perhaps?
No.
No, an object?
If it was an object that could get into that area under the eyebrow, yes.
You mentioned the spoiler on the back of Miss Reed's Lexus. Do you remember that?
I remember that.
Do you know how tall John O'Keefe was?
He's around 7 foot, 5'11", I think, 7'2", something around in there.
No, he's more closer to 6'1". Does that make sense?
Sure.
Okay. And that spoiler on the Lexus, do you know how high off the ground that is?
No.
Did you ever try to measure it or ask for photos or any information about that?
No, I looked at the photos.
Did you ever ask for any measurements or try to take any measurements?
No.
Could I have Exhibit 166, please? Did you see this cut on Mr. O'Keefe's nose?
That's a scratch. It's not made by a sharp instrument. It's not a cut. It's a scratch.
Is there any scratches on the left side? Do we have a photo of the left side? Please. And that, you say that's a scratch, not a cut?
Correct, because a cut means it's made by a sharp thing, like a knife, and a scratch is made by something that's kind of rounded that has a little point on it, but it's not sharp.
Do you have any information or basis to say where that scratch came from?
No.
Did you do any differential diagnosis on that scratch?
I don't know what caused that. There could be a number of things that caused it.
There was no scratch on the right side of Mr. O'Keefe's nose?
I don't see it one, no.
Could you zoom in, Ms. Gilman? So the only scratch was on the left side?
Looks to be, that's not a good photograph because there's some blood obscuring the skin.
Yes.
If my memory serves me, there is a scratch on the left side of the nose and maybe a small scrape on the tip of the nose.
And we can go back to the left side? And you said that could not have been caused by a sharp object?
Correct. It's not an incised wound. Incised wound means a bladed sharp cut. This is a scratch, not made by a blade.
Were you aware the defendant made a statement that she pulled a piece of glass from the defendant's nose?
No.
And you would say that that wound is inconsistent with being caused by glass or a sharp object?
It would not be caused by a blade. It could be caused by a piece of glass that was thick.
I thought before I offered you that statement, you had said that it could not have been caused by glass. Do you now have a different opinion?
I don't remember saying it couldn't have been caused by glass.
Didn't you say it couldn't have been caused by glass or a sharp object?
A sharp object.
Like
a sharp object, like it's not an incised wound made by a blade. It could be caused by something sharper that's thicker, but does not have a thin blade. So it could be caused by a thicker piece of glass.
If somebody is deceased, does any blood pressure from their heart still move in their body?
No, they're dead.
If somebody removed a sharp object like glass from somebody's face, would they spurt blood if they've died?
If you're dead, there's no blood pressure. So if you're dead and you remove something, there may be some superficial blood, but it's not going to have blood flow because your heart's not pumping blood out of the cut ends of the blood vessels.
So it's not going to spurt if you pull something out of a person's skin if they've passed?
You wouldn't get a spurt of blood from arterial pressure.
I just want to ask you a very few questions about hypothermia.
Sure.
You mentioned that Mr. O'Keefe's body temperature at the hospital was 80 degrees,
Yes.
and there's different ways to take somebody's or a body's temperature, isn't there?
Yeah, that was a rectal temperature, so that's a good representation of the body temperature.
Is the variance between a common practice of taking temperature and by somebody's mouth and rectal, is it about a 3 or 4 degrees difference, or do you have a different experience?
It can be different. A rectal temperature gives you a better internal body temperature. The oral temperature, if you're breathing in or if you just had something cold in your mouth, may not register a proper temperature. So the rectal temperature is the preferred temperature to for a medical diagnosis.
98.6 is an important temperature, isn't it?
Yeah, it's our usual normal body temperature.
And so, is there a standard? Is 95 degrees considered hypothermic?
If you have, then clinically you would start to worry that the person might be experiencing bad effects of hypothermia.
At 95 degrees?
At 95, you start to worry about it.
And could some of the things that happen is labored breathing?
Is what?
Labored breathing?
What about labored breathing?
Well, if someone is hypothermic, if they're 95 degrees, does it affect their breathing patterns?
Not especially.
Okay. Does it affect the way their respiratory system works?
No.
Does it have any effects on the human body if you're hypothermic at 95 degrees?
No. You're still okay.
If that temperature continues to decline, it starts to become dangerous, doesn't it?
It can.
Mr. O'Keefe was evaluated, and at the hospital, his body temperature from a rectal reading was 80 degrees at about, what, 6:37?
Correct.
Did you know that before he got to the hospital, first responders had him in an ambulance?
Of course.
Did you know they turned the heat up and put blankets on him and tried to provide warmth to him before he got to the hospital?
Yes, that would be standard practice.
And that standard practice would usually add temperature to the person, wouldn't it?
Well, it might.
Okay. So it's possible it could, but it might not.
It usually doesn't add that much.
I see. And so inevitably, at 6:37, Mr. O'Keefe's body was 80 degrees?
Yes, when he got to the hospital, his rectal temperature was 80 degrees.
And so that is a drop from the standard, or what's expected, of 98.6 degrees. That's a drop of at least 18.6 degrees?
Yes.
You mentioned that Mr. O'Keefe, after suffering his head injury, would not have moved other than twitching.
Correct. No purposeful movement.
Were you aware that he had an iPhone with healthcare data on it?
No.
If there's no movement, assume for a second there's no movement of Mr. O'Keefe after 12/32/16, and he's found a little after 6 a.m. in the morning. That's about 5 hours, or 5.5 hours, correct?
About.
And if somebody is in the cold for 5.5 hours, that's consistent with dropping from 98.6 degrees to 80 degrees in body temperature, isn't it?
If the person is dead, yes.
If a person is outside in the cold and still alive, will their body temperature decrease?
If they can, people can die of hypothermia, but that's not the case here.
Oh, not the ultimate death, but if somebody's outside and they're alive and they're lying in the snow and it's below freezing, will they lose body temperature?
They will, especially if they're not bundled up well.
And body temperature can drop from 2.5 to 4 degrees an hour?
In a dead body.
Okay. In a living person, it can drop 1.5 degrees.
No. A dead body at room temperature will usually lose body temperature at like 1.5 degrees an hour. If a dead body is in a cold environment covered with snow and avalanche environments, the dead body can cool at 4 degrees per hour.
And so a person who is in cold conditions, starting to be covered by snow, less than freezing, they can lose body temperature when they're living, can't they?
If you're sure, you can. People die of hypothermia, but that's not the case here.
Well, someone could be alive, lose body temperature, and not die. That can happen, can't it?
Yeah.
Right. So if someone is in the cold, let's assume they're not dead for a second.
All
They're in the
right.
snow, below freezing, not moving. Can that person lose body temperature if they're still alive?
Sure. They just lie there. They can become hypothermic and die.
Even before they become hypothermic, can they lose body temperature?
Well, losing body temperature makes you hypothermic. Thermic is temperature and hypo means below. So your temperature goes down and you're hypothermic because it's going down.
And people can survive from being hypothermic if they get the right care.
Sure.
And so in that 5.5 hours, it is consistent with a person being outside in the cold and starting at 98.6 and ending at 80. That's consistent with being in the cold for 5.5 hours, isn't it?
For a dead body, yes. That's how a dead body would cool in a snow-covered cold environment.
And it could also be consistent with somebody who is alive for some time and then dies, correct?
I don't understand your question.
Somebody could be out in the cold, under the snow, sub-freezing. They could be alive for some time. Their body temperature could drop. And then when they pass and die, their body temperature could continue to drop probably at a more rapid pace. That still fits within
No.
5.5 hours, doesn't it, Dr. LaPosada?
No.
Oh. Because if someone can drop 4 degrees of body temperature in an hour,
A dead body.
yes, it would only take about a little over 4 hours if it was at 4 degrees to go from 98.6 to 80. Yes?
Correct, yes. So he was exposed to that cold environment for 4 to 5 hours.
If somebody was alive for a couple of hours, it's a lower rate, say they'd lose 3 degrees. And then, after that couple hours, they lose body temperature at 4 degrees. That would still fit and be consistent with the drop from 98.6 to 30 degrees,
No.
to 80 degrees, wouldn't it?
No, but you were saying a dead body cools in a cold environment at maybe 3 to 4 degrees an hour. And that has nothing to do with a living body and how long they can stay at a body temperature.
Do you disagree that somebody could be alive, lose body temperature out in the cold, freezing temperature below 32? They could lose body temperature at a certain rate, then die, and then continue to lose body temperature. Is that possible?
Anything's possible. It's just what's important is what happened in this case.
I'm asking for your medical opinion, though, rather than to be an advocate. As far as your medical opinion,
So sustained, and I'll strike that.
as far as
Dr.
your,
Lapisada,
Yes.
could you listen to the question, please?
Of course, thank you, Your Honor.
as far as your medical experience, could somebody be alive, outside, in the cold, below 32 degrees, not moving, covered by snow, still alive, and lose body temperature?
Sure.
And then could they, after an hour, 2 hours, could they then die and continue to lose more body temperature?
Sure.
You mentioned your opinion about injury on Mr. O'Keefe. And at one point you said that his injury was inconsistent with a taillight, and you said because there was no damage from the bumper. Do you remember saying that?
I don't think I said it quite that way.
Okay. Do you remember how you said it?
No.
Do you remember discussing or raising the issue of a bumper as part of your equation, that the injury to Mr. O'Keefe was inconsistent with the injuries?
he has no injuries on him that are consistent with being hit by the back of the SUV. That includes the spoiler, that includes the bumper.
Okay, if we could play video E, please. I want to ask you, Dr. Laposada, have you seen this video before?
No.
Thank you. You can take that down. Did you see anything in that video that would suggest any contact between that mannequin and the vehicle's bumper?
Objection.
I'm going to see you at sidebar on this for just a minute, please.
Okay, this looks like it'll be a quick sidebar, but you know, the way she's continuously trying to inject herself into this by saying that's not what happened here. You know, I don't know how the jury will react to this, but to me, it shows she's really she's just trying, kind of like Dr. Marie Russell did. She's trying so hard to help the defense. And I think the jury would have to ask herself is why? I mean, she's really making that extra effort to try to help the defense. As Dr. Marie Russell did when she was talking about a lot of different things that she had seen in evidence, like she was trying to anticipate the questions here. But I mean, is this doctor, I mean, she's effective to a degree, but is she really better than Dr. Wolf, the neurosurgeon? It's not even close. I mean, there's a guy that's operating on brains every day. There's a guy that really understands how the brain works. And yet she gives this opinion that I've never heard anybody else say in the last 2 years, any other medical expert that's talked about this case. She's looked at those injuries that are apparent in the medical exam and saying that to a degree of medical certainty, John would have died within 15 or 20 minutes, which is just stunning because it doesn't match any of the defense theories or the prosecution theories or anything else that anybody else seems to have said. For her to say that with a degree of certainty that John would have been dead within 15 to 20 minutes, that's a really bizarre opinion. That doesn't match anything else that anybody else is saying. But, you know, I think Hank does need to call up witnesses to clean this up on his rebuttal. I mean, it makes it necessary. You have to call in a medical expert, either somebody new, which I don't think they can get. I'm not sure what the rules are, if they can even get somebody new on at this point, or call back Dr. Scordy Bella, who is not the best witness, ideally to get back Dr. Wolf. But this guy obviously has an extremely busy schedule. He probably has surgery scheduled every day this week and next week. So obviously that would be ideal if they could get him back, but that seems like it would be really hard. So I don't know. But yeah, because of, she is going to do a degree of making things difficult. Oh, Margaret is back too. Let me bring in Margaret. Hey, Margaret.
Hey.
How much damage is this doing, do you think, to the prosecution?
How much damage is this doing to the prosecution or the defense?
Well, what do you think the impact of this testimony is of this medical examiner here?
I don't think she has as much impact as people out there think she does, because like you were saying just now, Dr. Wolf is a neurosurgeon. This woman's just a forensic person. You know, she's not even a qualified doctor like that. So,
right. But her testimony is going to be much more recent, you know.
I know, unfortunately, it is. But I think Brennan's doing a nice job at cross-examination right now. I really do. And
he's doing the best he can under the circumstances, because this doctor has a lot of experience. She was the chief medical examiner for a number of years in Rhode Island. And for whatever reason, she is determined to help the defense here. I mean, she just keeps interjecting here by saying, well, that wasn't what happened. And that, you know, she's skipping past his question, you know, by every chance she gets of saying John did not die of hypothermia. So,
and the jury will see that. It's very obvious to me.
So you think they'll see it? Okay.
I do, especially how she started out, remember?
Right.
I'm sorry, it's
I
not.
do think
It's not the afternoon yet. Yeah.
Right. I know exactly. But I do think Hank needs to bring on an expert witness to clean this up, to make sure, really to make sure there's no reasonable doubt.
Mm-hmm.
And it shouldn't be hard to find that, because I haven't seen any medical expert anywhere say that with some degree of certainty, John, based on his injuries, would have died within 15 or 20 minutes. That's an extreme opinion, it seems.
It really is.
So they'll be getting out of sidebar any moment now.
Yeah.
I have it on the TV as well. It's a few seconds ahead of this. So do you think if there's a mistrial, Margaret, that the judge will want to go immediately into a third trial, assuming the state wants to do it?
Well, that's up to,
All right, so
that's up
juries,
to the
I am
district
going
attorney,
to strike
Morrissey.
the
Right. Okay.
Completely.
last bit of questioning of this witness and the video as it goes to this witness. All right.
Dr. LaPosada, after you received materials, did you ever ask for any additional materials?
Let's see, I always make sure I have all the scene investigation, autopsy, medical records, police and witness investigate and witness statements. So I felt I had a pretty complete database. I didn't get the x-rays until a couple weeks ago, so that was delayed.
That was newer?
Yes.
You said a medical examiner has to make a determination in 90 days. Is that the rule?
When you work at a medical examiner's office, when you get a deceased in, our national standards want us to have the autopsy report completed and all the associated tests done within 90 days.
Can investigations occur in the additional accumulation of evidence happen after that 90 days?
Oh, sure.
Thank you, Dr. LaPosada.
Yes.
I'm so sorry.
It's okay. Dr.
Okay,
LaPosada.
hold on one second. Jurors, when I strike something, that means disregard it. And what I've struck through this witness, the video that you just saw and some of the testimony means that if it's in evidence, it's in evidence, but it is not part of your consideration with this witness. Okay. All right, go ahead, Mr. Jackson.
May I proceed? Thank you. Dr. LaPosada, you were just asked a series of questions about body cooling, correct?
Yes.
Does a body, as it's cooling, does it know if it's indoors or outdoors?
No.
If there's a very cold environment, be it indoor or outdoor environment, would it still cool?
Oh, absolutely.
And it would would it cool at the rates that you earlier described?
Yes,
Even if indoors, if that indoors was cold?
absolutely.
Your Honor, may we approach along with the Commonwealth very briefly?
Okay, we're back. More sidebars. And just when my voice starts coming back, like it almost does, then it dies out again. Margaret is back too.
I'm back.
Boomer's back, I think, too. Hey, Boomer, did you get some lunch in, Boomer?
I got a bit more coffee, thank God. I'm running on fumes. I didn't sleep much last night. I hope it's not showing. But he's saying it could have cooled indoors now. Come on, man. This is just too stupid. Wow.
Well, I think the issue too is if John died at 12:30 or somewhere in that vicinity,
right?
That with the body cooling off at 1.5 degrees an hour, would it end up somewhere where it did, being around 81 degrees at the crime scene? or comparing that to John being alive outside but unconscious. So you should be able to figure out this to some degree of scientific, maybe not conclusion, but let's see. Somebody's putting up something about Dr. Renshaw. It's so hard. Chat moves so fast with this many people.
It does.
WCVB reporting Dr. Renshaw is still waiting in the hall. This means the defense believes there is a chance he will be called to testify today. You remember they wanted to end this, defense to end this today, but I think there's a good chance now it's going to go into tomorrow.
Oh yeah, I don't see it in.
Oh, definitely.
Yeah. This was because of all these motions and things that delayed things this morning,
Mm-hmm.
And it looks like the judge again split the decision on this. Apparently, this new slides came in from Dr. Renshaw at the 11th hour again. But was it reasonable that they were responding by putting those in since Dr. Welcher also had a slideshow? I think that's part of the argument, but that cost the judge and many of us our lunch.
I know. I haven't eaten yet. I was able to get my dump run in, but that was it. Kevin, Court TV moved me to 9 o'clock, so I won't be on with you at 8.
Oh, well, that would have been.
I'm bummed.
Yeah. Who's in the feed that you're on? Who are you on with? If you looked at the emails.
Oh, I don't know yet. They just texted me, so I'll have to look at that.
Yeah. Yeah, I wonder if Joe's just back. Go ahead.
Is the defense just hoping that the jury is as stupid as they are tired? Like they're fed up and dumb? Like, how is the defense going to finagle anything out of trying to put him back in the house again? There's too much evidence that proves he did not go in the house.
I think what they're hoping for is it's just too much information for a jury to absorb. We've been absorbing this information for a while. I know I've been absorbing a lot of it for 2 years. But for the jury, in theory, almost all of this is new, and it's just a lot to sort out in your head.
Right.
Yes, it is. Yeah. Let's see if I can see who I'm on with.
I haven't got my message from them yet, but I usually get mine email around 4 o'clock.
Yeah, I don't have a message yet either.
Yeah.
Yeah.
But me, Joe, and Nick have been on there consistently for about a year. So I think they try to keep the three of us together and then add either Peter or Richard or I wonder how they judge ratings. They must have some way of looking at those numbers.
They do, because Vinny told me that when they did the live show, the ratings were through the roof, and it helped with the advertisers. So they obviously they judge that. They must be able to judge it on a daily basis. I don't know how they do that, but I asked it, are you going to do another live show? And I just don't think Vinny wanted to, which is too bad, because that would have been
they're
great.
not coming back. Yeah.
No.
Yeah.
No. It was the highest ratings the show ever had, was when they just did the live.
Yeah. It's just bad timing after covering this for so long. I had to miss out on it. Just all this stuff medically hit me at that time,
I know, but you're back. Thank God.
Yeah. They were messaging me in the hospital, like, can you make tomorrow? I'm like, I'm in the hospital. Can you make Friday? I'm like, I almost tried to go Friday, but I really couldn't even walk. I just got out of the hospital Thursday. They would have had to wheel me in, and I didn't want that either. I would have just made sure I could walk the short distance to getting in so nobody could see me,
Yeah.
But.
So I wonder what's going to become of these X-rays here. I still think that Alessia's going to come running in screaming that vindicates her and mistrial or some dumb shit. I just think he's got one more stunt left in him, and maybe he'll run around with this new info.
So I just got my notification from Court TV, and it looks like so far I'm only on with Peter, Elikin, and Nick. There's nothing here for Joe. Hopefully Joe's on. I love being on with
Probably.
Joe.
I'm
Yeah.
sure.
But
Yeah,
usually we
Joe.
get
They bumped
usually
me
all
for
four.
Joe.
No
It's
shame in
okay.
that. Joe is the most
No,
entertaining.
he's excellent. Yeah. I'll be on at 9. Hopefully people will hang around and watch me at 9.
Yeah, they do.
Of course they will.
They do.
Yeah.
It's definitely through this trial, and I guess whatever other trial people are interested nationally. Once they get hooked, they do start watching all of the shows.
Yeah.
Mm-hmm.
Yeah, that's great.
It's tough being on when you went on with 4. It's so
Mhm.
hard because you got to get you get like 2 or 3 times to answer something, and you only have about a minute and 20 seconds at the most to talk about it. It's really tough.
Yeah.
I would
It was the
much
same
rather
thing the
be.
other day. Yeah, with Canton Confidential, I ran into the same thing. I had so many things to say,
Yeah.
and then it ended up I was asked a weird question about Turtle Boy, and it's like, oh God.
Yeah,
So all the
I
legal
saw that
stuff.
one.
Yeah, remember that? It's like, oh.
Yeah. Yeah.
But
I don't know if
hopefully
there's any
tonight they'll
not
give me a
weird
chance.
questions about that guy.
No, that's true.
I don't know.
I know.
Right?
I was all ready to provide tip-top legal analysis.
Mm-hmm.
Mm-hmm.
Yeah, it was not the
Right
question you
there,
were
Paul.
expecting. I know that.
No. No, I know. But
Let's see. WCVB report. This is Channel 5. Reporting during sidebar, a juror is again holding her head, this time with a fist to her forehead and grasping pens. A few jurors looking at the bench. One has her head tilted to the side. So this is the kind of stuff that I guess. This is the kind
they're
of stuff that I
checking
guess the judge is saying enough's enough. I mean, too many sidebars,
Yeah.
too much bullshit. Get control of the trial, judge. Come on.
what does grasping pens mean? Just grasping a bunch of pens? I'm confused.
Yeah, she's just got a clutch full of pens,
Like-
staring at the sky.
Oh, here we go.
Yeah.
I'm going to grasp pens and do this. Oh,
She's angry, I guess. Yeah.
I don't know.
Yeah.
Interesting.
Now, if a jury gets, ground down and just sort of sick of it all, I mean, I guess it's a weird question, but statistically, is there any statistic to point to that favor one side or the other, prosecution or defense? Do they tend to take it out on one?
It depends
Historically?
on who appears to be delaying the trial, who appears to be
Gotcha.
going on forever with direct examination or confusing the issues, or perhaps even going on too long with a cross examination. So I think it really depends on how much time they feel the attorneys are wasting their time, or maybe putting on a witness that they feel we've heard this already. Why is the defense adding this witness? So at this point, they're definitely,
I agree with that,
yeah. So maybe they'll be thinking today, why do we need to hear from another expert who is simply, offering an opinion about an animal bite again?
It goes to that connection. Go ahead. I'm sorry. Go ahead, Boomer.
I was going to say, I watched the Alessi meltdown, the last one he did with the gloves. I couldn't imagine that the jury would have appreciated that.
Right.
And that was a long sidebar there, too.
Yes.
Thank you. Dr. LaPosada, stand back here for a quick second. Before I sat down the last time, I asked you a little bit about x-rays.
Yes.
And the effect of x-rays on an evaluation by a forensic pathologist. Do you remember that?
Yes.
Are x-rays important for a forensic pathologist to consider?
Yes, they are.
Did you find any, you reviewed the x-rays, correct?
Absolutely.
I'm going to relegate my question to just the right arm of John O'Keefe.
Yes.
Did you find any deformities, defects, breaks, fractures, or hairline fractures of that kind on any of the x-rays that you reviewed?
None.
May I approach you on?
Yes, I have a question for you. When you printed these, did you print them from a flash drive?
Your
Sure.
Honor. I have some assistance with this.
Do you have them up on the,
We do have electronic versions of this.
why don't we do that instead of the big, the large?
As long as I can mark the large ones, I want those marked and moved into evidence for reasons that we discussed at sidebar.
So those will be, and you're objecting to this, Mr. Brennan? Okay, well, even if the Commonwealth objected, I'll allow those in, but I prefer to give the jury a flash drive with these on them instead of these big. So we will mark your flash drive, and you can just go ahead, do it in evidence. We'll mark the flash drives. Flash drive will go in with the jury rather than these very cumbersome additional pieces of paper, and you can go ahead and show them.
If I did, or I don't want to have a whole discussion in open court. If it
All right, jurors, we're going to make this one really quick.
Yeah, they got to be sitting there saying you're lying, Judge. You never make these quick. If you're asking who they're going to take this out on, they're going to take it out on the judge. This judge is not in control of her own trial. This is a second trial, and this went on. She wasn't in control of the first trial. She's not in control of this trial. It's just they're going to be mad at the judge, but I don't know how they can take it out on the judge. You know,
Right?
they got to be frustrated.
Margaret?
This is just unbelievable. It's like the old hockey game adage. I went to a hockey game and all we saw were fights and hockey broke out. I forget how does that go, Boomer? You're from Canada.
What's that? What's that? The hockey fight?
I went to a fight and a hockey game broke out or something like that.
Yeah, right. Yeah, no, for real. That honestly, that was.
That's
my
actually
only
funny.
favorite.
I like that.
It's like
my only favorite portion of hockey.
We went to this.
Yeah.
We went to Dedham to watch sidebars and a trial broke out.
Right? Yeah, dude. No, I hear you. Margaret, in your opinion, is there a way to surmise? Okay, let's say that they want to take it out on the judge and they can't. Does that deflect off who's second in line for their ire?
Yes.
Who's going to catch it?
Prosecution.
Oh no.
I don't know necessarily if it's the prosecution. It could be the defense.
Thank you so much.
What's going on now?
I mean, because they both kind of just, even though they're technically not the same side, in some sense they both work for the government. So,
I can see that. Yeah.
I think they like the judge because she's like a motherly opinion, a motherly figure. I mean,
On an overhead. May I approach, Your Honor?
Yes.
Do you recognize this document?
Yes, I do.
How do you recognize it?
I recognize it by the medical examiner identification of Mr. O'Keefe, and I recognize the x-ray of the right hand, the right wrist, the right femur, and I can also tell by the R designation here that that's the right side of the body.
Is this what you reviewed in coming to your opinions and conclusions concerning injuries to his right hand?
Yes.
Thank you.
So these now will mark whatever the next exhibit in A, B, and C.
A, B, and C, yes, Your Honor.
H is now 229A.
May I approach, Your Honor?
Yes.
I'm sorry, I need to wait. May I approach?
Yes.
Dr. Hewitt, sister,
Sure.
do you recognize this document?
Yes, this is a x-ray of the body of Mr. O'Keefe from the medical examiner's office. The R indicates the right side, and we see here the two bones of the arm. There's no injury to them. We see the pelvis bone. There's no injury to that bone. They're perfectly normal, and there's no abnormal soft tissue swelling. It's a normal right arm.
Thank you. I may have this marked as next to order.
That may obviate the need to put it up, right?
It could.
The 229B.
May I?
Yes.
Thank you. Doctor, do you recognize this document?
Yes, this is another x-ray at the medical examiner's office of Mr. O'Keefe. And again, it shows the right side. We see some of the ribs there. We see the shoulder and the humerus, the upper arm bone. And the upper arm bone is totally normal. There's no soft tissue swelling around it. There's no breakage or microfractures.
Thank you, doctor. With the court's permission, next in order, sub C is in Charlie.
Yes.
Dr. LaPosada, that's all I have for you. Thank you for coming.
Anything, Mr. Brennan?
No, thank you.
All right, Dr. Laposada, you are all set.
Thank you, Your Honor.
Dr. Wrench was in the wings, and it looks like they're going to a sidebar. And Tyler, I don't know why you would say that. I really don't understand. So there were objections. Both sides have had objections
Is
the
there
whole
anything
trial.
else today? Yes.
There were objections this morning by the prosecution because the defense, by Alan Jackson, kept trying to sneak things in that they were banned from saying by the judge. That's why there were objections.
Your Honor, may we approach?
Okay, jurors, feel free to stand up and stretch.
And again, I don't actually blame the defense for that. I blame the judge for her split decisions. As if you've been listening, Jackson did what any other defense lawyer was going to do in trying to get that in. No, but they were not allowed to say those things. She was not allowed to opine on certain things. She was the only thing that she was allowed to say was that John's injuries to his right arm were caused by an animal. That's it. And Jackson kept trying to sneak in the rest, even though he was banned. No, I don't blame Jackson. Any defense lawyer would have done it. I blame the judge for her usual split decisions. But Jackson fully knew that what he was doing was going to be objected to. He knew it fully. The judge knew it too. So to blame the prosecution for this is just not being reasonable.
Your Honor, with the court's permission, I would ask the court to invite Dr. Andrew Richler to join us.
Okay.
Sir, I need you to step up, face the clerk, and raise your right hand, please.
You solemnly swear the evidence given to the court and jury in the case now hearing is for the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Good afternoon.
Well, Your Honor, it's fine. It's fine. Feels good.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Sir, could you please, pull that to you. You're a little on the tall side. Pull that to you right up under your chin if you can. And in a nice, clear voice, tell the jurors your name and spell your last name for us, please.
Dr. Andrew John Rentschler, Rentschler.
Sir, what do you do for a living?
I'm a biomechanist, a biomechanical engineer, and an accident reconstructionist.
Where do you work?
I work for a company called ARCA LLC.
Tell us a little bit about ARCA. What is ARCA?
ARCA is an engineering consulting firm. So we do litigation type work, both civil and criminal, where we look at, for instance, I do biomechanics. So I look at injury causation in different types of events, motor vehicle accidents, pedestrian, automobile incidents, sports-related injuries, industrial accidents. We also do accident reconstruction, as well as all types of really forensic type engineering. And we also do R&D, research and development, for private and governmental entities.
What's your current title?
I'm a vice president and Director of Biomechanics for the Midwest Division.
The director position that you hold, that's the official position at ARCA?
That's correct, yes, sir.
How are you ARCA's senior biomechanist?
I'm one of them, yes.
And how long have you held the position of Director of Biomechanics and Human Factors?
It's been at least 5 years. I don't recall exactly how long.
What exactly does is it biomechanist or biomechanist?
Biomechanist, yeah.
All right, I'll get it right by the time we're finished. What is a biomechanist? What do you do?
So a biomechanist really looks at the human body, and we look at the response of the human body to forces and accelerations. We apply traditional engineering, but to the human body. So a mechanical engineer, for instance, might look at a piece of steel, and you know the dimensions and size of the steel. If you apply a force in a certain direction with a certain magnitude, that steel will bend and eventually it'll break. Was a biomechanist or biomechanical engineer, I do the same thing, but I look at the human body. How much force has to be applied in what direction to get a specific type of injury, whether it's a fracture of your humerus, a concussion, an vertebral disc injury. Any type of injury has what we call an injury mechanism. So we look at the response of how the body reacts to forces in different environments. Ultimately, our hope is to actually help prevent and mitigate accidents. You know, motor vehicle incidents, we look at the design of airbags and seatbelts, sporting equipment, how can we reduce concussions and injuries associated with that? So ultimately, we try to figure out how to make the environment and the world safer for people in whatever type of interaction you might have.
Is that sometimes called injury causation analysis?
It is. That's one aspect of it. Injury causation analysis is looking at how an injury occurs. So if someone sustains an injury, as a biomechanist, I can look at the events surrounding that incident and determine how the injury occurred. Now, how someone was positioned, how much force had to have been applied to certain parts of their body to actually produce a given injury.
Why is injury causation analysis important in the broader field of biomechanics? Why do you want to know the causation of certain injuries?
Well, like I just said, our main goal and interest is to really mitigate and prevent injuries from occurring. So in order to do that, you have to know how they occur. You have to know, for instance, hockey, we do a lot of work with the NHL, how certain injuries occur, cervical injuries, concussions, shoulder injuries. So if your intent is to prevent injuries in certain settings and situations, you have to study how the body reacts, how those injuries are created, and then you can determine or attempt to determine how to prevent them from occurring in different events and situations.
What sort of contracts or commissions does ARCA routinely engage in?
You know, we have a number of different contracts. We've worked in the past with the United States military. I helped design what we call the energy absorbing seat for the MRAP vehicles.
Hold on 1 second, Dr. Sure. Okay.
For the MRAP, which are the mine-resistant, ambush-protected, armor-plated vehicles that they had over in Iraq and Afghanistan. And the issue there is that when they go over an IED, an improvised explosive device, it would blow the vehicle up off the ground. So we were seeing very severe accelerations and forces going through the vehicle, through the seat, into the soldiers' spines. And we're seeing severe spinal and head injuries as a result of that. So we worked with the military to design what we call an energy absorbing seat design. As the vehicle gets blasted up off the ground, the seat's designed to absorb that energy and that force from the blast and the movement of the vehicle and help protect the soldier's spine. We also, as I said, do a lot of work with the NHL. We work with the Department of Player Safety there, the National Hockey League. We look at the equipment, we look at helmets, trying to help prevent concussions, skate guards, how to prevent cuts and injuries due to the skates. One of the big things we did was actually redesign part of the rink. It used to be at the player area. At the end of the player area was a 90-degree stanchion of plexiglass. And what was happening was players were getting checked into the boards at the player area and then slamming up against the glass. And they were sustaining head and cervical injuries. I've mentioned before, it was actually the Boston and Montreal that caused the NHL to take a look at it, the hit of Chara on Pacioretty. He sustained a concussion and a cervical fracture. So they gave us part of the rink to the Winter Classic, the outdoor contest, and we used crash test dummies, hybrid 3, 50th percentile male dummies, and threw them into different configurations of glass. And ultimately, the new design that we developed is a curved piece of spring-loaded Lexan or plexiglass. So now when the players get checked into the boards, it absorbs that impact and they glance off of it. And it's helped prevent and pretty much mitigate any type of head or neck injuries as a result of player interaction at that part of the rink.
Hockey players tend to be pretty big guys, right?
They do, yes.
You said you used the 50 percentile hybrid 3 as a crash test dummy in ATD to do your work in furtherance of the NHL contractor commission, correct?
That's correct.
Did you need to use a hybrid 3 that was the same size as these big, tall, 6'4", 230-pound hockey players?
No, not at all.
Why not?
There's a 95th percentile male dummy, which not many people have or use. The 50th percentile male is basically the gold standard for crash test dummies. And you're probably most familiar with it if you see automotive manufacturers and the ads on TV where they put the crash test dummy in the car and run them into walls and flip them over. Well, they use the 50th percentile for all of those tests. And then they scale the actual injury assessment reference values to different size people. So they record the force off of that, and they might say, well, for the 50th percentile average person, you can sustain 180 Gs of acceleration to the head before you see a severe injury. And then they'll scale that and say, well, the hybrid 3 has to record, say, 300 Gs before someone twice that size gets hurt. So you just use one size dummy, and then you scale that to whatever size person you're looking at or you want to actually investigate.
Is that undertaking of mathematical scaling, is that an industry standard in biomechanics?
Absolutely. And I mean, it's set forth in NHTSA, the National Highway Traffic and Safety Administration. They set, well, the government sets the Federal Motor Vehicle Safety Standards, and that's all the crash tests that vehicles have to go through. And during those tests, they have to ensure that the values on the dummy, on the head, on the neck, on the spine, on the arms, are below certain values to ensure that they're safe at specific speeds. And they scale, they have a certain papers, a lot of papers actually, which talk about scaling the values for different size people.
Is that an accepted methodology in the scientific community?
Oh, it certainly is, yes, sir.
Dr. Rentschler, do you specialize in any particular research and analysis at ARCA to evaluate the relationships between crash injuries and crash forces?
I do, yes.
What about kinematics?
Kinematics is one of the specialties, yes, sir.
Fancy word, probably nobody knows. I didn't know it before I met some of the folks involved in this case. What does kinematics mean?
Kinematics is just motion of the human body. So it's looking at how the body moves in different situations. Whether you're in a vehicle and it hits a wall, how does your body move? It moves forward. Will it load into the seatbelt? Does the airbag deploy? Or if you're a pedestrian and you're struck by a car, how does the body move as a result of that interaction? That allows us to look at the loading to the body. Forces are exerted on someone's body because their body's loaded by different objects or different forces. So kinematics is one of the first steps. If you're going to look at injury causation, you have to determine the kinematics of an event.
What are human tolerances?
Human tolerance is really just looking at how much force it takes to cause an injury. So there's been generations of testing to look at different forces. For instance, the humerus, the upper bone in your upper arm. How much force does it take to cause that fracture? They've tested the cadaver bones. There's a lot of research for decades out there looking at different parts of the body, the ulna, the radius, the two bones in your forearm, skull fractures. Almost any type of injury, again, has an injury mechanism, and in order to determine how it occurs, we have to look at tolerance. How much force can the body withstand before you start to see a specific injury occur?
Doctor, how long have you worked at ARCA?
I've been with ARCA now for about 17 and a half years.
How many cases have you been a part of in terms of investigating or conducting crash injury analysis?
Over my whole career, probably thousands of cases. I've been doing this since 2004, so for about 21 years total.
Dr. Rentschler, are you able to estimate how many of those cases that you just talked about, those potentially thousands of cases, have involved motor vehicle pedestrian circumstances?
Oh, I'm sure over the year there's been hundreds of cases. A lot of them are motor vehicle accidents, but certainly a large percent's automobile pedestrian type impacts.
What education, training, and background qualifies you to perform the duties that you just told us about as the Director of Biomechanics and Human Factors at ARCA?
Well, I got my BS in mechanical engineering with a minor in biomedical engineering from Carnegie Mellon University in 1995. I then went on to get my master's in bioengineering and biomechanics from the University of Pittsburgh in 2002. And then I got my PhD in bioengineering and biomechanics from the University of Pittsburgh in 2004.
2004. Thank you. Are you a member of any professional associations associated with your field?
I'm a member of SAE, the Society of Automotive Engineers, as well as the American Society for Mechanical Engineers, ASME.
Are you also a reviewer for an outfit called Archives of Physical Medicine and Rehabilitation in Biomechanical Engineering?
I have. I've done peer-reviewed articles for those journals before, yes, sir.
When you say peer-reviewed articles, you're the peer reviewer?
That's right. If you want to submit a scientific article to a journal, you'll write that manuscript and then submit it to the journal, and then they'll send it out to other experts or peers in that same field, probably 3 others normally. And then they'll review that transcript, send it back with any suggested revisions. And then usually the author will make changes, send it out again, and that's how it gets accepted. Usually it goes through several different iterations before a paper is actually published.
Have you received any additional training following your PhD, formal training or otherwise, in the field of biomechanics?
I have, yes.
Describe some of that for us, please.
Throughout the years, I've taken classes through the NTSB, National Transportation Safety Board, as well as SAE, as I said, Society of Automotive Engineers, and at different universities, Virginia Tech, different seminars and classes with respect to biomechanics.
Is that normal to, even for someone at your education level, a PhD, to take continuing education to stay up on issues in your field?
It is. You take continuing education and then also just working with your peers. And when you work in a certain company, for instance, at ARCA, we don't do just litigation, we do the research and development. We have an epic sports branch at ARCA where we look at sports performance of athletes, how to help them perform better, whether you're a baseball player or volleyball player. So it's really the experience and the work that you do that also helps keep you up to date with technology and the different aspects of that field.
Does some of that additional education include biomechanics of high impact injuries that was offered by the NTSB?
Yeah, that's correct, yes.
Methodology and techniques of crash data retrieval offered by IPTM?
Correct, yes.
What is the IPTM?
That's the Institute for Police Technology and Management. It's actually a school down in Jacksonville, Florida, that offers basically vehicle crash reconstruction and biomechanical classes.
What about human factors in traffic crash reconstruction, also offered by the same outfit?
Yes.
Did you take a course in automobile safety and injury biomechanics from, is this the one from Virginia Tech?
That's correct, yes.
Okay. Did SAE offer a course in injuries, anatomy, biomechanics, and federal regulations?
Yes, that was in Detroit, I think, where SAE is based.
And you took that seminar as well?
Yes.
What about vehicle accident reconstruction methods offered by the SAE?
I've taken that class before, yes.
Linear momentum analysis offered by CAARS?
That was, yes, in a class out in California.
Motor vehicle accident reconstruction offered by SAE?
I've taken that class as well, yes.
Advanced collision investigations out of California law enforcement?
I believe that was a 2-week class I took. That's the introductory class that they give to the sheriff's department and police officers out in California.
And what about the post-collision passenger vehicle inspection and seatbelt analysis offered by CARS, CAARS?
I've taken that as well, yes, sir.
Have you published in peer-reviewed articles and book chapters? You said you were a reviewer. Have you actually published yourself along with you and your colleagues?
I have published, and that was mainly when I was in graduate school, doing graduate work. I worked at the Human Engineering Research Lab. We helped people with disabilities, so we looked at people in wheelchairs, manual wheelchair users, looked at the forces acting on the arms, how to help reduce injuries, rotator cuff tears, carpal tunnel syndrome, things such as that. So I did publish primarily when I was in graduate school at the University of Pittsburgh.
When you were in graduate school, approximately how many publications did you participate in, either yourself or with colleagues?
Probably 10 or 12 papers and then some abstracts and I believe a book chapter as well.
Have you been qualified in other courts to testify as an expert in the area of biomechanics and accident reconstruction?
I have, yes.
Approximately how many times?
Oh, I've testified throughout my career probably over 150 times in both state and federal courts throughout the country.
I want to talk to you for a second, Dr. Rentschler, about how you began working on this particular case, the case that's before the bench. When were you initially retained in connection with this case?
We were initially retained, I believe it was for the first trial. It was, I believe, maybe it was the fall prior to that actual trial that was last year.
All right. When you were, by the way, initially, were you hired by the defense?
No, we were not.
Were you hired by the Commonwealth?
We were not, no.
Was that a separate agency that hired you?
It was, yes.
It wasn't an insurance company, was it?
It was not, no, sir.
Okay. What were you initially asked to do by this separate entity?
Initially, we were kind of constrained in what we were asked to do and to review, but we were asked to evaluate whether the injuries sustained by Mr. O'Keefe were consistent with being struck by the Lexus.
And who at ARCA was assigned on the team to undertake this commission?
There was myself, Dr. Dan Wolf, and I believe Mr. Scott Klein was another engineer who was involved.
And did all three of you join in the analysis that ultimately ended up in a report that you authored, or the three of you authored together?
We did, yes, sir.
What materials did you review in furtherance of your initial consultation in this matter?
Obviously, I looked at the medical records. We looked at photographs of the vehicles, information about the vehicle, photographs of the actual incident scene, various information pertaining to the Lexus itself.
You know who Dr. Dan Wolf is?
I do, yes.
Is that the other person, the Dan Wolf, the Dr. Wolf that you just mentioned?
That's correct, yes.
Did you and Dr. Wolf look at basically the same set of information? You were provided the same set of information?
We did, yes. We were provided a tranche of information that all three of us looked at, yes.
Can you explain the difference between your area of expertise and Dr. Wolf's area of expertise? I don't want you to get into his analysis, just what area he covers. In other words, you're dealing with a Lexus and a pedestrian, Mr. John Doherty, correct?
Correct, yes.
What's the difference between the analysis that you undertook and the responsibilities of Dr. Dan Wolf?
So Dr. Wolf really concentrated looking at the vehicle itself and the damage to the vehicle, the damage to the taillight, which is really the only damage we have to that vehicle. And so his analysis pertained to evaluating the force associated with producing that damage, what's consistent with causing that type of fracture and damage to the taillight itself. Whereas my part of the investigation was really looking more at the injuries and looking at Mr. O'Keefe and his kinematics and his alleged or any interaction between him and the vehicle, and whether that would be consistent with his injuries as well as the damage that we see to the Lexus as evaluated by Dr. Wolf.
Did you ultimately issue a report, an initial report summarizing your opinions and your conclusions following your analysis?
We did, yes, sir.
About when was that report issued?
I believe it was sometime in February.
February of what year?
It would have been February of last year,
Okay,
2024.
2024, okay,
Correct.
thank you. Were you able to provide an analysis, given the information that you had, were you able to provide an analysis for the biomechanical aspect of the analysis of the case?
I was, yes, sir.
All right, did you review medical records and other materials?
I did, yes.
Did you make note of anything with regard to Mr. O'Keefe's injury or injuries based on what you reviewed initially when you began your analysis?
I did, yes.
Can you describe what you noted in terms of Mr. O'Keefe's injuries?
There were really just two basically different areas of injury. There was injury to the head. There was a laceration on the rear kind of right occipital region of the head, which resulted in fractures, an occipital skull fracture, which is the rear part of your skull, as well as basilar skull fractures that propagated up through the skull. And then there were injuries which were noted or diagnosed to be superficial abrasions along his right arm.
What is a subscapular hemorrhage?
Subscapular is?
Yes.
Yeah, with respect to the head, is
Yes,
that what? Yes,
as it relates to the head.
Yes, well, so when we talk about there's subarachnoid, there's pia hemorrhages, but basically they're hemorrhages, and scapular is hemorrhage under the scalp, but above the skull. So subdural is within on the surface of the brain, but scapular means that it's a hematoma or bleeding that occurs under the scalp but above the actual skull.
Did you note subscapular hemorrhage in your analysis of Mr. O'Keefe's injuries?
There was, yes, I believe there was extensive subscapular hemorrhaging.
What about skull fractures?
There were, as I described, occipital skull fracture in the back of the skull that then propagated forward the calvarium as well as the basilar or the base of the skull.
You mentioned subdural hemorrhage as one of the issues that you would look at normally. Did you note whether Mr. O'Keefe suffered from subdural hemorrhage?
He did, yes. He had sustained subdural hemorrhage as a result.
And also subarachnoid hemorrhage?
Correct, yes.
What about bilateral orbital ecchymosis?
He did, yes, bruising along the eyes, basically.
What does bilateral mean? Both?
Bilateral means left and right, correct.
Did you note a 1 centimeter or approximately 1 centimeter laceration to the upper right eyelid?
There was, yes, 1 centimeter, yeah, and so, that's a little less than half an inch laceration right above the right eye.
What about abrasions to the anterior and left aspect of the nose?
There were some abrasions on the nose, and then I believe a few lacerations as well.
Laceration on the right anterior tongue?
The tongue was lacerated, yes.
You noted, with regard to one of Mr. O'Keefe's extremities, abrasions along that extremity.
Superficial abrasions, that's correct, sir.
Describe which arm we're talking about and what part of the arm.
It was the right arm, and it was from the forearm up towards the top of the shoulder. And there were various abrasions, what were diagnosed as superficial abrasions along that kind of posterior aspect of the arm, the elbow, forearm, and the upper arm.
When you undertake an analysis, do you use biomechanics and kinematics both to try to evaluate whether or not a specific set of injuries are consistent or inconsistent with a proposed set of facts? Or I guess I'll just leave it there, a proposed set of facts.
Yeah, I mean, those are basic steps to look at how an injury occurs. I mean, first you have to identify the injury, and that's by looking at the medical records and determining what the diagnosed injuries are. And then you have to determine the kinematics and the kinetics associated with a certain event. So how did the person move? How was their body moved? Did they interact with anything? And how did that result in loading or force being applied to the body? Those are basic steps of a biomechanical injury causation analysis.
How did you go about undertaking those steps in this particular case?
So in this particular case, we looked at how those injuries are actually produced or created. So occipital skull fracture, you need a sufficient force. You need a force of around maybe 1,400 or 1,600 pounds applied at the back of the skull to actually cause a fracture like that. The abrasions, superficial abrasions, and an abrasion is basically rubbing or scraping or friction that kind of scrapes away the top part of your skin, the epidermis. You have the epidermis, the dermis, and then the hypodermis. An abrasion is just gets into the top epidermis and doesn't get any farther. Laceration is an actual tearing or ripping of the skin, usually down past the epidermis into the dermis. And so that takes either a blunt object or a sharp edge, depending on whether it's an incision or laceration, to actually produce that type of an injury.
Did you look at patterns of injuries on Mr. O'Keefe?
Yes.
Did you also, the other side of that handshake, did you also look at damage to the vehicle, physical damage to the Lexus?
We did, yes. our goal or what we were tasked with was to determine whether the injuries are consistent with the damage to the car. So clearly, you look at how these injuries are created, what injury mechanism you need to produce them, and then you look at the damage to the car. Can you line up contact between where those injuries occurred and how they occurred with damage to the vehicle?
What kind of materials did you review, in addition to, I'm guessing, photographs?
Photographs, yes, autopsy photographs, as well as photographs of the vehicle and the damage to the Lexus.
What about medical records, hospital records, things of that nature?
Absolutely. That's the first step, looking at the injuries to find what the injuries are, what are the diagnosed injuries, as well as it's important to determine what injuries don't exist, because that's also helpful in determining whether certain impacts may or may not have actually occurred.
Did you receive a full file from the medical examiner's office in this case?
I did, yes, sir.
Did you also receive police reports, follow-up reports, witness statements, things of that nature in this case?
We did, yes.
Did you receive any data concerning the vehicle itself, contained either in police reports or follow-up reports or expert reports?
We did, yes.
Mr. Jackson, I'm just going to ask you to slow down
I'm
the
sorry.
cadence of your voice a little bit.
It's late in the day and I'm doing it again, aren't I? I'll slow down. I forgot where I left off, but let me ask you sort of openly, was there anything else that you considered and analyzed in at least building a database from which you would build an analysis?
Well, yeah, I mean, we review all the materials that are provided to look at all the injuries, to look at all aspects of the vehicle, damage to the vehicle, information about what the vehicle may have been doing. Any other evidence that may help contribute to looking at what either caused the injuries or what may or may not have caused the damage to that vehicle.
When you and your teammates undertook this analysis, did you even know who we were?
Initially, we did not. No, initially, I personally didn't know anything about the case. And we were asked not to do any research or to look up anything about it. We were given certain parameters, certain information, and that was it.
Did you follow those instructions?
I did, yes.
The undertaking, the analysis that you did, was it in keeping with the accepted methodology or methodologies in your field of engineering?
It was, yes.
Did you ultimately reach some opinions and conclusions based on that initial investigation or analysis?
I did, and we did it at ARCA, yes. Myself, Dr. Wolf, and Mr. Klein did.
Did you reach any opinions or conclusions with regard to the force required to produce the occipital skull fracture that you noted with Mr. O'Keefe, his head being struck by the rear tail lamp of the subject Lexus?
I did, yes.
Tell me what those opinions and conclusions were.
Well, again, we determined by looking at research and tolerance values that it would take about 1,400 to 1,600 pounds of force to cause an occipital skull fracture. Now, we were tasked with looking at, again, could that result from impact with the car? So one of the things we did is we took a head form, the head from a dummy basically that's instrumented with accelerometers, and we dropped it onto a taillight cover to attain a speed of 15 miles an hour. And so that would be comparable to the vehicle striking the head at 15 miles an hour. And I concluded a few things from that. A, that the force wasn't sufficient, or the acceleration wasn't sufficient to produce enough force to cause a skull fracture at 15 miles an hour. And also, when you look at the position and configuration of the occupant, it really wasn't possible to get a skull fracture by hitting the taillight and not sustain any other significant fractures. For instance, where the taillight's positioned to have an impact to the back of the head, you really couldn't have someone positioned in such a manner to strike just the head and not have subsequent concomitant injury to the neck or any other part of the body. So my findings with respect to the skull or the occipital skull fractures was that it likely did not occur as a result of contact, specifically with the taillight cover on the rear passenger side of the Lexus.
So as to the question of whether Mr. O'Keefe suffered the occipital skull fracture as a result of being hit by the tail lamp at 15 miles an hour, were you able to scientifically rule that out?
I was, yes, sir.
Was that to a reasonable degree of scientific certainty?
It was, yes.
Did you reach any opinions or conclusions regarding the abrasions on the right arm that you noted earlier on Mr. O'Keefe's body?
Yes, I believe my conclusions with respect to the abrasions are that it was inconsistent with contact to the tail light, and that not only that those injuries are inconsistent, but you would expect additional injuries, likely fractures to the hand and or the forearm, depending on the actual speed of the vehicle.
Other than the expectation that you would see fractures or other damage to the arm, what was the basis for your opinion that the linear abrasions would not result from impact with a non-damaged taillight traveling in reverse?
What you have to look at the kinematics associated with that, and that in order to get just superficial abrasions, that doesn't take a significant amount of force, but essentially that to have an arm contact the rear of the car, and we weren't really given any theory of how the arm contacted the car. So initially, we weren't privy to any theories or allegations of how this may occur. So just generally speaking, looking at the arm, how it would contact the car, and subsequent movement and interaction with the light cover, my opinion was that the injuries would be inconsistent, or the injuries that Mr. O'Keefe sustained on his right arm and didn't sustain would be inconsistent with actual interaction with the taillight.
Doctor, were your opinions and conclusions, along with those of your colleagues, reduced to a report?
They were, yes, sir.
Was that report, to your knowledge, ultimately turned over to both the defense and the Commonwealth in this case?
To my knowledge, it was, yes, sir.
I'm going to change gears for a second and bring us forward to the spring of 2024, after February of 2024, moving into the start of 2025. Did the defense at some point reach out to ARCA and contact you and Dr. Wolf?
They did, yes.
That was back in 2024 after the spring, correct?
That's correct, yes.
At some point, did the defense engage you specifically to testify?
Yes.
This year?
This year?
This year, meaning
Yes.
this trial?
For this trial, yes.
Okay.
Yes, correct.
Were you asked to conduct further testing in furtherance of your potential testimony in this trial?
We were, yes, sir.
And were you provided additional materials from the defense in furtherance of your potential testimony and your testing?
We were, yes, we were provided additional material with respect to, yes, the theory of how this may have occurred and how Mr. O'Keefe may have sustained his injuries, allegedly.
Included in the materials that you were provided in anticipation of your testimony in this case, in this trial, were you provided anything from a company called Aperture?
We were, yes.
What were you provided from Aperture?
We were provided a written report from Aperture, a PowerPoint presentation, about 140 some pages from Aperture, and then a file material, I believe, what was reviewed and the results of some testing that Aperture had conducted with respect to this case.
Was it your understanding that the Aperture PowerPoint was authored by a particular individual?
Yes, sir.
Who authored that PowerPoint as far as you knew it?
As far as I'm aware, it was Dr. Judson Welcher.
Your Honor, may we approach briefly?
Okay.
Anything stand out to you guys here? And by the way, Kate is on her way back, and she should be able to get up the camera can soon.
I'm back.
Oh, Kate's
Sorry,
back.
I'll get
Okay.
it.
All right.
Yeah, I'm back.
Kate's adjusting to her emotional day.
Yeah, right. My dog is fine.
Oh, good.
Oh man, but I did have to get him poked and prodded with needles, so he's probably pissed off at me. But it's just a
So-
lymphoma.
Kate, I have a question for you. Now, missed Dr. Scordibella's testimony. I think that was one of the days that I was in the hospital. I watched every bit of it last year and rewatched it for the book several times. My understanding was there was no x-rays. And now, at least today, for me, the first time.
I do too. I'm so confused.
So what is going on here? Who took these x-rays? When were they taken? Why are we just learning about them now? Why didn't nobody use them? I don't understand.
I don't either.
I mean, if the
I'm
x-rays
confused about that too. Yeah.
Like if they showed no broken bones, why didn't the defense use them last year? I'm baffled.
I don't know. How much does it really move the needle at this point? I don't know.
I'm just trying to understand for my own reputation, because many times I got on the show and explained that usually in autopsies in this country, x-rays are not typical. And that's what the research I found was, but it depends on where you are. In Europe, they're more typical. In Japan, they're more typical. But so I falsely told my audience that for a long time, and it turns out there were x-rays. I'm just stunned. But
no, I was surprised by that too. And then, wondered the effect that it has. But I think, again, a car collision is not guaranteed. It's just too much other stuff they have to get over.
Right.
And I guess, sure. So she disputes the hypothermia, which I don't think is going to land on the jury because it makes no sense, right?
Right.
Even if we decide, okay, well, she kept saying too, he didn't die of hypothermia. Like, okay, nobody's saying that. We got that. But it still places him outside for, what'd she say, 4 to 5 hours? Right.
But one thing quickly, her testimony about how come his extremities didn't have frostbite, I think that might resonate a little bit with the jurors.
Yeah.
Right.
it was also clear from Dr. Rensler today that they never considered, even as a possibility, the ground causing the head wound. And this is something that Hank's going to point out. They only considered the vehicle striking John in the head, which is something I only considered back in that time too. But I'm not an accident reconstructionist. They are. They should have considered all the possibilities. And it also goes back to the deep corruption of Josh Levy and the feds here, because the the Norfolk County DA's office reached out with multiple letters to the feds, to the U.S. Attorney's office, and offered to give them what evidence they had. They would have shared their own theory on the case. And the arrogant feds just completely ignored those letters. So they could have had that evidence and could have shared that with ARCA, but they didn't because of the feds. The feds, it's hard to really overestimate how much damage the federal government did to this trial in this case. It's unbelievable. And need to get to the bottom of why.
Yeah.
You know, was there some corrupt connection between Karen and somebody on her team and the U.S. Attorney's Office? Was it that? Was it the matter of just they duped Josh Levy, and then once he was in, you know, and he maybe it tells us something about the way he always conducted his office, that there was a little bit dirty there, and they didn't think the rules applied to them. And you know, you get the arrogance sometimes at that level of power, you know. And so he had people that were his closest cohorts in the U.S. Attorney's Office violating protocol and communicating very closely with Karen's team, and even communicating with Dr. Wolf. And you noticed how Dr. Rensler here said, I didn't break the rules. He was because he knows Dr. Wolf did. Looks like they're coming back soon. So I got in the mail the other day, somebody named Lynn, who I don't know who it is, and it didn't give me a way to message back, but thank you, Lynn. She sent me, it says, welcome to the cottage. I don't know if you can see this.
Oh, that's nice.
Thank you for the thought. This would be nice at the Cape too, right? Right, Margaret?
Yeah, that's super nice. You know.
Yeah.
So they've gone to sidebar.
That's awesome.
And back to sidebar again. Margaret, Joe is on tonight with us. Joe is on. So we do have our usual.
Oh, okay, well, that's
Joe.
good. Yeah.
Yeah,
that's
me,
good.
Joe, Pete, and Nick. They keep.
Yeah, I'm on with Wayne.
Oh, you're on with Wayne.
He's
Wayne
the
is a really nice
podcaster.
guy.
Yeah.
He's a really
he
nice
is
guy.
a nice guy.
I'm sure
he's
Peter
from
is
the
too,
Midwest.
you know. Yeah. Okay, I'm
Yeah.
sorry. Go ahead.
I think Wayne's from the Midwest or something, right?
I don't know where
Unless
he's
I'm
from.
thinking
I
of
thought he
somebody
was.
else. He has an accent.
I always thought he
Unless
was more local. But,
Okay,
yeah.
maybe I'm thinking of somebody else.
So
But
Joe's
want to
got
hear
us
my
on
questions?
schedule. We picked up a lot of time today. I think it was because we did spend less time at sidebar and less time doing things outside the presence.
Didn't feel like it.
So we're back
No.
on track, and we're going to let you go for today, and we're expecting a full day tomorrow. I can tell you,
good.
the lawyers tell me that we're definitely winding down. Okay, so please, those same 3 cautions, do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. And please continue to be very careful with your social media use. So we'll see you ready to start at 9 o'clock.
Kate, while you were gone, WCV, somebody was posting that Channel 5 WCVB was describing how the jurors were really frustrated during the last couple of sidebars. Like one of them, they're banging their heads on the and just really visibly frustrated.
Right.
Clutching of pens.
Yeah,
Clutching
yeah,
of
weird clutching of pens. And so the question was, does that help the defense? Does it help nobody? Does it help the prosecution? Do you have any thoughts on that?
I mean, I think it's probably going to help the prosecution when Alessi does process Welcher. Like,
You're
right?
all
Like,
set, Dr. Rensler. I
Thank
should
you.
have told you, I'm sorry.
So we'll see you tomorrow morning as well. So
Thank you. All right. So first of all, anybody object if I give Ms. McLaughlin back the paperwork on the State of Rhode Island versus Michael Patino transcript or whatever she was giving me? Any objection to that? All right, thank you. All right, so Mr. Jackson, for purposes of your edits, so the text will be removed from 5, 6, 8, 9, 23. The word measurements, I think, is perhaps the only word there. 24, 31, 32, 33, 34, 46, 47, 54, 55, 56, 58, 66, 67, 68, 69, 71, 72, 73, 74, and 75, and 76. Separately, pursuant to what will be an upcoming evidentiary ruling on whether foundation has been made, if you could separately have a way to exclude, if it becomes appropriate based on whatever ruling, based on the foundation that you're going to attempt to put, slides 9 to 23. Now, as I said to you at sidebar, once you do this, or if you talk to the Commonwealth, if there's no objection to some of those numbered slides that I said needed to be edited, if the Commonwealth agrees that they come in, you can go ahead and put them in because I would allow them if it's by agreement.
Thank you.
Okay? All right. So do you expect that we will finish with Dr. Rentschler tomorrow?
I do, Your Honor.
Okay, Mr. Brennan?
I don't think I'll be as long as I was with Dr. Wolf,
Okay.
depending on how it goes. If he has an hour and a half, I expect I'll probably be about an hour, maybe an hour and 10 minutes.
Okay. All right. And then we'll figure out where we are Thursday. It seems that the case may be ready to go to the jury Friday, maybe Monday at the latest. But that's,
By Monday. Based on our sidebar
does that seem like a fair estimate to you, Mr. Brennan?
I think we can be ready Friday.
Okay. All right. So we'll see. Okay. All right. Thank you. We'll see everybody tomorrow morning. Yes.
Should I have Dr. Welcher in court tomorrow or wait till Wednesday?
Um,
Oh, tomorrow's Wednesday.
tomorrow's Wednesday already. Can we, Mr. Jackson, can we reevaluate that mid-morning or the luncheon break and see where we are, whether we need Dr. Welcher here in the afternoon?
Of course.
Okay. All right. We'll do that.
I think Mr. Alessi would have one issue he wanted to address the court.
Yes, Your Honor. With regard to various exhibits that Your Honor said would be admitted based upon the issue that we had with regard to the Exhibit 88, Your Honor said you would...
Yes. We'll put those into evidence.
Thank you very much.
Okay.
That was the only item pressing for today.
Yeah. I said yesterday they'd come in. They're coming in. Okay. So those will be in evidence. Mr. Brennan, you were on notice yesterday that I was letting those in. Okay. All right, we're all set. We'll see you tomorrow.
All rise for the court, please.
I think Alessi, with his style, tends to
Goodbye.
wear down the judge. She's going to let things in just so he doesn't go on for an hour.
Maybe.
Oh, God. I'm telling you, he's the worst. The worst.
All right. So we're glad that things are okay with Kate's dog, first of all. And
Yeah,
I was
totally.
not able to I have not been able to confirm the tragedy that was with Matt, if it's actually real or not. But if it is, if Matt is in any way paying attention again, I personally really appreciate the work you've done for this channel. I enjoyed listening to you when I was laid up in the hospital, but I hope things are going well with you. I don't know if anybody's confirmed that. You can tell me privately.
I don't know. I haven't spoken to Matt.
Yeah. It may explain why we haven't seen him as much the last week or so. So, all right. Anybody else have any observations or comments about today?
It was a cluster. Today was just a mess, I felt.
Yeah.
I think that probably Dr. LaPosada is the most effective witness that they've had thus far.
Yeah, I think so. And I think that's why it's so important to bring a rebuttal witness up on this. I have no idea if they plan to, but I think it's necessary.
I don't know that they're entitled to a rebuttal witness because it's like they had their medical examiner that said one thing.
Yeah. Right.
They had theirs that said another. This happens all the time. It's
Right.
just
So it would
last
only
year
be if
Dr.
something
Doherty
new
was
was introduced, right?
Yeah, I mean, again, people are looking at reasonable doubt, like one thing can either make or break an entire case. And I don't think that's true most of the time, right? Because it's like, in order to just hang your hat on, his arm wasn't broken and this doctor thinks he didn't have hypothermia, you have to disregard a huge volume of evidence, right? And again, when you're going through, and I know these are note-taking jurors, so I'm sure they took notes when he went through great pains with Dr. Russell about how you can hit a group of people with your car and each person's going to walk away with some with just a scratch, others with, life-threatening or fatal injuries right there. So,
Could this be part of the reason why they didn't bring on Rich Green? So that the defense, so the prosecution couldn't bring on a rebuttal to that, because that would have been information the jury hadn't seen. What do you think, Margaret? Yeah.
I don't know. I think Rich Green just doesn't stand up to the two witnesses that Hank brought in already. No way.
And it wouldn't have been new.
It wouldn't have helped. It wouldn't have been new. It just would. They had to let that piece go. The 227.
John is reporting, asked about no arm fractures noted on O'Keefe, and Welcher said there were no fractures noted in the autopsy report, but they didn't actually x-ray his hand or arm. But we looked at x-rays of his arm. Right there. So I don't know.
Yeah, I have no idea where these x-rays, why we're just hearing about this now.
I'm so confused.
It's like so much about this case that just ends up being baffling. On all sides, between the way the prosecution handled it last time and this time, the way the defense operates, just the whole thing is baffling. And I don't know. And frustrating. I mean, not that this trial is staged for us, it's obviously not. But I mean, if this sunlight is the best disinfectant, the public should be able to see at some point what's out there. And it's really strange when key evidence like that doesn't come out. Mm-hmm. I tried to take a nap earlier during lunch for about 15 minutes, and I had the window open, and I could hear a little dog out back, and I was like, "Is that Alessi?"
Oh God!
So Green wouldn't have been. They wouldn't have had a rebuttal on Green. I think Margaret's right that they just,
because they already had
that was done.
They
wouldn't be in. But all the time. You have two competing medical examiners. Yes. I think a lot of the time they just cancel each other out.
Right. Ends up being a wash. Yeah. My only worry is it was quite a while ago for this jury when they heard someone like Dr. Wolf, the neurosurgeon. And I didn't hear this time, Dr. Scordi-Bella, I really can't remember how in the first trial she was not very effective. Almost seemed hostile to the prosecution. I don't know if it was any better this time. Was it better this time? When you guys watched it?
I don't think she's hostile. She's a brisk person, like just kind of.
Yeah.
gruff a little bit, but I think she does her job. I think out of the two of them is clearly the more neutral and professional one.
Yeah.
And this is kind of what harkening back to most juries already have sort of a natural distrust, I think, of a lot of witnesses that particularly the defense, because they're going to be self-serving by nature versus the Commonwealth has to provide everything,
Right.
that any test they get, anything to do with the case, they have to give it right over to the defense, and the defense can pick and choose. So you kind of have to overcome that anyway. It would have been nice to see a little bit more, because she's had some issues in the past with this, kind of being outed as a hired gun. That would have been nice to come out. But I think that I think one of the most devastating things that she did was when she kept insisting he wasn't hit by a car, right? And Hank was able to go, "Oh, you already formed an opinion before we began," right?
Right. Would it have been normal, Margaret, for Hank to have asked her how she became involved in the case, whether or not she reached out to the defense or the defense reached out to her? Would that have been normal?
It is most likely that the defense reached out to her.
Because Dr. Russell, for instance, reached out to the defense.
That was different. Usually that doesn't happen. So Hank must, through discovery, Hank must know that the defense reached out to her.
Okay, right.
I think then it would have been brought up during cross-examination. Well, you were watching this trial and you reached out.
Right.
So I think it's pretty clear that the defense hired her as a hired gun.
Well, like you said earlier, Margaret, what a gift for her to start out her testimony by correcting him on the good afternoon. That just showed the hostility, that she is kind of a typical defense witness there, where she's all in on the defense. She's going to do everything she can to help them. And I just think also her testimony that John would have died, she's so certain within 15 or 20 minutes, is so bizarre and is such in contradiction to what everybody else says on this. Certainly what the neurosurgeon testified, that John could have been saved. So, I hopefully the jury remembers that.
The state's case at all, though. Again, because right from the beginning in opening statement, Alan Jackson has set up an alternative theory. So the burden's on the Commonwealth for sure, right? That's the law. But you risk a certain degree of burden shifting when you come in hot and say, no, this didn't happen, this happened.
Right.
You have to remember why they're doing that. They're doing
that. No,
that.
that's what I'm saying. I'm agreeing. Right. That's what I've been saying. Yeah. I'm sorry, go ahead.
No, but because they don't have another option because of all this evidence, right? That you can't really overcome without some sort of explanation as to how it was planted there. Because if it wasn't planted, what the hell? And they haven't been able to get there at all. There's absolutely nothing that's come in that would suggest any sort of evidence planting. Quite the contrary. So we're stuck with all of this evidence, which everybody is they're basing their conclusions around the evidence of the scene. They're accepting it as fact. Nobody's challenging that, right? So, you come in with a couple, well, no, I really don't think he was that hypothermic. Fine. Okay. I think he could have survived in 15 minutes, no, an hour. Either way, the facts that we're left with is that everybody agrees that as soon as he sustained that injury, he was incapacitated, could not move, do anything productive for himself. Everybody agrees that his phone stopped moving at 12:32, and everybody agrees that it was found under his body in the morning. That stuff you really can't get past. I understand. I think it's normal, right? I know it's normal that, your defense is going to be comprised of pulling in experts and having them give alternative theories or contrary, opinions. I just don't know how much it's going to move. And she was a fine witness. I'm not saying anything bad about her. There wasn't anything that really, struck out other than she's clearly an advocate. But I just don't see how much impact it really could have. If you've got one person that's hung up on the lack of, fracture to his arm with all this other evidence, you were going to have problems to begin with anyway. That's unreasonable.
Right. No, what I wasn't saying was in agreement with you. It's just kind of unusual that her testimony is so dramatically different from what Dr. Scortibella or Dr. Wolf, a very impressive witness, Dr. Wolf, what they said. Dr. Wolf said John could have been saved. And she's saying not only that he could not have been saved, but he would have been dead within 15 or 20 minutes. That's so dramatically different that it almost calls into question her testimony. I don't know if a jury will absorb it that way, but.
Well, and the medical personnel, the EMT people tried to save him.
Yeah.
So if he had died, if John O'Keefe had died within 20 minutes, then wouldn't the EMTs have looked at him and said, there's no
Right.
chance.
Right.
To
They're
save
professionals.
him?
They would notice this guy's been dead for 6 hours. Wouldn't they? See,
Yeah.
but I don't understand why none of that ever, I don't know. I guess Hank can explore it in his closing statements, but it just seems like some of this stuff should have been explored in cross. Like, why wouldn't EMTs, I don't know. I don't know. Maybe like there's always reasons for this. I'm not a lawyer, so I don't.
I'm not a doctor either. Or an EMT, but yeah, that contradicts what they said. Why would they bother to save him?
Right. If John died at 12:30, how would his body look at 6 when the EMTs found him?
Well, 12.
And Karen herself said he didn't look mortally wounded. So
I know. Well, let's see for a minute. So the impact occurs at 12:32, right? So then that would give it what, half an hour. So by 12:50, he would have been dead. It's a long time, right?
yeah. So let's say he died at 1, and then the paramedics arrived to treat him 5 hours later. That's a long time. What would that body look like if it was lying there in the cold, which might have preserved it to some degree, but still for 5 hours? What would that body, like Kate was talking about earlier, there'd be signs of I would think there'd be signs of rigor mortis by then, like very clearly visible signs.
I'm surprised Hank didn't cross-examine on that issue, because we're thinking about it.
Yeah, yeah.
I don't know if the jury's thinking about that.
I would think they would be, but
I'm
sure he has his reasons.
How much do you really want to push that, though? I mean, when that lines up to, the only other theory that and I mean, they've put, and I understand that opening statements are not evidence, but it lays out, their stance, their case. The defense has already said he was killed inside and then moved outside, and they don't have any movement past 12:32. How hard do you want to push on whether or not? I mean, she was very clear. He didn't die of hypothermia. He didn't die of hypothermia. Nobody ever said that he did. Like that to me, honestly, that's probably some of the most devastating, testimony that she gave on direct and on cross is that, number one, he was incapacitated immediately. Okay, so what's the only other evidence we have of his movements, right? This digital footprint. It stops at 12:32. So we know, where, and 12:32 is when she's backing up her car and she says she left him on the left side of the property. Okay.
Right.
Like how much do you really want to fight it? How much do you want to fight it? I wouldn't want to fight it that much. He really took that back, and there was something else that he had. Oh, the glass.
Yeah.
That could fuck her too. I'm sorry, but it's Karen's words coming in to wreck the day again, right? Whatever, because when he's asking about the glass and she admits, yes, that could have been caused by glass. As soon as she hears the defendant said that she pulled glass out of his face, and then he goes, well, would that happen if he was dead? No, it would not. Okay. All right. Yeah. Now the jury's here, and I'm sure that's going to be highlighted because now it sounds like Karen is talking about pulling glass out of his face right after it happened.
Right.
Whether or not that's true, whether that's what she meant, I don't know. But there's nothing to combat that.
There's nothing to say otherwise unless she testifies.
Right.
Yeah.
EK, we don't know. We were just, maybe you weren't here about 15 minutes ago, but we were just talking about these x-rays and we're baffled. We have no idea where they came from, why they weren't testified to before. Why did this come up in the first trial? We're baffled. So we're all 4 of us here are baffled by this. We have no idea why. And it's very, very strange. It makes you wonder what other evidence might be sitting out there that we don't know about. It's really bizarre. But we don't know the answer to it. It's like a lot of things in life, though. Just because we don't know the answer doesn't mean there isn't an answer. There obviously is an answer. There's a reason. We just don't happen to know it. Laura said medical guidelines mandate that attempts be made to resuscitate individuals found with a body temperature below 85 degrees. Thank you, Laura. That's good to know.
Oh, yeah,
Laura,
yeah.
And Laura is also the one that got us the picture. Her son is 6'2" and got us the picture of her son standing next to the Lexus of the same model, and how her son's hand lined up with the dent, just as John's hand lined up with the dent. And we learned that during the first trial because of Laura's work. Thank you, Laura.
That's Laura. Well, thank you, Laura. You were right. You and Trooper Paul deserve some credit.
Yeah. And your son, Laura.
Well, and your son, of course, your son.
I've got a question for Laura, actually. So, medical guidelines mandate that attempts be made to resuscitate injured individuals found with a body temperature below 85. But what's the lowest threshold? I mean, 1, 5? Is there
Right.
one? 0?
I don't know, but we also found out during the trial that they can't
Curious.
pronounce the victim dead until they warm the body up to a certain degree. So and that's why it took an hour and a half or so before John was pronounced dead. They had to at the hospital warm his body up, presumably up to 98.6, right? And then once they get it to that temperature and he's still not able to breathe or get his heart going, then they can pronounce him dead. Because we do know the cold, there's a lot of people that go into sudden cold, life can be preserved. Like someone falls through the ice, like a boy pretty famously falls through the ice into a pond and is at the bottom of that pond for an hour, and they bring him up, and an hour later they're able to revive him and he doesn't even have any major damage. So excuse me.
Which is hard to believe.
Right.
Well,
that's crazy, right?
To be fair, I've seen emergency services attend to people that appear by all means. They look like there's no viability of life. They look like they cannot support or sustain life, and they still work on them because there is that small percentile that it looks worse than it is. So I think most guidelines would be it's better to attempt than to not. So
might as well try. Yeah.
Right. Thank God, because there are a percentage of folks out there that wouldn't be here if it wasn't for those policies. So,
Did you see?
There's no question the X-rays are legit. We just don't know why we didn't hear about them before. But I'm sorry, go ahead, Kate.
No idea.
Did you see Karen's face yesterday leaving court?
Yes. She looked rough.
So, I mean, they got a little bit of what they wanted out of Lapisota, but I think that mainly what they wanted out of her was the dog bites. I think that's probably why Karen left so dejected yesterday. Like she literally looked like she wanted to control alt delete when she got home. Honestly, like that was a sad woman, and I don't really feel bad for her, I'll be honest, but I recognized just how devastated she looked, and it had to be because that had been disallowed, and they still didn't get the full breadth of everything they wanted, but I think that's a good indication, and how hard they fought for it. They're really hanging their hat on this dog bite thing, right? And of course we know the dog bite at this point, Rentler's their last witness, and then we're done, we're going into rebuttal, fine. The dog bite thing, I think, is dead, just in the sense that they weren't really able to introduce Chloe. They weren't able to introduce anything about Chloe's supposed bite history with the neighbor dog there. Like,
well, it goes back to, remember the juror that the one with the bow tie that goes around and talks about
Ronnie.
I know.
Ronnie.
It talks about the
like Orville Redenbacher.
20-story Ronnie, that one?
Ronnie.
Every interview does. Yeah.
But I remember early on, he said they were hung up on what exactly happened to John O'Keefe. So obviously, the issue is, has enough reasonable doubt been raised by the defense that, well, maybe it was a collision. Maybe it was some sort of, something else happened to him, but we don't know what. So, Ronnie
said that he would lean towards guilty this trial because of her statements.
He did.
Oh, yes, I didn't know that.
Okay, I didn't know that either, but
I
remember that being.
Yeah.
I remember that being a real
What you have
issue.
to understand about the jury thing is, so I've talked about this a little bit just because I follow both. So I obviously, and Margaret, I would be happy to fill you in later, probably, because I don't want to dominate this, but I'm very, very aware of the witness intimidation stuff. Very aware of it. Have been before even the police were aware of it. I'll put it that way, as far as like figuring out the connection of what was going on. Okay, so I'm aware of that. I'm aware of this case. Some people say I have kind of a Karen Reed encyclopedia brain, which is probably not that far from the truth at this point. So I'm very aware with everything, as far as like, everything going on. So I know that there is a pervasive pattern of both Turtle Boy's defense and Karen Reed's defense attempting to elicit false affidavits from people, going back to very early on with Steve Scanlon, right? So I'll preface it with that and then put an addendum on that. With these jury deliberation claims that they've made, they never produced an affidavit, not even signed anonymously by any jurors. There was nobody ever put pen to paper, put their name on it, nothing. This is all assertions from the defense that they acquitted on 2 charges without filling out the form, and that they were 9-3 according to the defense on manslaughter. I know, and Kevin knows, that this is categorically false because we happen to have information. We happen to have information that would indicate that there are at least 2 jurors that were unanimously guilty across the board, without getting into specifics about how we got that information or what it is. But it's pretty, it's pretty compelling. So I mean, and pretty direct. So that already, the version that Ronnie is giving out, what I truly believe happened in the first trial is that you had a handful, maybe only 1, maybe 2, maybe even up to 3, but a couple jurors that probably went in with their minds made up pre-deliberation. And I say this because of the information that I have. I say this because of how many times Ronnie has changed his story. And I say this because of the wording of the notes that were going up to the judge, particularly the last one, where the foreman made it clear that there were jurors that believed that the Commonwealth had surpassed its burden, and there were jurors that believed that they couldn't get there and that they would be compromising deeply held personal beliefs.
Right.
Get there.
Mark, I have a legal question for Margaret. So this, and maybe Kate knows the answer to this too, but certainly Margaret would. So I included in the book the standard jury instructions from a judge when it comes to reasonable doubt. Is there a choice that the judge has, or are there a couple she gets to choose from, or do they just all tend to use the standard reasonable doubt here? Because this is something that I'm kind of shocked by the lawyers that I see on court TV that all seem to be, it's almost like they don't understand like they haven't heard the instructions before or weighed them, because they seem to think that reasonable doubt, if you can, like, for instance, you'll hear this a lot. You're going to hear Wayne say this tonight. Tie goes to the defense. So if there's one particular topic on the trial and is a tie, so one expert on the defense says one thing and one expert on the prosecution says another, then the tie goes to the defense, and that's reasonable doubt, and you have to let this person go. Is there some range of choice that the judge has on reasonable doubt instructions?
I mean, it's pretty standard, the reasonable doubt instruction, but it'd be interesting, and I'll have to do this tonight or tomorrow, is to go back and see what Judge Cannoni read for reasonable doubt last time. But remember, it's a totality of all the evidence. So basically, if there's one piece of evidence where it's a tie, and the jury is allowed to consider other evidence. So exactly. If they just choose like, oh, I have a doubt on, I don't know, the dog bite or something. Well, they've got to look at it in totality. So she's going to explain that, and it's a long instruction. But maybe what I can do is I'll go back and see what exactly she's likely to use the same one.
She used the standard.
Okay.
Yeah, she used the standard. Yes.
Yeah.
I do remember.
So
that.
The reasonable doubt is not absence of all doubt, just the reasonable. I mean, the standard language. I looked up the jury instruction.
Okay.
Every time.
Yeah.
But yeah,
it's important.
Yeah. Well, it's really, especially to understand, because I mean, she's going to instruct the jury, right?
Yeah.
On the elements of the crime. And it's important to understand the elements, because I think too many people think like, oh, if we can create a question over here, that's reasonable doubt. And it's like, not if the question doesn't hit on one of the elements of the crime, right?
Well, that's true.
Right.
Mm-hmm.
So I like to keep kind of a running total. And like, so someone had asked in the comments what my prediction was. My prediction is still manslaughter. My prediction is still that I don't know that they're going to, I see how they could get to murder too, but I can see how that would be more in contention. I definitely think that manslaughter is a no-brainer, because right out of the gate within the first couple of weeks, Hank Brennan proved 4 of the 5 elements beyond a reasonable doubt, right? And then the rest of the time was getting to that fifth element that caused the death. But I mean, I don't know. I like to ask lawyers to do the opposite. I like to say, if this was your client, if you were heading the defense team, how would you feel about your case right now?
I have it right here if you guys want me to read it. And I did quote this in the book. This is the one that the judge used.
Okay. Thank you, Kevin.
Proof beyond a reasonable doubt is proof that leaves jurors firmly convinced of the defendant's guilt. It does not require eliminating all possible doubt. A reasonable doubt is based on reason and common sense, not speculation. If jurors are not convinced beyond a reasonable doubt, they must find the defendant not guilty. And that's the standard one from the Ninth Circuit model. There's also another one from Wisconsin, which I won't read, and there's also a legal scholarship one. So you can see where this is a difficult one to settle, and it's by design a little bit vague for a jury, because there's no easy way to define what reasonable doubt is. But the key thing is it does not require, it's not proof beyond all doubt.
Right.
And there is a longer version of this too, but this is the one that I just got now.
And she didn't read the longer version last year?
This is the basic one she gave. I think there's one that's a couple of sentences longer, but it's based on the same ruling here. But that's the basic one there.
Does not require. Good. I think there's still a high likelihood and probability of murder too, and that lies in the text stream data that shows her pulling forward first, right?
And the battery data that shows what time John got out of the car.
Yeah.
Exactly.
Because it's all about the act. It's about the act. It's not about whether she had the intent to kill him at the moment. She's engaged in an act that's so inherently dangerous. Backing up at 24 miles an hour, pulling way up, like you said, and knowing he's standing right there.
Right. And he just got out of the car.
That would rise to the level of second degree.
I think if the vehicle had just backed up, they could have made the argument she was so drunk, it was an accident. She didn't know it was in reverse kind of thing. But the act of pulling forward first, stopping, then backing up, then gunning it.
Right.
That's too many emotions and actions and gear shifts to kind of explain that away. So
in the first trial, he didn't know what time John got out of the car. In theory, he could have got out and been on the phone for 5 minutes. He could have gone out and gone over and take a leak in the bushes. I mean, we didn't know. But we now know because of the new evidence.
I thought maybe he had gone over and taken a leak, but now I know that he didn't.
Yep.
It was all that SD card that was strangely missed by the defense's expert. Right? The defense's expert just overlooked an SD card. I mean, I'm not a tech, savvy guy, but I know what an SD card looks like and the slot that it sits in. It's pretty overt.
Right. So there's a good chance, I think, as we talked about earlier, that this last witness was there really just to try to overcome the second degree charge, which is important for Karen. Even though the OUI manslaughter still comes with a lengthy sentence, but second degree is a lot worse.
Right.
Oh, yeah.
I think that's been a secondary focus. That's what I've been saying the whole time. If you read between the lines and look at how strenuously they tried to get 1 and 3 tossed, right, which are connected, right? Because if murder 2, in theory, requires some sort of level of, I guess, cognizance about what happened, and that would then satisfy the leaving the scene, right? So I think they've been able, I think that at some point they had a conversation, and the most that she would ever be willing to take any responsibility for was manslaughter, because in her mind it was an accident. So I think top priority is probably getting that life sentence, thrown out, and then the second priority is getting everything thrown out. But I just don't know that she's gotten there for manslaughter. There's just too much evidence against her that the jury would have to discard to vote not guilty at this point.
Right. Thank you for Katherine, who's saying she's still reading the book. Me and Kate will be doing the second book, and so I was just told by someone the other day that my book is the best-selling book they've had there since they've been publishing.
That's
I don't know
awesome.
if that's true or not.
Oh,
I don't know if that's actually true or not. But,
congratulations. I'm not surprised.
That's because we haven't written ours yet. We haven't
yes.
ours yet.
Yes.
I'm a decent writer. I'll put it that way. I much more emotional because I'm a lady.
I have no doubt it'll be much better than my crappy, boring legal arguments.
Not better, not
my
better,
weighing of
but
evidence and all that stuff is tedious.
I'm always trying to prod Kevin to like reach deep, connect with the
I haven't.
emotions. Right?
Oh, I do in my fiction, but this was kind of a different purpose for this book. I really just wanted to, in my naive kind of thinking, influence at least some people in how they weigh evidence, because it bothers me that they don't, But I haven't talked to too many people that have finished the book, so that's probably a sign. But all right, so we will. Are there any half days this week? Obviously, tomorrow's not because she talked about. Well, I guess it's going to depend on what's going to. But has the jury been promised anything in terms of half days? I guess it's hard to know because we don't know when exactly things are going to be ended here, and we're going to get to closing statements. But do we know from our own perspective, is Thursday or Friday going to be a half day or anything like that?
I don't think so.
Talking about wrapping up possibly Friday.
Yeah. She said that there weren't. I remember last week she said it's doubtful that they will have a half day on Thursday because they're interested. She gave that full day off before.
Right. I don't think she wants to repeat
near the
that.
end. No, so there's not going to be a half day. I mean, she wants the attorneys to be able to do their closing. She's got to give instructions. We've got a closing arguments first, then the instructions. She would love to get them into that jury deliberation room
by Friday.
No kidding, yeah.
Oh God.
So closing arguments probably Thursday. You think?
I'm thinking they might be Thursday. Yeah. Okay. Let me think for a second. So, how long did Brennan say the cross-examination of Rentschler would take? What do you say?
An hour to an hour 10 or 20.
Yeah, closings will be Thursday.
Okay.
If I were a betting woman, I would bet on it.
Okay. All right. Well, Kate, I do now have chemo scheduled for Friday and Saturday, so you'll be in control again on Friday. Hopefully you can manage that time-wise. If you can't, let me know. We'll try to get someone else to take over. Are you available Friday, Kate? I will be here early in the morning, so I can launch it. But
yeah, no, Friday's fine.
Okay,
I can handle the whole thing. No big deal.
I definitely don't want to miss closing arguments, so it would suck if it was Friday. But I can watch them from the hospital. So I enjoyed watching everybody from the hospital. I was like quiet and chat, but I was, some days I wasn't feeling up to it. But a lot of the times I just pull out the laptop and listen to you guys and your analysis of it, and it kept me it kept time moving for me. It was great.
Oh, good.
That's good.
Yeah, no, it was good. So hopefully Matt will be back soon, and
yeah, definitely,
and we can find out. All right, so we will set up the show for tomorrow, and I think the jury's supposed to be back at 9 tomorrow, no delay, right? So, but I'm sure there'll be the usual five.
Yeah, there usually is, but
yeah, there used to be 5 sidebars before they get started. And, so, all right, guys.
Yeah.
Well,
I mean, yeah. All right.
True to
well, thank you very
All
much.
right, well,
we'll
see you tonight. I won't see you tonight, Kevin. I'll be on at 9, but hopefully you'll watch me at 7.
Will do. And everybody, Margaret, what's your channel? That give them a shout out. People go subscribe there.
Yeah, it says see Margaret McLean at It's a Crime Media. So my channel is at It's a Crime Media on YouTube. That would be great. At It's a Crime Media. I even changed my name to be It's a Crime Media at It's a Crime Media. Do you think that's a good idea? Just trying to get it so people find me.
I don't know.
Or do you think it should be?
Yeah,
Margaret
I don't
McLean
know
at?
either. I don't even have content yet, so I can't tell you nothing. I don't know.
You stumped us with that one, Margaret.
Jeez.
Yeah, right. Yeah.
I'm just trying to make it so
we can put up. Actually, I can put up Boomer's.
I think
Boomer's channel again, but go.
Boomer,
you can have more subscribers, even though you haven't launched anything yet.
I know, man. I put a little trailer thingy up, so I didn't have nothing. But I don't have. I'm working. I got a couple videos that I'm editing right now, but I don't have one that's finished yet, and I got to figure out which is appropriate for this channel and for the other one, etc. But
I'm trying to hit 10K subscribers, and I knew that I kind of have to do it by the end of the trial because then it'll be like creeping along after that. But yesterday I bumped up like 45, so that's good numbers for me.
Great.
For us non-free care and read channels, the numbers are different.
Oh man, it's a whole other deal, right? If you're not catching on to the grift, it's it's an honest grind, but yeah, it's definitely not as easy.
For anybody that's interested, we are going to be discussing a new case during deliberations. Not a new case, but one of New England's famous old cases that we have a little bit of a new angle on, and that is the Karina Holmer. This is the Swedish nanny that in the middle of the 90s, half of her torso was found in a dumpster. And so I have a special guest that'll be coming on, and a couple other people that might be relevant to this case. But a special guest from a lawyer from Washington, D.C., who lived in the area at that time. But so this will give us something that we can all start, or at least those of us that like unsolved cases, that we can all kind of start working on. I like the puzzle of an unsolved
Me
case.
too.
And,
Me too. That'll
yeah,
be great.
so
I'll watch.
Well, you can stick around with us and any of those
I'll have
days
to,
and help us.
Yeah.
I'll get you all
I
the
remember,
information, Margaret.
Yeah. And you know what? I did talk about this case in one of so I taught law at Boston College, and I do believe I talked about this case during my law class at one point. Oh, yeah.
Even better.
I taught law
awesome.
at BC for years, since 2005. I only stopped.
No, I knew that, but I didn't
ago.
know you had covered this case. I didn't know
I think I did. It rings a bell that I did in my class. Like so I very often put out scenarios, or I'll talk about a certain aspect of a case.
Right.
So I think I may have. But yes,
there were several suspects, and the angle that we have is this person that had reached out to me a couple months ago, who had partied a little bit. It involved this kind of alternative sexuality kind of thing, freak. I don't know what. I got to find out what he wants to call it, but that he had participated in this back a little bit in the 90s, around when this happened, or a little bit before, and he had been to a party at a loft where this was kind of known for, this kind of stuff. And it was right in the same area where she was using a loft. So her body was found in this area, and she herself had been allowed to stay at. So the people that employed her was a wealthy couple. One was an artist and one was a professional photographer from Dover. And the photographer also owned a loft, and he allowed her to use this on the weekends, and she liked to party. And so, what exactly was going on here? Could this been something of an alternative sex thing that went bad?
Yeah.
It was just an
accident. So that sounds like something that sounds great, to discuss something new and fresh,
Yeah. It's a new angle that I don't think anybody's covered before.
Yeah.
And when he reached out to me, and he's researched this case. Once he put this connection together, it's a couple of years ago, he's kind of researched it obsessively.
The chat goes by so fast. I think somebody said to use Margaret McLean as my name and then my handle.
Oh, someone trying to help find it. Yeah.
Somebody's trying to help me, which I really appreciate, because I'm new to YouTube. I only started this year. So, so maybe Margaret McLean at It's a Crime Media would be the best thing to go with.
Okay. It's snappy, sharp. Sounds good. I like it.
See, my problem is there's another big YouTube channel that's It's a Crime.
Yes, it's a huge channel. Yeah.
And so that's not good for me, but maybe somebody looking for them will stumble across me.
So someone says, I guess because I'm covering this, that I don't care about John's family. Are you crazy? Look, this community that's come together through the coverage of this case, they enjoy each other's company. So they're messaging me all the time to want to get something else going so they can stay together and chat as a community. I'm really just here. I don't even think half of them are listening to me. They're just here because they enjoy each other's company and chat. So, but the pressure's on me to kind of cover something to keep it going. That's all right. And
I just saw the chat.
It was John's family and the witness's family. That's what got me involved. I mean, not them personally, like they reached out to me, got me involved, but that's their stories is absolutely what got me involved in covering this. Absolutely. Ground Zero was,
that's what's made me feel a certain responsibility to kind of see this through, because I usually don't have, I have an interest in unsolved case because it's a puzzle to figure out. I generally don't have interest in cases that have been solved. And this case has been solved as far as I'm concerned,
Right. Yeah.
But I felt a certain responsibility because you saw innocent people getting bullied by
big time,
a largely mindless mob.
Yeah.
So,
and it's worse when it's
when
kids,
I say
man.
that, but yeah.
Always
I
worse
know
when
this.
it's kids.
Right.
It makes
so many.
It's horrible, man.
Right.
And
I guess some very inappropriate comments
you.
were shouted out to John's mom again yesterday by some of that mob outside.
Disgusting.
And to be honest,
It's
there were some
sad.
people within that. There were some people within that mob that shouted those people down and said, "Please don't do that." So,
Hopefully,
so you want
yeah,
to
that's good.
you want to be fair,
Right.
in the way you cover it.
Yeah, there's nothing wrong with being wrong. Like if I'm wrong about something, or you're wrong about something, that's fine. It's what you do about it. It's how you behave. Like, did you harass
Right.
children? The answer is no. Think whatever you want to think, man.
Right.
It's of no consequence. So I'm glad to hear that there were people in that group or that crowd calling that out. They
There were.
should. Yeah,
It's funny.
having an
So
opinion is fine. You know,
right.
fine.
In August, I went to 2 of the standouts or whatever, and those are the only 2 I've been to. And in the first one, that was maybe at the end of July. I was there. There were hundreds of people from both sides, and when John's family showed up, I heard those hundreds and hundreds of people from the Karen Reed side booing John's family.
Yeah,
I witnessed it. I recorded it. All right, but a few weeks later, in the next hearing, when John's family showed up, the other side had learned, and they had said they started chanting justice for JJ. They actually joined the people on the blue side, so they learned. And I think even, at one point, Rita Lombardi, when she was doing a rant back then, and she pulled on Nick Rocco, and Nick did the right thing, and he said, "Look, let's just have a moment of silence for John and his family." So there are some people that, at least whether as a strategy or it's generally who they are, they've had a sense of trying to do the right thing here. So there's been there are good people within the crowd. No question.
Of course, and it's good to hear when they call that crap out. I mean, it's
right.
God, man.
Right, absolutely. Okay, guys. Well, thank you very much. So let's end this here, and we had a long day. We didn't get much of a lunch because of the way that went today. Let's all go have supper, and I will see everybody tomorrow.
Thank
All
you.
right, sounds good.
For having
Thanks, guys.
me.